Chapter 17 President. Article 52 to 78 in Part 5th of the Constitution deal with the Union Executive. The Union Executive consists of the President, the Vice President, the Prime Minister, the Council of Ministers, and the Attorney General of India. The President is the head of the Indian state. He is the first citizen of India and acts as the symbol of unity and integrity and solidarity of the nation. Election of the President. The President is elected not directly by the people but by members of Electoral College consisting of number 1. The elected members of both the Houses of Parliament, number 2. The elected members of the Legislative Assemblies of the state, and number 3. The elected members of the Legislative Assemblies of the Union Territories of Delhi and Puducherry. Thus, the nominated members of both the Houses of Parliament, the nominated members of the state legislative assemblies, the members both elected and nominated of the state legislative councils in case of the bicameral legislature, and the nominated members of the legislative assemblies of Delhi and Puducherry do not participate in the election of the President. Where an assembly is dissolved, the member ceases to be qualified to vote in presidential election even if fresh elections to the dissolved assembly are not held before the presidential election. The Constitution provides that there shall be uniformity in the scale of representation of different states as well as parity between the state as a whole and the union at the election of the President. To achieve this, the number of votes which each elected member of the Legislative Assembly of each state and the Parliament is entitled to cast at such election shall be determined in the following manner. Number 1. Every elected member of the Legislative Assembly of a state shall have as many votes as there are multiples of 1000 in the quotient obtained by dividing the population of the state by the total number of the elected members of the assembly. This can be expressed as value of the vote of an MLA is equals to total population of a state upon total number of elected members in the state legislative assembly into 1 upon 1000. Number 2. Every elected member of either House of Parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to members of the legislative assemblies of the states by the total number of the elected members of both the Houses of Parliament. This can be expressed as value of the vote of an MP is equals to total value of votes of all MLAs of all states upon total number of elected members of Parliament. The President's election is held in accordance with system of proportional representation by means of the single transferable vote, and the voting is by secret ballot. This system ensures that the successful candidate is returned by the absolute majority of votes. A candidate, in order to be declared elected to the office of President, must secure a fixed quota of votes. The quota of votes is determined by dividing the total number of valid votes polled by the number of candidates to be elected. Here only one candidate is to be elected as President plus 1 and adding 1 to the quotient. The formula can be expressed as electoral quota is equals to total number of valid votes polled upon 1 plus 1 minus 2 plus 1. Each member of the Electoral College is given only one ballot paper. The voter, while casting his vote, is required to indicate his preference by marking 1, 2, 3, 4, etc. against the name of candidate. This means that the vote can indicate as many preferences as there are candidates in the fray. In the first phase, the first preference votes are counted. In case a candidate secures the required quota in this phase, he is declared elected. Otherwise, the process of transfer of votes is set in motion. The ballots of the candidate securing the least number of first preference votes are cancelled and his second preference votes are transferred to the first preference votes of the other candidate. This process continues till a candidate secures the required quota. All doubts and disputes in connection with election of the President are inquired into and decided by the Supreme Court, whose decision is final. The election of a person as President cannot be challenged on the ground that the Electoral College was incomplete, that is, existence of any vacancy among the members of Electoral College. If the election of a person as President is declared void by the Supreme Court, act done by him before the date of such declaration of the Supreme Court are not invalidated and continue to remain in force. Some members of the Constituent Assembly criticized the system of indirect election for the president as undemocratic and proposed the idea of direct election. However, the constitution makers chose the indirect election due to the following reasons. Number one, the indirect election of the president is in harmony with the parliamentary system of government envisaged in the constitution. Under this system, the president is only a nominal executive and the real powers are vested in the Council of Ministers headed by the Prime Minister. It would have been anomalous to have the president elected directly by the people and not give him any real power. Number two, the direct election of the president would have been very costly and time and energy consuming due to the vast size of the electorate. This is unwarranted, keeping in view that he is only a symbolic head. Some members of the Constituent Assembly suggested that the president should be elected by the members of the Houses of Parliament alone. The makers of the Constitution did not prefer this, as the Parliament, dominated by one political party, would have invariably chosen a candidate from that party, and such a president could not represent the states of the Indian Union. The present system makes the president a representative of the Union and the states equally. Further, it was pointed out in the Constituent Assembly that the expression proportional representation in the case of presidential election is a misnomer. Proportional representation takes place where two or more seats are to be filled. In case of the president, the vacancy is only one. It could better be called a preferential or alternative vote system. Similarly, the expression single transferable vote was also objected on the ground that no voter has a single vote. Every voter has plural votes. Qualifications, oath and conditions. Qualification for election as president. A person to be eligible for election as president should fulfill the following conditions. Number 1, he should be a citizen of India. Number 2, he should have completed 35 years of age. Number 3, he should be qualified for election as a member of the Lok Sabha. Number 4, he should not hold any office of profit under the union government or any state government or any local authority or any other public authority. A sitting president or vice president of the union, the governor of any state, and a minister of the union or any state is not deemed to hold any office of profit and hence qualified as a presidential candidate. Further, the nomination of a candidate for election to the office of president must be subscribed by at least 50 electors as proposers and 50 electors as seconders. Every candidate has to make a security deposit of rupees 15,000 in Reserve Bank of India. The security deposit is liable to be forfeited in case of the candidate fails to secure one-sixth of the votes polled. Before 1997, number of proposers and seconders was 10 each and the amount of security deposit was rupees 2,500. In 1997, they were increased to discourage the non-serious candidate. Oath or affirmation by the President. Before entering upon his office, the President has to make and subscribe to an oath or affirmation. In his oath, the President swears, number 1, to faithfully execute the office, number 2, to preserve, protect and defend the Constitution and the law, number 3, to devote himself to the service and well-being of the people of India. The oath of office to the President is administered by the Chief Justice of India, and in his absence, the senior most judge of the Supreme Court is available. Any other person acting as President or discharging the function of the President also undertakes the similar oath or affirmation. Conditions of President's office. The Constitution lays down the following conditions of the President's office. Number 1, he should not be a member of either House of Parliament or a House of the State Legislature. If any such person is elected as President, he is deemed to have vacated his seat in that House on the date on which he enters upon his office of President. Number 2, he should not hold any other office of profit. Number 3, he is entitled without payment of rent to the use of his official residence, the Rashtrapati Bhavan. Number 4, he is entitled to such emoluments, allowances and privileges as may be determined by Parliament. Number 5, his emoluments and allowances cannot be diminished during his term of office. In 2018, the Parliament increased the salary of the President from 1.50 lakh to rupees 5 lakh per month. Earlier in 2008, the pension of the retired President was increased from rupees 3 lakh per annum to 50% of his salary per month. In addition, the former presidents are entitled to furnished residence, phone facilities, car, medical treatment, travel facility, secretariat staff, and office expenses up to rupees 1 lakh per annum. The spouse of a deceased president is also entitled to a family pension at the rate of 50% of pension of a retired president. For furnished residence, phone facility, car, medical treatment, travel facility, secretariat staff, and office expenses up to rupees 20,000 per annum. The president is entitled to a number of privileges and immunities. He enjoys personal immunity from legal liability for his official act. During his term of office, he is immune from any criminal proceedings, even in respect of his personal act. He cannot be arrested or imprisoned. However, after giving 2 months' notice, civil proceedings can be instituted against him during his term of office in respect of his personal act. Term, impeachment, and vacancy. Term of President's office. The President holds office for a term of 5 years from the date on which he enters upon his office. However, he can resign from his office at any time by addressing the resignation letter to the Vice President. Further, he can also be removed from the office before completion of his term by the process of impeachment. The President can hold office beyond his term of 5 years until his successor assumes charge. He is also eligible for re-election to that office. He may be elected for any number of terms. However, in USA, a person cannot be elected to the office of the President more than twice. Impeachment of President. The President can be removed from office by a process of impeachment for violation of the Constitution. However, the Constitution does not define the meaning of the phrase violation of the Constitution. The impeachment charges can be initiated by either house of the Parliament. These charges should be signed by 1/4 members of the house that frame the charges, and a 14-day notice should be given to the President. After the impeachment resolution is passed by a majority of 2/3 of the total membership of that house, it is sent to the other house, which should investigate the charges. The President has the right to appear and to be represented, and the President has the right to appear and to be represented at such investigation. If the other house also sustains the charges and passes the impeachment resolution by a majority of 2/3 of the total membership, then the President stands removed from his office from the date on which the resolution is so passed. Thus, an impeachment is a quasi-judicial procedure in the Parliament. In this context, two things should be noted. A. The nominated members of either House of Parliament can participate in the impeachment of the President, though they do not participate in his election. B. The elected members of the legislative assemblies of states and the union territories of Delhi and Puducherry do not participate in the impeachment of the President, though they participate in his election. No President has so far been impeached. Vacancy in the President's office. A vacancy in the President's office can occur in any of the following ways. Number 1. On the expiry of his tenure of 5 years. Number 2. By his resignation. Number 3. On his removal by the process of impeachment. Number 4. By his death. Number 5. Otherwise, for example, when he becomes disqualified to hold office or when his election is declared void. When the vacancy is going to be caused by the expiration of the term of the sitting President, an election to fill the vacancy must be held before the expiration of the term. In case of any delay in conducting the election of new President by any reason, the outgoing President continues to hold office beyond his term of 5 years until his successor assumes charge. This is provided by the Constitution in order to prevent an interregnum. In this situation, the Vice President does not get the opportunity to act as President or to discharge the function of the President. If the office falls vacant by resignation, removal, death, or otherwise, then election to fill the vacancy should be held within 6 months from the date of the occurrence of such a vacancy. The newly elected President remains in office for a term of 5 years from the date he assumes charge of his office. When a vacancy occurs in the office of the president due to his resignation, removal, death, or otherwise, the vice president acts as the president until a new president is elected. Further, when the sitting president is unable to discharge his functions due to absence, illness, or any other cause, the vice president discharges his functions until the president resumes his office. In case the office of vice president is vacant, the Chief Justice of India, or if his office is also vacant, the senior most judge of the Supreme Court available, act as the president or discharges the function of the president. When any person, that is, Vice President, Chief Justice of India, or the senior most judge of the Supreme Court, is acting as the President or discharging the function of the President, he enjoys all the powers and immunities of the President and is entitled to such emoluments, allowances, and privileges as are determined by the Parliament. Powers and functions of the President. The powers enjoyed and the functions performed by the President to be studied under the following heads. Number 1. Executive powers. Number 2. Legislative powers. Number 3. Financial powers. Number 4. Judicial powers. Number 5. Diplomatic powers. Number 6. Military powers. Number 7. Emergency powers. Executive powers. The executive powers and function of the President are A. All executive actions of the Government of India are formally taken in his name. B. He can make rules specifying the manner in which the orders and other instruments made and executed in his name shall be authenticated. C. He can make rules for more convenient transaction of business of the Union Government and for allocation of the said business among the ministers. D. He appoints the Prime Minister and the other ministers. They hold office during his pleasure. E. He appoints the Attorney General of India and determines his remuneration. The Attorney General holds office during the pleasure of the President. F. He appoints the Comptroller and Auditor General of India, the Chief Election Commissioner and other election commissioners, the Chairman and members of the Union Public Service Commission, the Governors of State, the Chairman and members of Finance Commission, and so on. G. He can seek any information relating to the administration of affairs of the Union, the proposals for legislation from the Prime Minister. H. He can require the Prime Minister to submit for consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. I. He can appoint a commission to investigate into the conditions of SCs, STs and other backward classes. J. He can appoint an interstate council to promote center-state and interstate cooperation. K. He directly administers the union territories through administrators appointed by him. I. He can declare any area as scheduled area and has powers with respect to the administration of scheduled areas and tribal areas. Legislative powers. The President is an integral part of the Parliament of India and enjoys the following legislative powers. A. He can summon or prorogue the Parliament and dissolve the Lok Sabha. He can also summon a joint sitting of both the houses of Parliament, which is presided over by the Speaker of the Lok Sabha. B. He can address the Parliament at the commencement of the first session after each general election and the first session of each year. C. He can send messages to the Houses of Parliament whether with respect to a bill pending in the Parliament or otherwise. D. He can appoint any member of the Lok Sabha to preside over its proceedings when the office of both the Speaker and the Deputy Speaker fall vacant. Similarly, he can also appoint any member of the Rajya Sabha to preside over its proceedings when the office of both the Chairman and the Deputy Chairman fall vacant. E. He nominates 12 members of the Rajya Sabha from amongst persons having special knowledge or practical experience in literature, science, art, and social service. F. He can nominate 2 members to the Lok Sabha from the Anglo-Indian community. G. He decides on questions as to disqualifications of member of the Parliament in consultation with the Election Commission. H. His prior recommendation or permission is needed to introduce certain types of bills in the Parliament. For example, a bill involving expenditure from the Consolidated Fund of India or a bill for the alteration of boundaries of a state or creation of a new state. I. When a bill is sent to the President after it has been passed by the Parliament, he can, give his assent to the bill, withhold his assent to the bill, return the bill if it is not a money bill for reconsideration of Parliament. However, if the bill is passed again by the Parliament with or without amendments, the President has to give his assent to the bill. J. When a bill passed by a state legislature is reserved by the governor for consideration of the President can give his assent to the bill, withhold his assent to the bill, or direct the governor to return the bill if it is not a money bill reconsideration of the state legislature. It should be noted that it is not obligatory for the President to give his assent on the bill is again passed by the state legislature and sent again him for consideration. K. He can promulgate ordinances when the Parliament is not in session. These ordinances must be approved by the Parliament within 6 weeks from its reassembly. He can also withdraw an ordinance at any time. L. He lays the report of the Comptroller and Auditor General, Union Public Service Commission, Finance Commission, and others before the Parliament. M. He can make regulations for the peace, progress, and good government of the Andaman and Nicobar Islands, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu, and Ladakh. In the case of Puducherry also, the President can legislate by making regulations but only when the Assembly is suspended or dissolved. Financial powers. The financial powers and function of the President are: number A. Money bills can be introduced in the Parliament only with his prior recommendation. B. He causes to be laid before the Parliament the annual financial statement, that is the Union budget. C. No demand for a grant can be made except on his recommendation. D. He can make advances out of the contingency fund of India to meet any unforeseen expenditure. E. He constitutes a finance commission after every 5 years to recommend the distribution of revenues between the centre and the states. Judicial powers. The judicial powers and functions of the President are: A. He appoints the Chief Justice and the judges of Supreme Court and High Courts. B. He can seek advice from the Supreme Court on any question of law or fact. However, the advice tendered by the Supreme Court is not binding on the President. C. He can grant pardon, reprieve, respite, and remission of punishment, or suspend, remit, or commute the sentence of any person convicted of any offence. In all cases where the punishment or sentence is by martial, in all cases where the punishment or sentence is for an offence against a union law, in all cases where the sentence is a sentence of death. Diplomatic powers. The international treaties and agreements are negotiated and concluded on behalf of the President. However, they are subject to the approval of the Parliament. He represents India in international forums and affairs and sends and receives diplomats like ambassadors, high commissioners, and so on. Military powers. He is the Supreme Commander of the Defence Forces of India. In that capacity, he appoints the Chiefs of Army, the Navy, and Air Force. He can declare war or conclude peace subject to the approval of the Parliament. Emergency powers. In addition to the normal powers mentioned above, the Constitution confers extraordinary powers on the President to deal with the following 3 types of emergencies. Number 1, national emergency under Article 352. Number 2, President's Rule under Article 356 and 365, Financial Emergency under Article 360. Veto power of the President. A bill passed by the Parliament can become an act only if it receives an assent of the President. When such a bill is presented to the President for his assent, he has 3 alternatives under Article 111 of the Constitution. Number 1, he may give his assent to the bill. Number 2, he may withhold his assent to the bill. Number 3, he may return the bill if it is not a money bill for reconsideration of the Parliament. However, if the bill is passed again by the Parliament with or without amendments and again presented to the President must give his assent to the bill. Thus, the President has the veto power over the bills passed by the Parliament. That is, he can withhold his assent to the bills. The object of conferring this power on the President is twofold: to prevent hasty and ill-considered legislation by the Parliament and to prevent a legislation which may be unconstitutional. The veto power enjoined by the executive in modern states can classify it into the following 4 types. Number 1, absolute veto, that is withholding of assent to the bill passed by the legislature. Number 2, qualified veto, which can be overridden by the legislature with a higher majority. Number 3. Suspensive veto, which can be overridden by the legislature with an ordinary majority. Number 4. Pocket veto, that is taking no action on the bill passed by the legislature. Of the above four, the President of India is vested with 3 absolute veto, suspensive veto, and pocket veto. There is no qualified veto in the case of Indian President. It is possessed by the American President. The three vetoes of the President of India are explained below. Absolute veto. It refers to the power of the President to withhold his assent to a bill passed by the Parliament. The bill then ends and does not become an act. Usually, this veto is exercised in the following 2 cases. First, with respect to private member bills, that is, bill introduced by any member of Parliament who is not a minister. Second, with respect to the government bills when the cabinet resigns after the passage of the bills but before the assent by the president and the new cabinet advises the president not to give his assent to such bills. In 1954, President Dr. Rajendra Prasad withheld his assent to the PAPSU appropriation bill. The bill was passed by the parliament when the president's rule was in operation in the state of PAPSU. But when the bill was presented to the president for his assent, the president's rule was revoked. Again in 1991, President R. Venkatraman withheld his assent to the Salary, Allowances and Pension of Members of Parliament Amendment Bill. The bill was passed by the Parliament on the last day before dissolution of Lok Sabha without obtaining the previous recommendation of the President. Suspensive veto. The President exercises this veto when he returns a bill for reconsideration of the Parliament. However, if the bill is passed again by the Parliament with or without amendments and again presented to the President, it is obligatory for the President to give his assent to the bill. This means that the presidential veto is overridden by a repassage of the bill by the same ordinary majority and not a higher majority as required in USA. As mentioned earlier, the President does not possess this veto in case of money bills. The President can either give his assent to a money bill or withhold his assent to a money bill but cannot return it for the reconsideration of the Parliament. Normally, the President gives his assent to money bill as it is introduced in the Parliament with his previous permission. Pocket veto. In this case, the President neither ratifies nor rejects nor returns the bill but simply keeps the bill pending for an indefinite period. This power of the President not to take any action, either positive or negative, on the bill is known as the pocket veto. The President can exercise this veto power as the Constitution does not prescribe any time limit within which he has to take the decision with respect to a bill presented to him for his assent. In USA, on the other hand, the President has to return the bill for reconsideration within 10 days. Hence, it is remarked that the pocket of the Indian President is bigger than that of the American President. In 1986, President Jail Singh exercised the pocket veto with respect to the Indian Post Office Amendment Bill. The bill passed by the Rajiv Gandhi government imposing restrictions on the freedom of press and hence was widely criticized. After 3 years, in 1989, the next President R. Venkatraman sent the bill back for reconsideration, but the new National Front government decided to drop the bill. It should be noted here that the President has no veto power in respect of a constitutional amendment bill. The 24th Constitutional Amendment Act of 1971 made it obligatory for the President to give his assent to a constitutional amendment bill. Presidential veto over state legislation. The President has veto power with respect to state legislation also. A bill passed by a state legislature can become an act only if it receives the assent of the governor or the President in case of the bill is reserved for the consideration of the President. When a bill passed by a state legislature is presented to the governor for his assent, he has 4 alternatives under Article 200 of the Constitution. Number 1. He may give his assent to the bill. Number 2. He may withhold his assent to the bill. Number 3. He may return the bill if it is not a money bill for reconsideration of the state legislature. Number 4. He may reserve the bill for consideration of the President. When a bill is reserved by the governor for the consideration of the President has 3 alternatives under Article 201 of the Constitution. Number 1. He may give his assent to the bill. Number 2. He may withhold his assent to the bill. Number 3. He may direct the governor to return the bill if it is not a money bill for the reconsideration of the state legislature if the bill is passed again by the state legislature with or without amendments and presented again to the president for his assent. The president is not bound to give his assent to the bill. This means that the state legislature cannot override the veto power of the president. Further, the Constitution has not prescribed any time limit which the president has to take decision with regard to a bill reserved by the governor for his consideration. Hence, the president can exercise pocket veto in respect of state legislation also. Ordinance making power of the President. Article 123 of the Constitution empowers the President to promulgate ordinances during the recess of Parliament. These ordinances have the same force and effect as an Act of Parliament, but are in the nature of temporary laws. The ordinance making power is the most important legislative power of the President. It has been vested in him to deal with unforeseen or urgent matters, but the exercises of this power is subject to the following 4 limitations. Number 1. He can promulgate an ordinance only when both the Houses of Parliament are not in session or when either of the 2 Houses of Parliament is not in session. And ordinances can also be issued when only one house is in session because a law can be passed by both the houses and not by one house alone. An ordinance made when both the houses are in session is void. Thus, the power of the President to legislate by ordinance is not a parallel power of legislation. Number 2. He can make an ordinance only when he is satisfied that the circumstances exist that render it necessary for him to take immediate action. In Cooper case of 1970, the Supreme Court held that the President's satisfaction can be questioned in a court on the ground of malafide. This means that the decision of the President to issue an ordinance can be questioned in a court on the ground that the ordinance can be questioned in the court on the ground that the President has prorogued one house or both houses of Parliament deliberately with a view to promulgate an ordinance on a controversial subject so as to bypass the parliamentary decision and thereby circumventing the authority of the Parliament. The 38th Constitutional Amendment Act of 1975 made the President's satisfaction final and conclusive and beyond judicial review, but this provision was deleted by the 44th Constitutional Amendment Act of 1978. Thus, the President's satisfaction is justiciable on the ground of malafide. Number 3. His ordinance making power is co-extensive as regards all matters except duration with the law-making powers of the Parliament. This has 2 implications. A. An ordinance can be issued only on those subjects on which the Parliament can make laws. Number B. An ordinance is subject to the same constitutional limitation as an Act of Parliament. Hence, an ordinance cannot abridge or take away any of the fundamental rights. Number 4. Every ordinance issued by the President during the recess of Parliament must be laid before both the Houses of Parliament when it reassembles. If the ordinance is approved by both the houses, it becomes an act. If Parliament takes no action at all, the ordinance ceases to operate on the expiry of 6 weeks from the reassembly of Parliament. The ordinance may also cease to operate even earlier than the prescribed 6 weeks if both the Houses of Parliament pass resolutions disapproving it. If the Houses of Parliament are summoned to reassemble on different dates, the period of 6 weeks is calculated from the later of those dates. This means that the maximum life of an ordinance can be 6 months and 6 weeks in case of non-approval by the Parliament, 6 months being the maximum gap between the 2 sessions of Parliament. If an ordinance is allowed to lapse without being placed before Parliament, then the act done and completed under it before it ceases to operate remain fully valid and effective. The President can also withdraw an ordinance at any time. However, this power of ordinance making is not a discretionary power, and he can promulgate or withdraw an ordinance only on the advice of the Council of Ministers headed by the Prime Minister. An ordinance, like any other legislation, can be retrospective, that is, it may come into force from backdate. It may modify or repeal any act of parliament or another ordinance. It can alter or amend a text law also. However, it cannot be issued to amend the constitution. The ordinance making power of the president in India is rather unusual and not found in most of the democratic constitutions of the world, including that of USA, UK. In justification of the ordinance making power of the president, Dr. B.R. Ambedkar said in the Constituent Assembly that the mechanism of issuing an ordinance has been devised in order to enable the executive to deal with a situation that may suddenly and immediately arise when the parliament is not in session. It must be clarified here that the ordinance making power of the president has no necessary connection with the national emergency envisaged in Article 352. The president can issue an ordinance even when there is no war or external aggression or armed rebellion. The rules of Lok Sabha requires that whenever a bill seeking to replace an ordinance is introduced in the House, a statement explaining the circumstances that had necessitated immediate legislation by ordinance should also be placed before the House. So far, no case has gone to the Supreme Court regarding promulgation of ordinary ordinance by the President. But the judgment of the Supreme Court in D.C. Wadhwa case 1987 is highly relevant here. In that case, the court pointed out that between 1967 to 81, the governor of Bihar promulgated 256 ordinances, and all these were kept in force for periods ranging from 1 to 14 years by promulgation from time to time. The court ruled that successive repromulgation of ordinances with the same text without any attempt to get the bills passed by the assembly would amount to violation of the constitution, and the ordinance so repromulgated is liable to be struck down. It held that the exceptional power of lawmaking through ordinance cannot be used as a substitute for the legislative power of the state legislature. Pardoning power of the President. Article 72 of the Constitution empowers the President to grant pardons to persons who have been tried and convicted of any offence in all cases where the number 1 punishment or sentence is for an offence against a union law. Number 2, punishment or sentence is by a court martial, military court, and number 3, sentence is a sentence of death. The pardoning power of the President is independent of the judiciary. It is an executive power, but the President, while exercising this power, does not sit as a court of appeal. The object of conferring this power on the President is twofold. A. To keep the door open for correcting any judicial errors in the operation of law. B. To afford correct relief from a sentence which the President regards as unduly harsh. The pardoning power of the President includes the following. Number 1. Pardon. It removes both the sentence and the conviction and completely absolves the convict from all sentences, punishment, and disqualifications. Number 2. Commutation. It denotes the substitution of one form of punishment for a lighter form. For example, a death sentence may be commuted to rigorous imprisonment, which in turn may be commuted to a simple imprisonment. Number 3. Remission. It implies reducing the period of sentence without changing its character. For example, a sentence of rigorous imprisonment for 2 years may be remitted to rigorous imprisonment for 1 year. Number 4. Respite. It denotes awarding a lesser sentence in place of one originally awarded due to some special fact, such as the physical disability of a convict or the pregnancy of a women offender. Number 5. Reprieve. It implies a stay of the execution of a sentence, especially that of a death, for a temporary period. Its purpose is to enable the convict to have time to seek pardon or commutation from the President. Under Article 161 of the Constitution, the governor of a state also possesses the pardoning power. Hence, the governor can also grant pardons, reprieves, respites, and remissions of punishment, or suspend, remit, and commute the sentence of any person convicted of any offence against a state law. But the pardoning power of the governor differs from that of the President in following two respects. Number 1. The President can pardon sentence inflicted by court-martial, military courts, while the governor cannot. Number 2. The President can pardon death sentence while governor cannot. Even if a state law prescribes death sentence, the power to grant pardon lies with the President and not the governor. However, the governor can suspend, remit, or commute a death sentence. In other words, both the governor and the president have concurrent power in respect of suspension, remission, and commutation of death sentence. The Supreme Court examined the pardoning power of the president under different cases and laid down the following principles. Number 1. The petitioner for mercy has no right to an oral hearing by the president. Number 2. The president can examine the evidence afresh and take a view different from the view taken by the court. Number 3. The power is to be exercised by the president on the advice of the Union Cabinet. Number 4. The president is not bound to give reasons for his order. Number 5. The president can afford relief not only from a sentence that he regards as unduly harsh but also from an evident mistake. Number 6. There is no need for the Supreme Court to lay down specific guidelines for the exercise of power by the president. Number 7. The exercise of power by the president is not subject to judicial review except where the presidential decision is arbitrary, irrational, malefied, or discriminatory. Number 8. Where the earlier petition for mercy has been rejected by the president, stay cannot be obtained by filing another petition. Constitutional position of the president. The Constitution of India has provided for a parliamentary form of government. Consequently, the president has been made only a nominal executive, the real executive being the Council of Ministers headed by the Prime Minister. In other words, the president has to exercise his powers and functions with the aid and advice of the Council of Ministers headed by the Prime Minister. Dr. B.R. Ambedkar summed up the true position of the president in the following way. In the Indian Constitution, there is placed at the head of the Indian Union a functionary who is called the President of the Union. The title of the functionary reminds of the President of the United States, but beyond the identity of names, there is nothing in common between the form of government prevalent in America and the form of government adopted under the Indian Constitution. The American form of government is called the presidential system of government, and what the Indian Constitution adopted is the parliamentary system. Under the presidential system of America, the president is the chief head of the executive and administration is vested in him. Under the Indian Constitution, the president occupies the same position as the king under the Indian Constitution. He is the head of the state but not of the executive. He represents the nation but does not rule in the nation. He is the symbol of the nation. His place in administration is that of a ceremonial device or a seal by which the nation's decisions are made known. He is generally bound by the advice of his ministers. He can do nothing contrary to their advice, nor he can do anything without their advice. The President of the United States can dismiss any secretary at any time. The President of the Indian Union has no power to do so, so long as his ministers command a majority in Parliament. In estimating the constitutional position of the President, particular references has to be made to the provisions of Articles 53, 74 and 75. These are: Number 1. The executive power of the Union shall be vested in President and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution, Article 53. Number 2. There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice under Article 74. Number 3. The Council of Ministers shall be collectively responsible to the Lok Sabha under Article 75. This provision is the foundation of the parliamentary system of government. The 42nd Constitutional Amendment Act of 1976, enacted by the Indira Gandhi government, made the President bound by the advice of the Council of Ministers headed by the Prime Minister. The 44th Constitutional Amendment Act of 1978, enacted by the Janata Party government headed by Morarji Desai, authorized the President to require the Council of Ministers to reconsider such advice either generally or otherwise. However, he shall act in accordance with the advice tendered after such reconsideration. In other words, the President may return a matter once for reconsideration of his ministers, but the reconsidered advice shall be binding. In October 1997, the Cabinet recommended President K.R. Narayana to impose President's rule under Article 356 in Uttar Pradesh. The Presidents returned the matter for the reconsideration of the Cabinet, which then decided not to move ahead in the manner. Hence, the BJP-led government under Kalyan Singh was saved. Again in September 1998, the President K.R. Narayana returned a recommendation of the Cabinet that sought the imposition of the President's rule in Bihar. After a couple of months, the Cabinet re-advised the same. It was only then that the President's rule was imposed in Bihar in February 1999. Though the President has no constitutional discretion, he has some situational discretion. In other words, the President can act on his discretion, that is, without the advice of the ministers, under the following situations. First, appointment of Prime Minister when no party has a clear majority in the Lok Sabha or when the Prime Minister in office dies suddenly and there is no obvious successor. Number 2, dismissal of the Council of Ministers when it cannot prove the confidence of the Lok Sabha. Number 3, dissolution of the Lok Sabha if the Council of Ministers has lost its majority. Chapter 18, Vice President. The Vice President occupies the second highest office in the country. He is accorded a rank next to the President in the official warrant of precedence. This office is modeled on the lines of the American Vice President. Election. The Vice President, like the President, is elected not directly by the people but by the method of indirect election. He is elected by the members of an electoral college consisting of the members of both houses of parliament. Thus, this electoral college is different from the electoral college for the election of the president in the following two respects. Number 1. It consists of both elected and nominated members of the parliament. In the case of president, only elected members. Number 2. It does not include the members of the state legislative assemblies. In the case of president, the elected members of the state legislative assemblies are included. Explaining the reasons for this difference, Dr. B.R. Ambedkar observed, the president is the head of the state and his power extends both to the administration by the center as well as to the state. Consequently, it is necessary that in his election, not only members of parliament should play their part, but the members of the state legislature should have a voice. But when we come to the vice president, his normal functions are to preside over two council of state. It is only on a rare occasion, and that too for a temporary period, that he may be called upon to assume the duties of the president. That being so, it does not seem necessary that the members of the state legislatures should also be invited to take part in the election of the vice president. But the manner of election is same in both the cases. Thus, the vice president's election, like that of the president's election, is held in accordance with the system of proportional representation by means of the single transferable vote, and the voting is by secret ballot. All doubts and disputes in connection with election of the vice president are inquired into and decided by the Supreme Court, whose decision is final. The election of a person as vice president cannot be challenged on the ground that the electoral college was incomplete, that is, existence of any vacancy among the members of electoral college. If the election of a person as vice president is declared void by the Supreme Court, act done by him before the date of such declaration of the Supreme Court are not invalidated, that is, they continue to remain in force. Qualifications, oath and conditions. Qualifications. To be eligible for election as vice president, a person should fulfill the following qualifications. Number 1, he should be a citizen of India. Number 2, he should have completed 35 years of age. Number 3, he should be qualified for election as a member of the Rajya Sabha. Number 4, he should not hold any office of profit under the union government or any state government or any local authority or any other public authority. But a sitting president or vice president of the union, the governor of any state, and the minister for the union or any state is not deemed to hold any office of profit and hence qualified for being a candidate for vice president. Further, the nomination of a candidate for election to the office of vice president must be subscribed by at least 20 electors as proposers and 20 electors as seconders. Every candidate has to make a security deposit of Rs 15,000 in the Reserve Bank of India. Oath or affirmation. Before entering upon his office, the Vice President has to make and subscribe to an oath or affirmation. In his oath, the Vice President swears to bear true faith and allegiance to the Constitution of India and to faithfully discharge the duties of his office. The oath of office of the Vice President is administered by the President or some person appointed in that behalf by him. Conditions of office. The Constitution lays down the following two conditions of the Vice President's office. Number one, he should not be a member of either House of Parliament or a House of the State Legislature. If any such person is elected Vice President, he is deemed to have vacated his office seat in that House on the date on which he enters upon his office as Vice President. Number two, he should not hold any other office of profit. Term and vacancy. Term of office. The Vice President holds office for a term of 5 years from the date on which he enters upon his office. However, he can resign from his office at any time by addressing the resignation letter to the President. He can also be removed from the office before completion of his term. A formal impeachment not required for his removal. He can be removed by a resolution passed by a majority of all the then members of the Rajya Sabha and agreed to by the Lok Sabha. This means that this resolution should be passed in the Rajya Sabha by an effective majority and in the Lok Sabha by a simple majority. It must be noted here that the effective majority in India is only a type of special majority and not in a separate one. Further, this resolution can be introduced only in the Rajya Sabha and not in the Lok Sabha, but no such resolution can be moved unless at least 14 days advance notice has been given. Notably, no ground has been mentioned in the Constitution for his removal. The Vice President can hold office beyond his term of 5 years until his successor assumes charge. He is also eligible for re-election to that office. He may be elected for any number of terms. Vacancy in office. A vacancy in the Vice President's office can occur only in any of the following ways. Number 1. On the expiry of his tenure of 5 years. Number 2. By his resignation. Number 3. On his removal. Number 4. By his death. Number 5. Otherwise, for example, when he becomes disqualified to hold office or when his election is declared void. When the vacancy is going to be caused by the expiration of the term of the sitting Vice President, an election to fill the vacancy must be held before the expiration of the term. If the office falls vacant by resignation, removal, death, or otherwise, then election to fill the vacancy should be held as soon as possible after the occurrence of the vacancy. The newly elected Vice President remains in office for a full term of 5 years from the date he assumes charge of his office. Powers and functions. The function of Vice President are twofold. Number 1, he acts as the ex officio chairman of Rajya Sabha. In this capacity, his powers and functions are similar to those of the Speaker of Lok Sabha. In this respect, he resembles the American Vice President, who also acts as the chairman of the Senate, the upper house of the American legislature. Number 2, he acts as president when a vacancy occurs in the office of the president due to his resignation, impeachment, death, or otherwise. He can act as president only for a maximum period of 6 months within which a new president has to be elected. Further, when the sitting president is unable to discharge his functions due to absence, illness, or any other cause, the vice president discharges his functions until the president resumes his office. While acting as president or discharging the function of president, the vice president does not perform the duties of the office of the chairman of Rajya Sabha. During this period, those duties are performed by the deputy chairman of Rajya Sabha. The Constitution has not fixed any emoluments for the Vice President in that capacity. He draws his regular salary in this capacity as the ex officio chairman of Rajya Sabha. In 2018, the Parliament increased the salary of the chairman of the Rajya Sabha from Rs 1.25 lakh to Rs 4 lakh per month. Earlier in 2008, the pension of the retired vice president was increased from Rs 20,000 per month to 50% of the salary per month. In addition, he is entitled to give daily allowances, free furnished residence, medical, travel, and other facilities. During any period when the vice president acts as president or discharges the function of the president, he is not entitled to the salary or allowances payable to the chairman of Rajya Sabha, but the salary and allowances of the president. Indian and American vice presidents compared. Though the office of the Indian vice president is modeled on the lines of the American vice president, there is a difference. The American vice president succeeds to the presidency when it fails vacant and remain president for the unexpired term of his predecessor. The Indian vice president, on the other hand, does not assume the office of the president when it falls vacant for the unexpired term. He merely serves as an acting president until the new president assumes charge. From the above, it is clear that the Constitution has not assigned any significant function to the Vice President in that capacity. Hence, some scholars call him His Superfluous Highness. This office was created with a view to maintain the political continuity of the Indian state. Chapter 19, Prime Minister. In the scheme of parliamentary system of government provided by the Constitution, the President is the nominal executive authority, de jure executive, and Prime Minister is the real executive authority, de facto executive. In other words, President is the head of the state while Prime Minister is the head of the government. Appointment of the Prime Minister. The Constitution does not contain any specific procedure for selection and appointment of the Prime Minister. Article 75 says only that the Prime Minister shall be appointed by the President. However, this does not imply that the President is free to appoint anyone as the Prime Minister. In accordance with the conventions of the parliamentary system of government, the President has to appoint the leader of the majority party in the Lok Sabha as the Prime Minister. But when no party has a clear majority in the Lok Sabha, then the President may exercise his personal discretion in the selection and appointment of the Prime Minister. In such a situation, the President usually appoints the leader of the largest party or coalition in the Lok Sabha as the Prime Minister and asks him to seek a vote of confidence in the House within a month. This discretion was exercised by the President for the first time in 1979 when Neelam Sanjeev Reddy, the then President, appointed Charan Singh, the coalition leader, as the Prime Minister after the fall of the Janata Party government headed by Morarji Desai. There is also one more situation when the President may have to exercise his individual judgment in the selection and appointment of the Prime Minister. That is, when the Prime Minister in office dies suddenly and there is no obvious successor. This is what happened when Indira Gandhi was assassinated in 1984. The then President Jail Singh appointed Rajiv Gandhi as the Prime Minister by ignoring the precedent of appointing a caretaker Prime Minister. Later on, the Congress Parliamentary Party unanimously elected him as its leader. However, if on the death of an incumbent Prime Minister, the ruling party elects a new leader, the President has no choice but to appoint him as Prime Minister. In 1980, the Delhi High Court held the Constitution does not require a person must prove his majority in the Lok Sabha before he is appointed as the Prime Minister. The President may first appoint him the Prime Minister and then ask him to prove his majority in the Lok Sabha within a reasonable period. For example, Charan Singh 1979, VP Singh 1989, Chandrasekhar 1990, PV Narasimha Rao 1991, Atal Bihari Vajpayee 1996, Deve Gowda 1996, I.K. Gujral 1997 and again Atal Bihari Vajpayee 1998 were appointed as Prime Ministers in this way. In 1997, the Supreme Court held that a person who is not a member of either House of Parliament can be appointed as Prime Minister for 6 months, within which he should become a member of either House of Parliament, otherwise he ceases to be the Prime Minister. Constitutionally, the Prime Minister may be a member of any of the two houses of Parliament. For example, three Prime Ministers, Indira Gandhi 1966, Deve Gowda 1996 and Manmohan Singh 2004 were members of the Rajya Sabha. In Britain, on the other hand, the Prime Minister should definitely be a member of the lower house, that is House of Commons. Oath, term and salary. Before the Prime Minister enters upon his office, the President administers him the oath of office and secrecy. In his oath of office, the Prime Minister swears, number 1, to bear true faith and allegiance to the Constitution of India. Number 2, to uphold the sovereignty and integrity of India. Number 3, to faithfully and conscientiously discharge the duties of his office. Number 4, to do right to all manner of people in accordance with the constitution and the law without fear or favor, affection or ill will. In his oath of secrecy, the Prime Minister swears that he will not directly or indirectly communicate or reveal to any person any matter that is brought under his consideration or becomes known to him as a Union Minister except as may be required for the due discharge of his duties as such minister. The term of the Prime Minister is not fixed and he holds office during the pleasure of the President. However, this does not mean that the President can dismiss the Prime Minister at any time. So long as the Prime Minister enjoys the majority support in the Lok Sabha, he cannot be dismissed by the President. However, if he loses the confidence of the Lok Sabha, he must resign or the President can dismiss him. The salary and allowances of the Prime Minister are determined by the Parliament from time to time. He gets the salary and allowances that are payable to a Member of Parliament. Additionally, he gets a sumptuary allowance, free accommodation, travelling allowance, medical facilities, etc. In 2001, the Parliament increased his sumptuary allowance from 1500 to rupees 3000 per month. Powers and functions of the Prime Minister. The power and function of Prime Minister can be studied under the following heads. In relation to Council of Ministers, the Prime Minister enjoys the following powers as head of the Union Council of Ministers. Number 1. He recommends persons who can be appointed as ministers by the President. The President can appoint only those persons as ministers who are recommended by the Prime Minister. Number 2. He allocates and reshuffles various portfolios among the ministers. Number 3. He can ask a minister to resign or advise the President to dismiss him in case of difference of opinion. Number 4. He presides over the meeting of Council of Ministers and influences its decisions. Number 5. He guides, directs, controls and coordinates the activities of all the ministers. Number 6. He can bring about the collapse of the Council of Ministers by resigning from office. Since the Prime Minister stands at the head of the Council of Ministers, the other ministers cannot function when the Prime Minister resigns or dies. In other words, the resignation or death of an incumbent Prime Minister automatically dissolves the Council of Ministers and thereby generates a vacuum. The resignation or death of any other minister, on the other hand, merely creates a vacancy which the Prime Minister may or may not be like to fill. In relation to the President, the Prime Minister enjoys the following powers in relation to the President. Number 1. He is the principal channel of communication between the President and the Council of Ministers. It is the duty of the Prime Minister, Number A, to communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation. Number B, to furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for. Number C, if the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Number 2, he advises the President with regard to the appointment of important officials like Attorney General of India, Comptroller and Auditor General of India, Chairman and members of the UPSC, election commissioners, chairman and members of the Finance Commission, and so on. In relation to Parliament, the Prime Minister is the leader of the lower house. In this capacity, he enjoys the following powers. Number 1, he advises the President with regard to summoning and proroguing of the sessions of the Parliament. Number 2, he can recommend dissolution of the Lok Sabha to President at any time. Number 3, he announces government policies on the floor of the House. Other powers and functions. In addition to the above-mentioned three major roles, the Prime Minister has various other roles. These are: Number 1, he is the chairman of the Niti Aayog, which succeeded the Planning Commission, National Integration Council, Interstate Council, National Water Resources Council, and some other bodies. Number 2, he plays a significant role in shaping the foreign policy of the country. Number 3, he is the chief spokesperson of the Union government. Number 4, he is the crisis manager in chief at the political level during emergencies. Number 5. As a leader of the nation, he meets various sections of the people in different states and receives memoranda from them regarding their problems and so on. Number 6. He is leader of the party in power. Number 7. He is political head of the services. Thus, the Prime Minister plays a very significant and highly crucial role in the politico-administrative system of the country. Dr. B.R. Ambedkar stated, if any functionary under our constitution is to be compared with the US President, he is the Prime Minister and not the President of the Union. Role descriptions. The various comments made by the eminent political scientists and constitutional experts on the role of Prime Minister in Britain holds good in the Indian context also. These are mentioned below. Lord Morley. He described Prime Minister as primus inter pares, first among equals and keystone of the cabinet arc. He said the head of the cabinet is primus inter pares and occupied a position which so long as it lasts is one of exceptional and peculiar authority. Herbert Madison. As the head of the government, the Prime Minister, is primus inter pares, but it is today for too modest an appreciation of the Prime Minister's position. Sir William Vernon Harcourt. He described Prime Minister as inter stellis luna minoris, a moon among lesser stars. Jennings. He is rather a sun around which planet revolve. He is the keystone of the Constitution. All roads in the Constitution lead to the Prime Minister. H.J. Lasky. On the relationship between the Prime Minister and the Cabinet, he said that the Prime Minister is central to its formation, central to its life, and central to its death. He described him as the pivot around which the entire governmental machinery revolves. H.R.G. Graves. The government is the master of the country and he, Prime Minister, is the master of the government. Munro. He called Prime Minister as the captain of the ship of the state. Ramsay Muir. He described Prime Minister as the steersman of steering wheel of the ship of the state. The role of the Prime Minister in the British parliamentary government is so significant and crucial that observers like to call it a prime ministerial government. Thus, R.H. Crossman says the post-war epoch has been the final transformation of cabinet government into prime ministerial government. Similarly, Humphrey Workley points out Parliament is not in practice sovereign. The parliamentary democracy has now collapsed at Westminster. The basic defect in the British system of governing is the superministerial powers of the Prime Minister. The same description holds good to the Indian context too. Relationship with the President. The following provisions of the Constitution deal with the relationship between the President and the Prime Minister. Number 1. Article 74. There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. However, the President may require the Council of Ministers to reconsider such advice and the President shall act in accordance with the advice tendered after such reconsideration. Number 2. Article 75. The Prime Minister shall be appointed by the President and the other ministers shall be appointed by the President on the advice of the Prime Minister. The ministers shall hold office during the pleasure of the President and the Council of Ministers shall be collectively responsible to the House of the People. Number 3. Article 78. It shall be the duty of the Prime Minister to communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation, to furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for, if the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Chief Ministers who became Prime Ministers. 6 people, Morarji Desai, Charan Singh, V.P. Singh, P.V. Narasimha Rao, H.D. Deve Gowda and Narendra Modi became Prime Ministers after being Chief Ministers of their respective states. Morarji Desai, Chief Minister of the erstwhile Bombay state during 1952 to 56, became the first non-Congress Prime Minister in March 1977. Charan Singh, who succeeded him, was the Chief Minister of the undivided Uttar Pradesh in 1967 to 68 and again in 1970. VP Singh, also from Uttar Pradesh, became Prime Minister in the short lived National Front government December 1989 to November 1990. P.V. Narasimha Rao, the first Prime Minister from South India who held the post from 91 to 96, was the Chief Minister of Andhra Pradesh between 1971 to 73. H.D. Devegowda was Chief Minister of Karnataka when he was chosen to lead the United Front government in June 1996. Narendra Modi was the Chief Minister of Gujarat when he became the Prime Minister in May 2014. He served as the Chief Minister of Gujarat for 4 times during 2001 to 2014. Chapter 20, Central Council of Ministers. As the Constitution of India provides for a parliamentary system of government modelled on the British pattern, the Council of Ministers, headed by the Prime Minister, is the real executive authority in our politico-administrative system. The principles of parliamentary system of government are not detailed in the Constitution, but two articles 74 and 75 deal with them in a broad, sketchy and general manner. Article 74 deals with the status of the Council of Ministers, while Article 75 deals with the appointment, tenure, responsibility, qualification, oath, and salaries and allowances of the ministers. Constitutional provisions. Article 74. Council of Ministers to aid and advise President. Number 1. There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in exercise of his functions, act in accordance with such advice. However, the President may require the Council of Ministers to reconsider such advice, and the President shall act in accordance with the advice tendered after such reconsideration. Number 2. The advice tendered by ministers to the President shall not be inquired into in any court. Article 75. Other provisions as to ministers. Number 1. The Prime Minister shall be appointed by the President, and the other ministers shall be appointed by the President on the advice of the Prime Minister. Number 2. The total number of ministers, including the Prime Minister, in the Council of Ministers shall not exceed 15% of the total strength of the Lok Sabha. This provision was added by the 91st Amendment Act of 2003. Number 3. A member of either House of Parliament belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister. This provision was also added by the 91st Amendment Act of 2003. Number 4. The ministers shall hold office during the pleasure of the President. Number 5. The Council of Ministers shall be collectively responsible to the Lok Sabha. Number 6. The President shall administer the oath of office and secrecy to a minister. Number 7. A minister who is not a member of the Parliament, either house, for any period of 6 consecutive months shall cease to be a minister. Number 8. The salaries and allowances of ministers shall be determined by the Parliament. Article 77. Conduct of business of the Government of India. Number 1. All executive action of the Government of India shall be expressed to be taken in the name of the President. Number 2. Orders and other instruments made and executed in the name of the President shall be authenticated in such manner as may be specified in rules to be made by the President. Further, the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the President. Number 3. The President shall make rules for the more convenient transaction of the business of the Government of India and for the allocation among ministers of the said business. Article 78. Duties of Prime Minister. It shall be the duty of the Prime Minister, number 1, to communicate to the President to all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation. Number 2. To furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for. Number 3. If the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Article 88. Rights of ministers as respect the houses. Every minister shall have the right to speak and take part in the proceedings of either house, any joint sitting of the house, and any committee of parliament of which he may be named a member, but he shall not be entitled to vote. Nature of advice by ministers. Article 74 provides for a council of ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. The 42nd and 44th Constitutional Amendment Act have made the advice binding on the President. Further, the nature of advice tendered by ministers to the President cannot be inquired by any court. This provision emphasizes the intimate and the confidential relationship between the President and the ministers. In 1971, the Supreme Court held that even after the dissolution of the Lok Sabha, the Council of Ministers does not cease to hold office. Article 74 is mandatory and therefore the President cannot exercise the executive power without the aid and advice of the Council of Ministers. Any exercise of executive power without the aid and advice will be unconstitutional as being violative of Article 74. Again in 1974, the court held that wherever the Constitution requires the satisfaction of the President, the satisfaction is not the personal satisfaction of the President, but it is the satisfaction of the Council of Ministers with whose aid and whose advice the President exercises his powers and functions. Appointment of ministers. The Prime Minister is appointed by the President while the other ministers are appointed by the President on the advice of Prime Minister. This means that the President can appoint only those persons as ministers who are recommended by the Prime Minister. Usually, the members of Parliament, either Lok Sabha or Rajya Sabha, are appointed as ministers. A person who is not a member of either House of Parliament can also be appointed as a minister, but within 6 months he must become a member either by election or by nomination of either House of Parliament, otherwise he ceases to be a minister. A minister who is a member of one House of Parliament has the right to speak and to take part in the proceedings of the other House also, but he can vote only in the House of which he is a member. Oath and salary of ministers. Before a minister enters upon his office, the President administers to him the oath of office and secrecy. In his oath of office, the minister swears, number 1, to bear true faith and allegiance to the Constitution of India, number 2, to uphold the sovereignty and integrity of India, number 3, to faithfully and conscientiously discharge the duties of his office, and to do right, number 4, to do right to all manner of people in accordance with the Constitution and the law without fear of favor, affection or ill will. In his oath of secrecy, the minister swears that he will not be directly or indirectly communicate or reveal to any persons any matter that is brought under his consideration or becomes known to him as a union minister, except as may be required for the due discharge of his duties as such minister. In 1990, the oath by Devi Lal as Deputy Prime Minister was challenged as being unconstitutional, as the Constitution provides only for the Prime Minister and ministers. The Supreme Court upheld the oath as valid and stated that describing a person as Deputy Prime Minister is descriptive only, and such description does not confer on him any powers of Prime Minister. It ruled that the description of a minister as Deputy Prime Minister or any other type of minister, such as Minister of State or Deputy Minister of which there is no mention in the Constitution, does not vitiate the oath taken by him so long as the substantive part of the oath is correct. The salaries and allowances of ministers are determined by Parliament from time to time. A minister gets the salary and allowances that are payable to a member of Parliament. Additionally, he gets a sumptuary allowance according to his rank, free accommodation, travelling allowance, medical facilities, etc. In 2001, the sumptuary allowances for the Prime Minister was raised from Rs 1500 to 3000 per month, for a Cabinet Minister from Rs 1000 to 2000 per month, for a Minister of State from Rs 500 to 1000 per month, and for a Deputy Minister from Rs 300 to 600 per month. Responsibility of ministers. Collective responsibility. The fundamental principle underlying the working of parliamentary system of government is the principle of collective responsibility. Article 75 clearly states that the Council of Ministers is collectively responsible to the Lok Sabha. This means that all the ministers own joint responsibility to the Lok Sabha for all their act of omission and commission. They work as a team and swim or sink together. When the Lok Sabha passes a no confidence motion against the Council of Ministers, all the ministers have to resign, including those ministers who are from the Rajya Sabha. Alternatively, the Council of Ministers can advise the President to dissolve the Lok Sabha on the ground that the House does not represent the views of the electorate faithfully and call for fresh elections. The President may not oblige the Council of Ministers that has lost the confidence of Lok Sabha. The principle of collective responsibility also means that the cabinet decisions bind all cabinet ministers and other ministers even if they differed in the cabinet meeting. It is the duty of every minister to stand by cabinet decisions and support them both within and outside the parliament. If any minister disagrees with the cabinet decision and is not prepared to defend it, he must resign. Several ministers have resigned in the past owing to their differences with the cabinet. For example, Dr. B.R. Ambedkar resigned because of his differences with his colleagues on the Hindu Code Bill in 1953. C.D. Deshmukh resigned due to his differences on the policy of reorganization of a state. Arif Muhammad resigned due to his opposition to the Muslim Women Protection of Right on Divorce Act 1986. Individual responsibility. Article 75 also contains the principle of individual responsibility. It states that the ministers hold office during the pleasure of the President, which means that the President can remove a minister even at a time when the Council of Ministers enjoys the confidence of the Lok Sabha. However, the President removes a minister only on the advice of the Prime Minister. In case of a difference of opinion or dissatisfaction with the performance of a minister, the Prime Minister can ask him to resign or advise the President to dismiss him. By exercising this power, the Prime Minister can ensure the realization of the role of collective responsibility. In this context, Dr. B.R. Ambedkar observed, collective responsibility can be achieved only through the instrumentality of the Prime Minister. Therefore, unless and until we create that office and endow that office with the statutory authority to nominate and dismiss ministers, there can be no collective responsibility. No legal responsibility. In Britain, every order of the king for any public act is countersigned by a minister. If the order is in violation of any law, the minister would be held responsible and would be liable in the court. The legally accepted phrase in Britain is, the king can do no wrong, hence he cannot be sued in any court. In India, on the other hand, there is no provision in the constitution for the system of legal responsibility of a minister. It is not required that an order of the president for a public act should be countersigned by a minister. Moreover, the courts are barred from inquiring into the nature of advice rendered by the ministers to the president. Composition of the Council of Ministers. The Council of Ministers consists of three categories of ministers, namely cabinet ministers, ministers of state, and deputy ministers. The difference between them lies in their respective ranks, emoluments, and political importance. At the top of all these ministers stands the Prime Minister, the supreme governing authority of the country. The cabinet ministers had the important ministries of the central government like Home, Defense, Finance, External Affairs, and so forth. They are members of the cabinet, attend its meetings, and play an important role in deciding policies. Thus, their responsibilities extends over the entire gamut of the central government. The ministers of state can either be given independent charge of ministries, departments, or can be attached to cabinet ministers. In case of attachment, they may either be given the charge of departments of the ministries headed by the cabinet ministers or allotted specific items of work related to the ministries headed by cabinet ministers. In both the cases, they work under the supervision and guidance as well as under the overall charge and responsibility of the cabinet ministers. In case of independent charge, they perform the same function and exercise the same powers in relation to their ministries, departments as cabinet ministers do. However, they are not members of the cabinet and do not attend the cabinet meetings unless specially invited when something related to their ministries, departments are considered by the cabinet. Next in rank are the deputy ministers. They are not given independent charge of ministries, departments. They are attached to the cabinet ministers or ministers of state and assist them in their administrative, political, and parliamentary duties. They are not members of the cabinet and do not attend cabinet meetings. It must also be mentioned here that there is one more category of ministers called parliamentary secretaries. They are the members of the last category of the Council of Ministers, which is also known as a ministry. They have no departments under their control. They are attached to the senior ministers and assist them in the discharge of their parliamentary duties. However, since 1967, no parliamentary secretaries have been appointed except during the first phase of Rajiv Gandhi government. At times, the Council of Ministers may also include a Deputy Prime Minister. The Deputy Prime Ministers are appointed mostly for political reasons. Council of Minister versus Cabinet. The word Council of Ministers and Cabinet are often used interchangeably, though they are definitely distinction between them. They differ from each other in respect of composition, functions, and role. Role of Cabinet. Number 1. It is the highest decision making authority in our politico administrative system. It is the chief policy formulating body of the central government. It is the supreme executive authority of the central government. It is a chief coordinator of central administration. It is an advisory body to the president and to advise binding on them. It is the chief crisis manager and thus deals with all emergency situations. It deals with all major legislative and financial matters. It exercises control over higher appointments like constitutional authorities and senior secretariat administrators. It deals with all foreign policies and foreign affairs. Distinction between Council of Ministers and Cabinet. Number 1. Council of Ministers is a wider body consisting of 60 to 70 ministers, while Cabinet is a smaller body consisting of 15 to 20 ministers. Number 2. Council of Ministers includes all the three categories of ministers, that is Cabinet Ministers, Ministers of State and Deputy Ministers, while Cabinet includes the Cabinet Ministers only. Thus, it is a part of the Council of Ministers. Number 3. Council of Ministers does not meet as a body to transact government business. It has no collective functions, while Cabinet meets as a body frequently and usually once in a week to deliberate and take decisions regarding the transaction of government business. Number 4. Thus it is collective function. Number 4. Council of Ministers is vested with all powers but in theory, while Cabinet practice the powers of the Council of Ministers and thus act for the latter. Number 5. Council of Ministers functions are determined by the Cabinet, while Cabinet directs the Council of Ministers by taking policy decisions which are binding on all ministers. Number 6. Council of Ministers implements the decision taken by the Cabinet, while Cabinet supervises the implementation of its decisions by the Council of Ministers. Number 7. Council of Ministers is a constitutional body dealt in detail by the Article 74 and 75 of the Constitution. Its size and classification are, however, not mentioned in the Constitution. Its size is determined by the Prime Minister according to the exigencies of the time and requirements of the situation. Its classification into a three-tier body is based on the conventions of parliamentary government as developed in Britain. It has, however, got a legislative sanction. Thus, the Salaries and Allowances Act of 1952 defines a minister as a member of the Council of Ministers by whatever name called and includes a deputy minister, while Cabinet was inserted in Article 352 of the Constitution in 1978 by the 44th Constitutional Amendment Act. Thus, it did not find a place in the original text of the Constitution. Now, also Article 352 only defines the Cabinet, saying that it is the council consisting of the Prime Minister and other ministers of Cabinet rank appointed under Article 75 and does not describe its powers and functions. In other words, its role in other politico-administrative system is based on the conventions of parliamentary government as developed in Britain. Number 8. Council of Ministers is collectively responsible to the lower house of the Parliament, while Cabinet enforces the collective responsibility of the Council of Ministers to the lower house of Parliament. Role descriptions. The various comments made by the eminent political scientists and constitutional experts on the role of Cabinet in Britain holds good in the Indian context also. These are mentioned below. Ramsey Muir. The Cabinet is the steering wheel of the ship of the state. Lowell. The Cabinet is the keystone of the political arc. Sir John Marriott. The Cabinet is the pivot around which the whole political machinery revolves. Gladstone. The Cabinet is the solar orbit around which the other bodies revolve. Barker. The Cabinet is the magnet of policy. Bagot. The Cabinet is a hyphen that joins the buckles that binds the executive and legislative departments together. Sir Ivor Jennings. The Cabinet is the core of the British constitutional system. It provides unity to the British system of government. Alice Emery. The Cabinet is the central directing instrument of government. The position of the cabinet in the British government has become so strong that Ramsay Muir referred to it as the dictatorship of the cabinet. In his book How Britain is Governed, he writes, a body which wields such powers as these may fairly be described as omnipotent in theory, however incapable it may be of using its omnipotence, its position, whenever it commands a majority, is a dictatorship only qualified by publicity. This dictatorship is far more absolute than it was 2 generations ago. The same description holds good in the Indian context too. Kitchen Cabinet. The Cabinet, a small body consisting of the Prime Minister as its head and some 15 to 20 most important ministers, is the highest decision making body in the formal sense. However, still a smaller body called the Inner Cabinet or Kitchen Cabinet has become the real center of power. This informal body consists of the Prime Minister and 2 to 4 influential colleagues in whom he has faith and with whom he can discuss every problem. It advises the Prime Minister on important political and administrative issues and assists him in making crucial decisions. It is composed of not only cabinet ministers but also outsiders like friends and family members of the Prime Minister. Every Prime Minister in India has had his inner cabinet, a circle within a circle. During the era of Indira Gandhi, the inner cabinet, which came to be called the kitchen cabinet, was particularly powerful. The Prime Ministers have resorted to the device of inner cabinet, extra constitutional body, due to its merits, namely, number one, it being a small unit is much more efficient decision-making body than a large cabinet. Number 2, it can meet more often and deal with business much more expeditiously than the large cabinet. Number 3, it helps the Prime Minister in maintaining secrecy in making decisions on important political issues. However, it has many demerits also. Thus, number 1, it reduces the authority and status of the cabinet as the highest decision-making body. Number 2, it circumvents the legal process by allowing outside persons to play an influential role in the government functioning. The phenomenon of kitchen cabinet, where decisions are cooked and placed before the cabinet for formal approval, is not unique to India. It also exists in USA and Britain and is quite powerful in influencing government decisions there. Chapter 21, Cabinet Committees. Features of Cabinet Committees. The following are the features of Cabinet Committees. Number 1, they are extra constitutional in emergence. In other words, they are not mentioned in the Constitution. However, the rules of business provide for their establishment. Number 2, they are of 2 types, standing and ad hoc. The former are of a permanent nature while the latter are of a temporary nature. The ad hoc committees are constituted from time to time to deal with special problems. They are disbanded after their task is completed. Number 3, they are set up by the Prime Minister according to the exigencies of the time and requirements of the situation. Hence, their number, nomenclature, and composition varies from time to time. Number 4, their membership varies from 3 to 8. They usually include only cabinet ministers. However, the non-cabinet ministers are not debarred from their membership. Number 5, they not only include the ministers in charge of subjects covered by them but also include other senior ministers. Number 6, they are mostly headed by the Prime Minister. Sometimes other cabinet ministers, particularly the Home Minister or the Finance Minister, also act as their chairman. But in case the Prime Minister is a member of committee, he invariably presides over it. Number 7, they not only sort out issues and formulate proposals for the consideration of the cabinet but also take decisions. However, the cabinet can review their decisions. Number 8, they are an organizational device to reduce the enormous workload of the cabinet. They also facilitate in-depth examination of policy issues and effective coordination. They are based on the principles of division of labors and effective delegation. List of cabinet committees. In 1994, there were the following 13 cabinet committees. Number 1, Cabinet Committee on Political Affairs. Number 2, Cabinet Committee on Natural Calamities. Number 3, Cabinet Committee on Parliamentary Affairs. Number 4, Appointment Committee of the Cabinet. Number 5, Cabinet Committee on Accommodation. Number 6, Cabinet Committee on Foreign Investment. Number 7, Cabinet Committee on Drug Abuse Control. Number 8, Cabinet Committee on Prices. Number 9, Cabinet Committee on Minority Welfare. Number 10. Cabinet Committee on Economic Affairs. Number 11. Cabinet Committee on Trade and Investment. Number 12. Cabinet Committee on Expenditure. Number 13. Cabinet Committee on Infrastructure. In 2013, the following 10 cabinet committees were in existence. Number 1. Cabinet Committee on Economic Affairs. Number 2. Cabinet Committee on Prices. Number 3. Cabinet Committee on Political Affairs. Number 4. Appointment Committee of the Cabinet. Number 5. Cabinet Committee on Security. Number 6. Cabinet Committee on World Trade Organization Matters. Number 7. Cabinet Committee on Investment. Number 8. Cabinet Committee on Unique Identification Authority of India related issues. Number 9. Cabinet Committee on Parliamentary Affairs. At present, 2019, the following 8 cabinet committees are functional. Number 1. Cabinet Committee on Political Affairs. Number 2. Cabinet Committee on Economic Affairs. Number 3. Appointment Committee of the Cabinet. Number 4. Cabinet Committee on Security. Number 5. Cabinet Committee on Parliamentary Affairs. Number 6. Cabinet Committee on Accommodation. Number 7. Cabinet Committee on Investment and Growth. Number 8. Cabinet Committee on Employment and Skill Development. Functions of Cabinet Committees. The following 4 are the more important Cabinet Committees. Number 1. The Political Affairs Committee deals with all policy matters pertaining to domestic and foreign affairs. Number 2. The Economic Affairs Committee directs and coordinates the governmental activities in the economic sphere. Number 3. Appointment Committee decides all higher level appointments in the Central Secretariat, public enterprises, banks and financial institutions. Number 4. Parliamentary Affairs Committee looks after the progress of government business in the Parliament. The first 3 committees are chaired by the Prime Minister and last one by the Home Minister. Of all the cabinet committees, the most powerful is the Political Affairs Committee, often described as a super cabinet. Groups of ministers. In addition to cabinet committee, several groups of ministers are constituted to look into different issues, subjects. Some of these groups of ministers are empowered to take decisions on behalf of the cabinet, whereas the other make recommendations to the cabinet. The institution of GOMs has become a viable and effective instrument of coordination among the ministries. These are an ad hoc bodies formed to give recommendations to the cabinet on certain emergent issues and critical problem areas. Ministers heading the concerned ministries are inducted into the relevant GOMs, and when the advice is crystallized, they are disbanded. The Second Administrative Reform Commission 2005-9 made the following observations and recommendations with respect to the working of government group of ministers. Number 1. The Commission observed that the constitution of a large number of GOMs has resulted in many GOMs not being able to meet regularly to complete their work, thus leading to significant delays on many major issues. Number 2. The Commission felt that more selective use of the institution of GOMs would perhaps lead to more effective coordination, particularly if they are empowered to arrive at a decision on behalf of the Cabinet with time limits that are prescribed for completing the work entrusted to them. Number 3. The Commission recommended that there is a need to ensure that the existing coordination mechanism of GOMs function effectively and helps in early resolution of issues. Selective but effective use of group of ministers with clear mandate and prescribed time limits would be helpful. Chapter 22. Parliament. The Parliament is the legislative organ of the Union Government. It occupies a preeminent and central position in the Indian democratic political system due to adoption of the parliamentary form of government, also known as Westminster model of government. Article 79 to 122 in Part 5th of the Constitution deal with the organization, composition, duration, officers, procedures, privileges, powers and so on of the Parliament. Organization of Parliament. Under the Constitution, the Parliament of India consists of 3 parts, that is, the President, the Council of State and the House of the People. In 1954, the Hindi names Rajya Sabha and Lok Sabha were adopted by the Council of States and the House of People respectively. The Rajya Sabha is the upper house, second chamber or House of Elders, and the Lok Sabha is the lower house, first chamber or popular house. The former represents the states and union territories of the Indian Union, while the latter represents the people of India as a whole. Though the President of India is not a member of either House of Parliament and does not sit in the Parliament to attend its meetings, he is an integral part of the Parliament. This is because a bill passed by both the Houses of Parliament cannot become a law without the President's assent. He also performs certain functions relating to the proceedings of the Parliament. For example, he summons and prorogues both the houses, dissolves the Lok Sabha, addresses both the houses, issues ordinances when they are not in session, and so on. In this respect, the framers of the Indian Constitution relied on the British pattern rather than the American pattern. In Britain, the Parliament consists of the Crown, King or Queen, the House of Lords, Upper House, and the House of Commons, Lower House. By contrast, the American President is not an integral part of the legislature. In USA, the legislature, which is known as Congress, consists of the Senate, Upper House, and the House of Representatives, Lower House. The parliamentary form of government emphasizes on the interdependence between the legislative and executive organs. Hence, we have the president in parliament like the crown in parliament in Britain. The presidential form of government, on the other hand, lays stress on the separation of legislative and executive organs. Hence, the American president is not regarded as a constituent part of the Congress. Composition of the two houses. Composition of Rajya Sabha. The maximum strength of the Rajya Sabha is fixed at 250, out of which 238 are to be the representatives of the states and union territories elected indirectly, and 12 are nominated by the President. At present, the Rajya Sabha has 245 members. Of these, 229 members represent the state, 4 members represent the union territories, and 12 members are nominated by the President. The fourth schedule of the Constitution deals with the allocation of seats in the Rajya Sabha to the states and union territories. Number 1. Representation of state. The representatives of states in the Rajya Sabha are elected by the elected members of the state legislative assemblies. The election is held in accordance with the system of proportional representation by means of the single transferable vote. The seats are allotted to the states in the Rajya Sabha on the basis of population. Hence, the number of representatives varies from state to state. For example, Uttar Pradesh has 31 members while Tripura has 1 member only. However, in USA, all states are given equal representation in the Senate irrespective of their population. USA has 50 states and the Senate has 100 members, 2 from each state. Number 2. Representation of union territories. The representatives of each union territory in the Rajya Sabha are indirectly elected by members of an electoral college specially constituted for the purpose. This election is also held in accordance with the system of proportional representation by means of the single transferable vote. Out of the 9 union territories, only 3, Delhi, Puducherry and Jammu and Kashmir, have representations in Rajya Sabha. The populations of other 6 union territories are too small to have any representative in the Rajya Sabha. Number 3. Nominated members. The President nominates 12 members to the Rajya Sabha from people who have special knowledge or practical experience in art, literature, science and social service. The rationale behind this principle of nomination is to provide eminent persons a place in Rajya Sabha without going through the process of election. It should be noted here that the American Senate has no nominated members. Composition of Lok Sabha. The maximum strength of the Lok Sabha is fixed at 552. Out of this, 530 members are to be representatives of the state, 20 members are to be representatives of the union territories, and 2 members are to be nominated by the President from the Anglo-Indian community. At present, the Lok Sabha has 545 members. Of these, 530 members represent the state, 13 members represent the union territories, and 2 Anglo-Indian members are nominated by the President. Number 1. Representation of a state. The representatives of states in the Lok Sabha are directly elected by the people from the territorial constituencies in the state. The election is based on the principle of universal adult franchise. Every Indian citizen who is above 18 years of age and who is not disqualified under the provision of the Constitution or any law is eligible to vote at such election. The voting age was reduced from 21 to 18 years by the 61st Constitutional Amendment Act of 1988. Number 2. Representation of Union Territories. The Constitution has empowered the Parliament to prescribe the manner of choosing the representatives of the Union Territories in the Lok Sabha. Accordingly, the Parliament has enacted the Union Territories Direct Election to the House of the People Act 1965, by which the members of Lok Sabha from the Union Territories are also chosen by direct election. Number 3. Nominated members. The President can nominate 2 members from the Anglo-Indian community if the community is not adequately represented in the Lok Sabha. Originally, this provision was to operate till 1960 but has been extended till 2020 by the 95th Amendment Act of 2009. System of elections to Lok Sabha. The various aspects related to the system of elections to the Lok Sabha are as follows. Territorial constituencies. For the purpose of holding direct elections to the Lok Sabha, each state is divided into territorial constituencies. In this respect, the Constitution makes the following 2 provisions. Number 1. Each state is allotted a number of seats in Lok Sabha in such a manner that the ratio between that number and its population is the same for all states. This provision does not apply to a state having a population of less than 6 millions. Number 2. Each state is divided into territorial constituencies in such a manner that the ratio between the population of each constituency and the number of seats allotted to it is the same throughout the state. In brief, the Constitution ensures that there is uniformity of representation in 2 respects between the different states and between the different constituencies in the same state. The expression population means the population as ascertained at the preceding census of which the relevant figures have been published. Readjustment after each census. After every census, a readjustment is to be made in allocation of seats in the Lok Sabha to the state and division of each state into territorial constituencies. Parliament is empowered to determine the authority and the manner in which it is to be made. Accordingly, the Parliament has enacted the Delimitation Commission Act in 1952, 1962, 1972 and 2002 for this purpose. The 42nd Amendment Act of 1976 froze the allocation of seats in the Lok Sabha to the states and the division of each state into territorial constituencies till the year 2000 at the 1971 level. This ban on readjustment was extended for another 25 years, that is, up to year 2026, by the 84th Amendment Act of 2001, with the same objective of encouraging population limiting measures. The 84th Amendment Act of 2001 also empowered the government to undertake readjustment and rationalization of territorial constituencies in the states on the basis of the population figures of 1991 census. Later, the 87th Amendment Act of 2003 provided for the delimitation of constituencies on the basis of 2001 census and not 1991 census. However, this can be done without altering the number of seats allotted to each state in the Lok Sabha. Reservation of seats for SCs and STs. Though the Constitution has abandoned the system of communal representation, it provides for the reservation of seats for scheduled caste and scheduled tribes in the Lok Sabha on the basis of population ratios. Originally, this reservation was to operate for 10 years, that is up to 1960, but it has been extended continuously since then by 10 years each time. Now, under the 95th Amendment Act of 2009, this reservation is to last until 2020. Though seats are reserved for scheduled castes and scheduled tribes, they are elected by all the voters in a constituency without any separate electorate. A member of scheduled caste and scheduled tribe is also not debarred from contesting a general non-reserved seat. The 84th Amendment Act of 2001 provided for refixing of the reserved seats on the basis of the population figures of 1991 census as applied to rationalization of the general seats. Later, the 87th Amendment Act of 2003 provided for the refixing of the reserved seats on the basis of 2001 census and not 1991 census. First past the post system. Though the Constitution has adopted the system of proportional representation in the case of Rajya Sabha, it has not preferred the same system in the case of Lok Sabha. Instead, it has adopted the system of territorial representation, first past the post system for the election of members to the Lok Sabha. Under territorial representation, every member of the legislature represents a geographical area known as a constituency. From each constituency, only one representative is elected. Hence, such a constituency is known as single member constituency. In this system, a candidate who secures majority of votes is declared elected. This simple majority system of representation does not represent the whole electorate. In other words, it does not secure due representation to minorities, small groups. The system of proportional representation aims at removing the defects of territorial representation. Under this system, all sections of the people get representation in proportion to their number. Even the smallest section of the population gets its due share of representation in the legislature. There are two kinds of proportional representation, namely single transferable vote system and list system. In India, the first kind is adopted for the election of members to the Rajya Sabha and State Legislative Council and for electing the President and the Vice President. Though some members of the Constituent Assembly had advocated the system of proportional representation for the election of members to the Lok Sabha, the Constitution has not adopted the system due to two reasons. Number one, difficulty for the voters to understand the system, which is complicated due to low literacy scale in the country. Number two, unsuitability to the parliamentary government due to the tendency of the system to multiply political parties, leading to instability in government. Additionally, the system of proportional representation has the following demerits. Number one, it is highly expensive. Number two, it does not give any scope for organizing by-elections. Number three, it eliminates intimate contacts between voters and representatives. Number 4. It promotes minority thinking and group interest. Number 5. It increases the significance of party system and decreases that of voters. Duration of two houses. Duration of Rajya Sabha. The Rajya Sabha, first constituted in 1952, is a continuing chamber, that is, it is a permanent body and not subject to dissolution. However, one-third of its members retire every second year. Their seats are filled up by fresh elections and presidential nominations at the beginning of every third year. The retiring members are eligible for re-election and re-nomination any number of times. The Constitution has not fixed the term of office of members of the Rajya Sabha and left it to the Parliament. Accordingly, the Parliament in the Representation of People Act 1951 provided that the term of office of a member of Rajya Sabha shall be 6 years. The Act also empowered the President of India to curtail the term of members chosen in the first Rajya Sabha. In the first batch, it was decided by lottery as to who should retire. Further, the Act also authorized the President to make provisions to govern the order of retirement of the members of the Rajya Sabha. Duration of Lok Sabha. Unlike the Rajya Sabha, the Lok Sabha is not a continuing chamber. Its normal term is 5 years from the date of its first meeting after the general elections, after which it automatically dissolves. However, the President is authorized to dissolve the Lok Sabha at any time, even before the completion of 5 years, and this cannot be challenged in a court of law. Further, the term of Lok Sabha can be extended during the period of national emergency, be a law of parliament for 1 year at a time for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. Membership of Parliament. Qualifications. The Constitution lays down the following qualifications for a person to be chosen as a member of Parliament. Number 1. He must be a citizen of India. Number 2. He must make and subscribe to an oath or affirmation before the person authorized by the Election Commission for this purpose. In his oath or affirmation, he swears to bear true faith and allegiance to the Constitution of India and to uphold the sovereignty and integrity of India. Number 3. He must be not less than 30 years of age in the case of Rajya Sabha and not less than 25 years of age in the case of Lok Sabha. Number 4. He must possess other qualifications prescribed by the Parliament. The Parliament has laid down the following additional qualifications in the Representation of People Act 1951. Number 1. He must be registered as an elector for a parliamentary constituency. This is same in the case of both the Rajya Sabha and Lok Sabha. The requirement that a candidate contesting an election to the Rajya Sabha from a particular state should be an elector in that particular state was dispensed within 2003. In 2006, the Supreme Court upheld the constitutional validity of this change. Number 2. He must be a member of a scheduled caste or scheduled tribe in any state or union territory if he wants to contest a seat reserved for them. However, a member of scheduled caste or scheduled tribes can also contest a seat not reserved for them. Disqualifications. Under the Constitution, a person shall be disqualified for being elected a member of parliament. Number 1. If he holds any office of profit under the union or state government except that of a minister or any other office exempted by parliament. Number 2. If he is of unsound mind and stands so declared by a court. Number 3. If he is an undischarged insolvent. Number 4. If he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance to a foreign state. Number 5. If he is so disqualified under any law made by Parliament. The Parliament has laid down the following additional disqualifications in the Representation of People Act 1951. Number 1. He must not have been found guilty of certain election offences or corrupt practices in the elections. Number 2. He must not have been convicted for any offences resulting in imprisonment for 2 or more years, but the detention of person under a preventive detention law is not a disqualification. Number 3. He must not have failed to lodge an account of his election expenses within the time. Number 4. He must not have any interest in government contract, work or services. Number 5. He must not be a director or managing agent nor hold a office of profit in a corporation in which the government has at least 25% share. Number 6. He must not have been dismissed from government services for corruption or disloyalty to the state. Number 7. He must not have been convicted for promoting enmity between different groups or for the offense of bribery. Number 8. He must not have been punished for preaching and practicing social crimes such as untouchability, dowry, and sati. On the question whether a member is subject to any of the above disqualifications, the President's decision is final. However, he should obtain the opinion of the Election Commission and act accordingly. Disqualification on ground of defection. The Constitution also lays down that a person shall be disqualified from being a member of Parliament if he is so disqualified on the ground of defection under the provision of the 10th schedule. A member incurs disqualification under the defection law. Number 1. If he voluntarily gives up the membership of the political party on whose ticket he is elected to that house. Number 2. If he votes or abstains from voting in the house contrary to any direction given by his political party. Number 3. If any independently elected member joins any political party. Number 4. If any nominated member joins any political party after the expiry of 6 months. The question of disqualification under the 10th schedule is decided by the chairman in the case of Rajya Sabha and a speaker in the case of Lok Sabha and not by the President of India. In 1992, the Supreme Court ruled that the decision of the chairman, speaker in this regard is subject to judicial review. Vacating of seats. In the following cases, a member of parliament vacates his seat. Number 1. Double membership. A person cannot be a member of both houses of parliament at the same time. Thus, the Representation of People Act 1951 provides for the following. If a person is elected to both the houses of parliament, he must intimate within 10 days in which house he desires to serve. In default of such intimation, his seat in Rajya Sabha becomes vacant. B. If a sitting member of one house is also elected to the other house, his seat in the first house becomes vacant. C. If a person is elected to 2 seats in a house, he should exercise his option for one. Otherwise, both seats become vacant. Similarly, a person cannot be a member of both the parliament and the state legislature at the same time. If a person is elected His seat in parliament becomes vacant if he does not resign his seat in the state legislature within 14 days. Number 2. Disqualification. If a member of parliament becomes subject to any of the disqualifications specified in the constitution, his seat becomes vacant. Here the list of disqualifications also include the disqualification on the ground of defection under the provision of the 10th schedule of the constitution. Number 3. Resignation. A member may resign his seat by writing to the chairman of Rajya Sabha or Speaker of Lok Sabha. As the case may be, the seat falls vacant when the resignation is accepted. However, the chairman, speaker may not accept the resignation if he is satisfied that it is not voluntary or genuine. Number 4. Absence. A house can declare the seat of a member vacant if he is absent from all its meeting for a period of 60 days without its permission. In computing the period of 60 days, no account shall be taken of any period during which the house is prorogued or adjourned for more than 4 consecutive days. Number 5. Other cases. A member has to vacate his seat in the parliament if his election is declared void by the court, if he is expelled by the house, if he is elected to the office of president or vice president, if he is appointed to the office of governor of a state. If a disqualified person is elected to the parliament, the constitution lays down no procedure to declare the election void. This matter is dealt with the Representation of the People Act 1951, which enables the High Court to declare an election void if a disqualified candidate is elected. The aggrieved party can appeal to the Supreme Court against the order of the High Court in this regard. Oath or affirmation. Every member of either House of Parliament, before taking his seat in the House, has to make and subscribe to an oath or affirmation before the President or some person appointed by him for this purpose. In his oath or affirmation, a member of Parliament swears to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to faithfully discharge the duty upon which he is about to enter. Unless a member takes the oath, he cannot vote and participate in the proceedings of the House and does not become eligible to parliamentary privileges and immunities. A person is liable to a penalty of Rs 500 for each day he sits or votes as a member in a House in the following conditions. Number 1. Before taking and subscribing to the prescribed oath or affirmation. Number 2. When he knows that he is not qualified or that he is disqualified for its membership. Number 3. When he knows that he is prohibited from sitting or voting in the House by virtue of any parliamentary law. Salaries and allowances. Members of either House of Parliament are entitled to receive such salaries and allowances as may be determined by the Parliament, and there is no provision of pension in the Constitution. However, Parliament has provided pension to the members. In 1954, the Parliament enacted the Salaries, Allowances and Pension of Members of Parliament Act. In 2018, the salary of members was increased from Rs 50,000 to Rs 1 lakh per month. The constituency allowances from Rs 45,000 to Rs 70,000 per month, and the office expenses allowances from Rs 45,000 to Rs 60,000 per month. Earlier in 2010, the daily allowances was increased from Rs 1,000 to 2,000 for each day of residence on duty. From 1976, the members are also entitled to a pension on a graduated scale for each 5-year term as members of either House of Parliament. Besides, they are provided with travelling facilities, free accommodation, telephone, vehicle advance, medical facilities, and so on. The salaries and allowances of the Speaker and Deputy Speaker of Lok Sabha and the Chairman and Deputy Chairman of Rajya Sabha are also determined by Parliament. They are charged on the Consolidated Fund of India and thus are not subject to the annual vote of Parliament. In 1953, the Parliament enacted the Salaries and Allowances of Officers of Parliament Act. Under this Act, Officer of Parliament means any of the following officers, namely the Chairman and Deputy Chairman of Rajya Sabha and the Speaker and the Deputy Speaker of Lok Sabha. In 2018, the Parliament increased the salary of the Chairman of the Rajya Sabha from Rs 1.25 lakh to Rs 4 lakh per month. Similarly, other officers of Parliament, that is the Speaker and Deputy Speaker of Lok Sabha and Deputy Chairman of Rajya Sabha, are entitled to receive a salary per month at the same rates as are payable to the members of Parliament. Further, Each officer of parliament, other than the chairman of Rajya Sabha, is entitled to receive a daily allowances for each day during the whole of his term at the same rate as is payable to the members of parliament. Also, each officer of parliament, other than the chairman of Rajya Sabha, is entitled to receive a constituency allowance at the same rate and as is payable to the member of parliament. According to the same act, the sumptuary allowance is paid to the speaker of Lok Sabha at the same rate as is payable to a cabinet minister, that is rupees 2000 per month. Likewise, the sumptuary allowance is paid to the Deputy Speaker of Lok Sabha and the Deputy Chairman of Rajya Sabha at the same rate as is payable to a Minister of State, that is rupees 1000 per month. Presiding officers of Parliament. Each House of Parliament has its own presiding officer. There is a Speaker and a Deputy Speaker for the Lok Sabha and a Chairman and a Deputy Chairman for the Rajya Sabha. A panel of chairpersons for the Lok Sabha and a panel of vice chairpersons for the Rajya Sabha is also appointed. Speaker of Lok Sabha. Election and tenure. The Speaker is elected by the Lok Sabha from amongst its members as soon as may be after its first sitting. Whenever the office of the Speaker falls vacant, the Lok Sabha elect another member to fill the vacancy. The date of election of a Speaker is fixed by the President. Usually the Speaker remains in office during the life of Lok Sabha. However, he has to vacate his office earlier in any of the following three cases. Number 1. If he ceases to be a member of Lok Sabha. Number 2. If he resigns by writing to the Deputy Speaker. And number 3. If he is removed by a resolution passed by a majority of all the then members of Lok Sabha, such a resolution can be moved only after giving 14-day advance notice. When a resolution for the removal of the Speaker is under consideration of the House, he cannot preside at the sitting of the House, though he may be present. However, he can speak and take part in the proceedings of the House at such a time and vote in the first instance, though not in the case of an equality of votes. It should be noted here that whenever the Lok Sabha is dissolved, the Speaker does not vacate his office and continues till the newly elected Lok Sabha meets. Role, powers and functions. The Speaker is the head of the Lok Sabha and is representative. He is the guardian of powers and privileges of the members, the House as a whole and its committee. He is principal spokesman of the House and his decision in all parliamentary matters is final. He is thus much more than merely the presiding officer of Lok Sabha. In these capacities, he is vested with vast, varied and vital responsibilities and enjoys great honor, high dignity and supreme authority within the House. The Speaker of the Lok Sabha derives his power and duties from three sources, that is, the Constitution of India, the Rules of Procedure and Conduct of Business of Lok Sabha and Parliamentary Convention, residuary powers that are unwritten or unspecified in the rules. Altogether, he has the following powers and duties. Number 1. He maintained order and decorum in the House for conducting its business and regulating its proceedings. This is his primary responsibility and he has final power in this regard. Number 2. He is the final interpreter of the provision of the Constitution of India, the Rules of Procedure and Conduct of Business of Lok Sabha and the parliamentary procedures within the House. Number 3. He adjourns the House or suspends the meeting in absence of a quorum. The quorum to constitute a meeting of the House is 1/10 of the total strength of that House. Number 4. He does not vote in the first instance, but he can exercise a casting vote in the case of a tie. In other words, only when the House is divided equally on any question, the Speaker is entitled to vote. Such vote is called casting vote and its purpose is to resolve a deadlock. Number 5. He presides over a joint sitting of the two houses of parliament. Such a sitting is summoned by the president to settle a deadlock between the two houses on a bill. Number 6. He can allow a secret sitting of the House at the request of the leader of the House. When the House sits in secret, no stranger can be present in the chamber, lobby or galleries except with the permission of the Speaker. He decides whether a bill is a money bill or not, and his decision on this question is final. When a money bill is transmitted to the Rajya Sabha for recommendation and presented to the President for assent, the Speaker endorses on the bill his certificate that it is a money bill. Number 8. He decides the question of disqualification of a member of Lok Sabha arising on the ground of defection under the provision of the 10th schedule. In 1992, the Supreme Court ruled that the decision of the Speaker in this regard is subject to judicial review. Number 9. He acts as the ex officio chairman of the Indian Parliamentary Group, which is a link between the Parliament of India and the various parliaments of the world. He also acts as the ex officio chairman of the conferences of presiding officers of legislative bodies in the country. Number 10. He appoints the chairman of all the parliamentary committees of Lok Sabha and supervises their functioning. He himself is the chairman of the Business Advisory Committee, the Rules Committee, and the General Purpose Committee. Independence and impartiality. As the office of Speaker is vested with great prestige, position, and authority, independence and impartiality becomes its sine qua non. The following provisions ensure that the independence and impartiality of the office of the Speaker. Number 1. He is provided with a security of tenure. He can be removed only by a resolution passed by the Lok Sabha by a special majority, that is a majority of all the then members of the House, and not by an ordinary majority, that is a majority of the members present and voting in the House. This motion of removal can be considered and discussed only when it has the support of at least 50 members. Number 2. His salaries and allowances are fixed by Parliament. They are charged on the Consolidated Fund of India and thus are not subject to the annual vote of Parliament. Number 3. His work and conduct cannot be discussed and criticized in the Lok Sabha except on a substantive motion. Number 4. His powers of regulating procedure or conducting business or maintaining order in the House are not subject to the jurisdiction of any court. Number 5. He cannot vote in the first instance. He can only exercise a casting vote in the event of a tie. This makes the position of Speaker impartial. Number 6. He is given a very high position in the order of precedence. He is placed at 7th rank along with the Chief Justice of India. This means he has a higher rank than all cabinet ministers except the Prime Minister or Deputy Prime Minister. In Britain, the Speaker is strictly a non-party man. There is a convention that the Speaker has to resign from his party and remain politically neutral. This healthy convention is not fully established in India, where the Speaker does not resign from the membership of his party on his election to the exalted office. Deputy Speaker of Lok Sabha. Like the Speaker, the Deputy Speaker is also elected by the Lok Sabha itself from amongst its members. He is elected after the election of the Speaker has taken place. The date of election of the Deputy Speaker is fixed by the Speaker. Whenever the office of the Deputy Speaker falls vacant, the Lok Sabha elects another member to fill the vacancy. Like the Speaker, the Deputy Speaker remains in office usually during the life of the Lok Sabha. However, he may vacate his office earlier in any of the following 3 cases. Number 1. If he ceases to be a member of Lok Sabha. Number 2. If he resigns by writing to the Speaker. Number 3. If he is removed by a resolution passed by a majority of all the then members of the Lok Sabha. Such a resolution can be moved only after giving 14 days advance notice. The Deputy Speaker performs the duties of the Speaker's office when it is vacant. He also acts as the Speaker when the latter is absent from the sitting of the House. In both the cases, he assumes all the powers of the Speaker. He also presides over the joint sitting of both the Houses of Parliament in case the Speaker is absent from such a sitting. It should be noted here that the Deputy Speaker is not subordinate to the Speaker. He is directly responsible to the House. The Deputy Speaker has one special privilege, that is, whenever he is appointed as a member of a parliamentary committee, he automatically becomes its chairman. Like the Speaker, the Deputy Speaker, while presiding over the House, cannot vote in the first instance. He can only exercise a casting vote in the case of a tie. Further, when a resolution for the removal of the Deputy Speaker is under consideration of the House, he cannot preside at the sitting of the House, though he may be present. When the Speaker presides over the House, the Deputy Speaker is like any other ordinary member of the House. He can speak in House, participate in its proceedings, and vote on any question before the House. The Deputy Speaker is entitled to a regular salary and allowance fixed by Parliament and charged on the Consolidated Fund of India. Up to to the 10th Lok Sabha, both the Speaker and Deputy Speaker were usually from the ruling party. Since the 11th Lok Sabha, there has been a consensus that the Speaker comes from the ruling party, a ruling alliance, and the post of Deputy Speaker goes to the main opposition party. The Speaker and the Deputy Speaker, while assuming their offices, do not make and subscribe any separate oath or affirmation. The institution of Speaker and Deputy Speaker originated in India in 1921 under the provision of the Government of India Act of 1990, Montagu-Chelmsford Reforms. At that time, the Speaker and the Deputy Speaker were called the President and the Deputy President respectively, and the same nomenclature continued till 1947. Before 1921, the Governor General of India used to preside over the meetings of the Central Legislative Council. In 1921, the Frederick White and Sachidanand Sinha were appointed by the Governor General of India as the first Speaker and the first Deputy Speaker respectively of the Central Legislative Assembly. In 1925, Vittal Bhai J. Patel became the first Indian and the first elected Speaker of the Central Legislative Assembly. The Government of India Act of 1935 changed the nomenclatures of President and Deputy President of the Central Legislative Assembly to the Speaker and Deputy Speaker respectively. However, the old nomenclature continued till 1947 as the federal part of the 1935 Act was not implemented. G.V. Mavlankar and Anantha Sayanam Iyengar had the distinction of being the first Speaker and the first Deputy Speaker respectively of Lok Sabha. G.V. Mavlankar also held the post of Speaker in the Constituent Assembly, Legislative as well as the Provisional Parliament. He held the post of Speaker of Lok Sabha continuously for 1 decade from 1946 to 56. Panel of Chairperson of Lok Sabha. Under the rules of Lok Sabha, the Speaker nominates from amongst the member a panel of not more than 10 chairpersons. Any of them can preside over the House in the absence of the Speaker or the Deputy Speaker. He has the same powers as the Speaker when so presiding. He holds office until a new panel of chairpersons is nominated. When a member of the panel of chairperson is also not present, any other person, as determined by House, act as the Speaker. It must be emphasized here that a member of the panel of chairpersons cannot preside over the House when the office of the Speaker or Deputy Speaker is vacant. During such time, the Speaker's duties are to be performed by such member of the House as the President may appoint for the purpose. The elections are held as soon as possible to fill the vacant post. Speaker Pro Tem. As provided by the Constitution, the Speaker of the last Lok Sabha vacates his office immediately before the first meeting of the newly elected Lok Sabha. Therefore, the President appoints a member of Lok Sabha as the Speaker Pro Tem. Usually, the senior-most member is selected for this. The President himself administers oath to the Speaker Pro Tem. The Speaker Pro Tem has all the powers of the Speaker. He presides over the first sitting of the newly elected Lok Sabha. His main duty is to administer oath to the new members. He also enables the House to elect the new Speaker. When the new Speaker is elected by the House, the office of the Speaker Pro Tem ceases to exist. Hence, this office is a temporary office existing for a few days. Chairman of Rajya Sabha. The presiding officer of the Rajya Sabha is known as the Chairman. The Vice President of India is the ex officio Chairman of the Rajya Sabha. During any period when the Vice President acts as President or discharges the function of the President, he does not perform the duties of the office of the Chairman of Rajya Sabha. The Chairman of Rajya Sabha can be removed from his office only if he is removed from the office of the Vice President. As a presiding officer, the powers and functions of the Chairman in the Rajya Sabha are similar to those of the Speaker in the Lok Sabha. However, the Speaker has two special powers which are not enjoyed by the Chairman. Number 1. The Speaker decides whether a bill is money bill or not, and his decision on this question is final. Number 2. The Speaker presides over a joint sitting of two houses of Parliament. Unlike the Speaker, who is a member of House, the Chairman is not a member of House. But like the Speaker, the Chairman also cannot vote in the first instance. He too can cast a vote in the case of an inequality of votes. The Vice President cannot preside over a sitting of Rajya Sabha as its chairman when a resolution for his removal is under consideration. However, he can be present and speak in houses and can take part in its proceedings without voting, even at such a time while the speaker can vote in the first instance when a resolution for his removal is under consideration of the Lok Sabha. As in case of a speaker, the salaries and allowances of the chairman are also fixed by the parliament. They are charged on the consolidated fund of India and thus are not subject to the annual vote of parliament. During any period when the vice president acts as president or discharges the function of the president, he is not entitled to any salary and allowances payable to the chairman of the Rajya Sabha, but he is paid the salary and allowances of the president during such a time. Deputy Chairman of Rajya Sabha. The Deputy Chairman is elected by the Rajya Sabha itself from amongst its members. Whenever the office of Deputy Chairman falls vacant, the Rajya Sabha elects another members to fill the vacancy. The Deputy Chairman vacates his office in any of the following three cases. Number 1. If he ceases to be a member of Rajya Sabha. Number 2. If he resigns by writing to the chairman. Number 3. If he is removed by a resolution passed by a majority of all the then members of Rajya Sabha. Such a resolution can be moved only after giving 14-day advance notice. The deputy chairman performs the duties of the chairman's office when it is vacant or when the vice president acts as president or discharges the function of the president. He also acts as the chairman when the latter is absent from the sitting of the house. In both the cases, he has all the powers of the chairman. It should be emphasized here that the deputy chairman is not subordinate to the chairman. He is directly responsible to the Rajya Sabha. Like the chairman, the deputy chairman, while presiding over the house, cannot vote in the first instance. He can only exercise a casting vote in the case of a tie. Further, when a resolution for the removal of the deputy chairman is under consideration of the house, he cannot preside over a sitting of the house, though he may be present. When the chairman presides over the house, the deputy chairman is likely any other ordinary member of the house. He can speak in the house, participate in its proceedings, and vote on any question before the house. Like the chairman, the deputy chairman is also entitled to a regular salary and allowances. They are fixed by parliament and are charged on the consolidated fund of India. Panel of Vice Chairperson of Rajya Sabha. Under the rules of Rajya Sabha, the chairman nominates from amongst the members a panel of vice chairperson. Any one of them can preside over the house in the absence of the chairman or the deputy chairman. He has the same power as the chairman when so presiding. He holds office until a new panel of vice chairperson is nominated. When a member of the panel of vice chairperson is also not present, any other person as determined by the house act as the chairman. It must be emphasized here that a member of the panel of vice chairperson cannot preside over the house when the office of the chairman or the deputy chairman is vacant during such a time. The chairman's duties are to be performed by such member of the house as the president may appoint for the purpose. The elections are held as soon as possible to fill the vacant post. Secretariat of Parliament. Each House of Parliament has separate secretarial staff of its own, though there can be some posts common to both the houses. Their recruitment and services conditions are regulated by Parliament. The Secretariat of each house is headed by a Secretary General. He is a permanent officer and is appointed by the presiding officer of the House. Leaders in Parliament. Leader of the House. Under the rules of Lok Sabha, the leader of the House means the Prime Minister. If he is a member of Lok Sabha or a minister who is a member of Lok Sabha and is nominated by the Prime Minister to function as the leader of the House, there is also a leader of the House in the Rajya Sabha. He is a minister and a member of Rajya Sabha and is nominated by the Prime Minister to function as such. The leader of the House is either house is an important functionary and exercises direct influence on the conduct of business. He can also nominate a deputy leader of the House. The same functionary in USA is known as the majority leader. Leader of the Opposition. In each House of Parliament, there is the leader of opposition. The leader of the largest opposition party, having not less than 1/10 seats of the total strength of the House, is recognized as the leader of the opposition in that House. In a parliamentary system of government, the leader of the opposition has a significant role to play. His main function are to provide a constructive criticism of the policies of the government and to provide an alternative government. Therefore, the leader of opposition in the Lok Sabha and Rajya Sabha were accorded statutory recognition in 1977. They are also entitled to the salary, allowances, and other facilities equivalent to that of a cabinet minister. It was in 1969 that an official leader of the opposition was recognized for the first time. The same functionary in USA is known as the minority leader. The British political system has a unique institution called the shadow cabinet. It is formed by the opposition party to balance the ruling cabinet and to prepare its member for future ministerial offices. In this shadow cabinet, almost every member in the ruling cabinet is shadowed by a corresponding member in the opposition cabinet. This shadow cabinet serves as the alternate cabinet if there is change of government. That is why Ivor Jennings described the leader of opposition as the alternative prime minister. He enjoys the status of a minister and is paid by the government. Whip. Though the offices of the leader of house and the leader of the opposition are not mentioned in the Constitution of India, they are mentioned in the rules of the house and parliamentary status statute respectively. The office of whip, on the other hand, is mentioned neither in the Constitution of India nor in the rules of the house nor in the parliamentary statute. It is based on the conventions of the parliamentary government. Every political party, whether ruling or opposition, has its own whip in the parliament. He is appointed by the political party to serve as an assistant floor leader. He is charged with the responsibility of ensuring the attendance of his party members in large numbers and securing their support in favor of or against a particular issue. He regulates and monitors their behavior in the parliament. The members are supposed to follow the directives given by the whip, otherwise disciplinary action can be taken. Sessions of Parliament. Summoning. The President from time to time summons each House of Parliament to meet, but the maximum gap between two sessions of Parliament cannot be more than 6 months. In other words, the Parliament should meet at least twice a year. There are usually 3 sessions in a year, that is, number 1, the budget session, February to May, number 2, the monsoon session, July to September, number 3, the winter session, November to December. A session of Parliament is the period spanning between the first sitting of a House and its prorogation or dissolution in the case of the Lok Sabha. During a session, the House meets every day to transact business. The period spanning between the prorogation of a House and its reassembly in a new session is called recess. Adjournment. A session of Parliament consists of many meetings. Each meeting of a day consists of 2 sittings, that is, a morning sitting from 11 am to 1 pm and post-lunch sitting from 2 pm to 6 pm. A sitting of Parliament can be terminated by adjournment or adjournment sine die or prorogation or dissolution in the case of Lok Sabha. An adjournment suspends the work in a sitting for a specified time, which may be hours, days, or weeks. Adjournment sine die. Adjournment sine die means terminating a sitting of Parliament for an indefinite period. In other words, when the House is adjourned without naming a day for reassembly, it is called adjournment sine die. The power of adjournment as well as adjournment sine die lies with the presiding officer of the House. He can also call a sitting of the House before the date or time to which it has been adjourned or at any time after the House has been adjourned sine die. Prorogation. The presiding officer, speaker or chairman declares the House adjourned sine die when the business of a session is completed. Within the next few days, the president issues a notification for prorogation of the session. However, the president can also prorogue the House while in session. Dissolution. Rajya Sabha, being a permanent house, is not subject to dissolution. Only the Lok Sabha is subject to dissolution. Unlike a prorogation, a dissolution ends the very life of the existing house and a new house is constituted after general elections are held. The dissolution of the Lok Sabha may take place in either of 2 ways. Number 1, automatic dissolution, that is, on the expiry of its tenure of 5 years or the terms as extended during a national emergency, or Number 2, whenever the president decides to dissolve the house, which he is authorized to do, once the Lok Sabha is dissolved before the completion of its normal tenure, the dissolution is irrevocable. When the Lok Sabha is dissolved, all business including bills, motions, resolutions, notices, petitions and so on pending before it or its committee lapse. They, to be pursued further, must be reintroduced in the newly constituted Lok Sabha. However, some pending bills and all pending assurances that are to be examined by the Committee on Government Assurances do not lapse on the dissolution of the Lok Sabha. The position with respect to lapsing of bills is as follows. Number 1. A bill pending in the Lok Sabha lapses whether originating in the Lok Sabha or transmitted to it by the Rajya Sabha. Number 2. A bill passed by the Lok Sabha but pending in the Rajya Sabha lapses. Number 3. A bill not passed by the two houses due to disagreement, and if the President has notified the holding of a joint sitting before the dissolution of Lok Sabha, does not lapse. Number 4. A bill pending in the Rajya Sabha but not passed by the Lok Sabha does not lapse. Number 5. A bill passed by both houses but pending assent of the President does not lapse. Number 6. A bill passed by both houses but returned by the President for reconsideration of houses does not lapse. Adjournment versus prorogation. Number 1. Adjournment only terminates a sitting and not a session of the House, while prorogation not only terminates a sitting but also a session of the House. Number 2. Adjournment is done by presiding officer of the House, while prorogation is done by the President of India. Number 3. Adjournment does not affect the bills or any other business pending before the House, and the same can be resumed when the House meets again, while prorogation also does not affect the bills or any other business pending before the House. However, all pending notices other than those for introducing bills lapse on prorogation, and fresh notices have to be given for the next session. In Britain, prorogation brings to an end all bills or any other businesses pending before the House. Quorum. Quorum is the minimum number of members required to be present in the House before it can transact any business. It is 1/10 of the total number of members in each House, including the presiding officer. It means that there must be at least 55 members present in the Lok Sabha and 25 members present in the Rajya Sabha if any business is to be conducted. If there is no quorum during a meeting of the House, it is the duty of the presiding officer either to adjourn the House or to suspend the meeting until there is a quorum. Voting in House. All matters at any sitting of either House or joint sitting of both the Houses are decided by a majority of votes of the members present and voting, excluding the presiding officer. Only a few matters which are specifically mentioned in the Constitution, like impeachment of the President, amendment of the Constitution, removal of the presiding officers of the Parliament, and so on, require a special majority, not ordinary majority. The presiding officer of a House does not vote in the first instance but exercises a casting vote in the case of an equality of votes. The proceedings of a House are to be valid irrespective of any unauthorized voting or participation or any vacancy in its membership. The following points can be noted with respect to the voting procedure in the Lok Sabha. Number 1. On the conclusion of a debate, the Speaker shall put the question and invite those who are in favor of the motion to say aye and those against the motion to say no. Number 2. The Speaker shall then say, I think the ayes or the noes, as the case may be, have it if the opinion of the Speaker as to the decision of a question is not challenged. He shall say twice, the ayes or the noes, as the case may be, have it, and the question before the House shall be determined accordingly. Number 3. If the opinion of the Speaker as to the decision of a question is challenged, he shall order that the lobby be cleared. After the lapse of 3 minutes and 30 seconds, he shall put the question a second time and declare whether, in his opinion, the ayes or the noes have it. If the opinion so declared is again challenged, he shall direct that the votes be recorded either by operating the automatic vote recorder or by using aye and no slips in the House or by the members going into the lobbies. Number 4. If, in the opinion of the Speaker, the division is unnecessarily claimed, he may ask the members who are for aye and those for no, respectively, to rise in their places and, on account being taken, he may declare the determination of the House. In such a case, the names of the voters shall not be recorded. Language in Parliament. The Constitution has declared Hindi and English to be the language for transacting business in the Parliament. However, the presiding officer can permit a member to address the House in his mother tongue. In both the Houses, arrangements are made for simultaneous translation, though English was to be discontinued as a floor language after the expiration of 15 years from the commencement of the Constitution, that is, in 1965. The Official Languages Act 1963 allowed English to be continued along with Hindi. Rights of Ministers and Attorney General. In addition to the members of a House, every minister and the Attorney General of India have the right to speak and take part in the proceedings of either House, any joint sitting of both the Houses, and any committee of Parliament of which he is a member, without being entitled to vote. There are two reasons underlying this constitutional provision. Number 1. A minister can participate in the proceedings of a House of which he is not a member. In other words, a minister belonging to the Lok Sabha can participate in the proceedings of the Rajya Sabha and vice versa. Number 2. A minister who is not a member of either house can participate in the proceedings of both the houses. It should be noted here that a person can remain a minister for 6 months without being a member of either house of parliament. Lame duck session. It refers to the last session of the existing Lok Sabha after a new Lok Sabha has been elected. Those members of the existing Lok Sabha who could not get re-elected to the new Lok Sabha are called lame ducks. Devices of parliamentary proceedings. Question hour. The first hour of every parliamentary sitting is slotted for this. During this time, the members ask questions and the ministers usually give answers. The questions are of three kinds, namely start, unstart, and short notice. A start question, distinguished by an asterisk, requires an oral answer and hence supplementary question can follow. An unstart question, on the other hand, requires a written answer and hence supplementary questions cannot follow. A short notice question is one that is asked by giving a notice of less than 10 days. It is answered orally. In addition to the ministers, the questions can also be asked to the private members. Thus, a question may be addressed to a private member if the subject matter of the question relates to some bill, resolution, or other matter connected with the business of the House for which that member is responsible. The procedure in regard to such question is the same as that followed in the case of questions addressed to a minister. The list of start, unstart, short notice questions and questions to private members are printed in green, white, light pink and yellow color respectively to distinguish them from one another. 0 hour. Unlike the question hour, the 0 hour is not mentioned in the rules of procedure. Thus, it is an informal device available to the members of the parliament to raise matters without any prior notice. The 0 hour starts immediately after the question hour and lasts until the agenda for the day, that is, regular business of the House, is taken up. In other words, the time gap between the question hour and the agenda is known as 0 hour. It is an Indian innovation in the field of parliamentary procedures and has been in existence since 1962. Motions. No discussion on a matter of general public importance can take place except on a motion made with the consent of the presiding officer. The House expresses its decisions or opinions on various issues through the adoption or rejection of motions moved by either ministers or private members. The motions moved by the members to raise discussions on various matters fall into three principal categories. Number 1, substantive motion. It is a self contained, independent proposal dealing with a very important matter like impeachment of the president or removal of chief election commissioner. Number 2, substitute motion. It is a motion that is moved in substitution of an original motion and proposes an alternative to it. If adopted by the House, it supersedes the original motion. Number 3, subsidiary motion. It is a motion that by itself has no meaning and cannot state the decision of the House without reference to the original motion or proceedings of the House. It is divided into three subcategories. Number 1, ancillary motion. It is used as the regular way of proceeding with various kinds of business. Number 2, superseding motion. It is moved in the course of debate on another issues and seeks to supersede that issue. Number 3, amendment. It seeks to modify or substitute only a part of the original motion. Closer motion. It is a motion moved by a member to cut short the debate on a matter before the House. If the motion is approved by the House, debate is stopped forthwith and the matter is put to vote. There are four kinds of closer motions. Simple closure. It is one when a member moves that the matter having been sufficiently discussed be now put to vote. Closer by compartments. In this case, the clauses of a bill or a lengthy resolution are grouped into parts before the commencement of the debate. The debate covers the part as a whole and the entire part is put to vote. Kangaroo closer. Under this type, only important clauses are taken up for debate and voting and the intervening clauses are skipped over and taken as passed. Guillotine closer. It is one when the undiscussed clauses of a bill or a resolution are also put in vote along with the discussed one due to want of time as the time allotted for the discussion is over. Privilege motion. It is concerned with the breach of parliamentary privileges by a minister. It is moved by a member when he feels that a minister has committed a breach of privilege of the House or one or more of its members by withdrawing fact of a case or by giving wrong or distorted fact. Its purpose is to censure the concerned minister. Calling attention motion. It is introduced in the parliament by a member to call the attention of a minister to a matter of urgent public importance and to seek an authoritative statement from him on that matter. Like the zero hour, it is also an Indian innovation in the parliamentary procedure and has been in existence since 1954. However, unlike the zero hour, it is mentioned in the rules of procedure. Adjournment motion. It is introduced in the parliament to draw attention of the House to a definite matter of urgent public importance and needs the support of 50 members to be admitted. As it interrupts the normal business of the House, it is regarded as an extraordinary device. It involves an element of censure against the government and hence Rajya Sabha is not permitted to make use of this device. The discussion on an adjournment motion should last for not less than 2 hours and 30 minutes. The right to move a motion for an adjournment of the business of the House is subject to the following restrictions. Number 1, it should raise a matter which is definite, factual, urgent, and of public importance. Number 2, it should not cover more than one matter. Number 3, it should be restricted to a specific matter of recent occurrence and should not be framed in general terms. Number 4, it should not raise a question of privilege. Number 5, it should not revive discussion on a matter that has been discussed in the same session. Number 6, it should not deal with any matter that is under adjudication by court. Number 7, it should not raise any question that can be raised on a distinct motion. No confidence motion. Article 75 of the Constitution says that the Council of Ministers shall be collectively responsible to the Lok Sabha. It means that the ministry stays in office so long as it enjoys confidence of the majority of the members of the Lok Sabha. In other words, the Lok Sabha can remove the ministry from office by passing a no confidence motion. The motion needs the support of 50 members to be admitted. Confidence motion. The motion of confidence has come up as a new procedural device to cope with the emerging situations of fractured mandates resulting in hung parliament, minority governments, and coalition governments. The governments formed with wafer thin majority have been called upon by the president to prove their majority on the floor of the house. The government of the day, sometimes on its own, seeks to prove its majority by moving a motion of confidence and winning the confidence of the house. If the confidence motion is negative, it results in the fall of the government. Censor motion. A censure motion is different from a no confidence motion. Motion of thanks. The first session after each general election and the first session of every fiscal year is addressed by the President. In this address, the President outlines the policies and programs of the government in the preceding year and ensuing year. This address of the President, which corresponds to the speech from the throne in Britain, is discussed in both the Houses of Parliament on a motion called the motion of thanks. At the end of the discussion, the motion is put to vote. This motion must be passed in the House, otherwise it amounts to the defeat of the government. This inaugural speech of the President is an occasion available to the members of Parliament to raise discussion and debates, to examine and criticize the government and administration for its lapses and failures. No day yet named motion. It is a motion that has been admitted by the Speaker, but no date has been fixed for its discussion. The Speaker, after considering the state of business in the House and in consultation with the state of business, in the consultation with the leader of the House or on the recommendation of the Business Advisory Committee, allots a day or days or part of a day for the discussion of such a motion. Dilatory motion. It is a motion for the adjournment of the debate on a bill, motion, resolution, etc., or a motion to retard or delay the progress of business under consideration of the House. It can be moved by a member at any time after a motion has been made. The debate on a dilatory motion must be restricted to the matter contained in such motion. If the Speaker is of the opinion that such a motion is an abuse of the rules of the House, he may either forthwith put the question thereon or decline to propose the question. Point of order. A member can raise a point of order when the proceedings of the House do not follow the normal rules of procedure. A point of order should relate to the interpretation or enforcement of the rules of the House or such articles of the Constitution that regulate the business of the House and should raise a question that is within a cognizance of the Speaker. It is usually raised by an opposition member in order to control the government. It is an extraordinary device as it suspends the proceedings before the House. No debate is allowed on a point of order. Censure motion versus no confidence motion. Number 1. Censure motion should state the reason for its adoption in the Lok Sabha, while no confidence motion need not state the reasons for its adoption in the Lok Sabha. Number 2. Censure motion can be moved against an individual minister or a group of ministers or the entire council of ministers, while no confidence motion moved against the entire council of ministers only. Number 3. Censure motion is moved for censoring the Council of Ministers for specific policies and actions, while no confidence motion is moved for ascertaining the confidence of Lok Sabha in the Council of Ministers. Number 4. Censure motion is passed in the Lok Sabha. The Council of Ministers need not resign from the office, while no confidence motion, if it is passed in the Lok Sabha, the Council of Ministers must resign from the office. Half an hour discussion. It is meant for discussing a matter of sufficient public importance which has been subjected to a lot of debate and the answer to which needs elucidation on a matter of fact. The Speaker can allot 3 days in a week for such discussion. There is no formal motion or voting before the House. Short duration discussion. It is also known as 2-hour discussion, as the time allotted for such a discussion should not exceed 2 hours. The members of the Parliament can raise such discussions on a matter of urgent public importance. The Speaker can allot 2 days in a week for such discussions. There is neither a formal motion before the House nor voting. This device has been in existence since 1953. Special motion mention a matter which is not a point of order or which cannot be raised during question hour, half an hour discussion, short duration discussion, or under adjournment motion, calling attention notice, or under any rule of the House can be raised under the special mention in the Rajya Sabha. Its equivalent procedural device in the Lok Sabha is known as notice mentioned under Rules 377. Resolutions. The members can move resolutions to draw the attention of the House or the government to matters of general public interest. The discussion on a resolution is strictly relevant to and within the scope of the resolution. A member who has moved a resolution or amendment to a resolution cannot withdraw the same except by leave of the House. Resolutions are classified into three categories. Number 1. Private members' resolution. It is one that is moved by a private member other than a minister. It is discussed only on alternate Fridays and in the afternoon sittings. Number 2. Government resolution. It is one that is moved by a minister. It can be taken up any day from Monday to Thursday. Number 3. Statutory resolution. It can be moved either by a private member or a minister. It is so called because it is always tabled in pursuance of a provision in the Constitution or an Act of Parliament. Resolutions are different from motions in the following respect. All resolutions come in the category of substantive motions. That is to say, every resolution is a particular type of motion. All motions need not necessarily be substantive. Further, all motions are not necessarily put to vote of the House, whereas all the resolutions are required to be voted upon. Youth Parliament. The schemes of Youth Parliament was started on the recommendation of the 4th All India Whips Conference. Its objectives are: number 1. To acquaint the younger generations with practices and procedures of Parliament. Number 2. To imbibe the spirit of discipline and tolerance cultivating character in the minds of youth. Number 3. To inculcate in the student community the basic values of democracy and to enable them to acquire a proper perspective on the functioning of democratic institutions. The Ministry of Parliamentary Affairs provides necessary training and encouragement to the states in introducing the scheme. Legislative procedure in Parliament. The legislative procedure is identical in both the houses of Parliament. Every bill has to pass through the same stages in each house. A bill is a proposal for legislation and it becomes an act or law when duly enacted. Bills introduced in the Parliament are of two kinds: public bills and private bills, also known as government bills and private members' bill, respectively. Though both are governed by the same general procedure and pass through the same stages in the House, they differ in various respects. The bill introduced in the Parliament can also be classified into four categories. Number 1. Ordinary bill, which are concerned with any matter other than financial subjects. Number 2. Money bill, which are concerned with the financial matters like taxation, public expenditure, etc. Number 3. Financial bills, which are also concerned with financial matters but are different from money bills. Number 4. Constitution amendment bills, which are concerned with the amendment of the provisions of the Constitution. The Constitution has laid down separate procedures for the enactment of all the four types of bills. The procedures with regard to ordinary bills, money bills, and financial bills are explained here. The procedure with regard to the Constitution Amendment Bill is explained further. Ordinary bills. Every ordinary bill has to pass through the following 5 stages in the Parliament before it finds a place on the statute book. Number 1. First reading. An ordinary bill can be introduced in either House of Parliament. Such a bill can be introduced either by a minister or by any other member. The member who wants to introduce the bill has to ask for the leave of the House. When the House grants leave to introduce the bill, the mover of the bill introduces it by reading its title and objectives. No discussion on the bill takes place at this stage. Later, the bill is published in the Gazette of India. If a bill is published in the Gazette before its introduction, leave of the House to introduce the bill is not necessary. The introduction of the bill and its publication in the Gazette constitute the first reading of the bill. Public will versus private will. Number 1. Public bill is introduced in the parliament by a minister, while a private member bill is introduced by any member of parliament other than a minister. Number 2. Public bill reflects of the policies of the government ruling party, while private bill reflects the stand of opposition party on public matter. Number 3. Public bill has greater chance to be approved by the parliament, while private bill has lesser chance to be approved by the parliament. Number 4. Public bill rejection by the House amounts to the expression of wants of parliamentary confidence in the government and may lead to its resignation, while rejection of private bill by the House has no implication on the parliamentary confidence in the government or its resignation. Number 5. Public bill Public bill's introduction in the House requires 7 days notice, while introduction in the House of private member bill requires 1 month's notice. Number 6. Public bill is drafted by the concerned department in the consultation with the law department, while private member bill is drafted by the responsibility of the member concerned. Number 2. Second reading of ordinary bill. During this stage, the bill receives not only the general but also the detailed scrutiny and assumes its final shape. Hence, it forms the most important stage in the enactment of a bill. In fact, this stage involves three more sub-stages, namely stage of general discussion, committee stage, and consideration stage. Stage of general discussion. The printed copies of the bill are distributed to all the members. The principles of the bill and its provisions are discussed generally, but the details of the bill are not discussed. At this stage, the House can take any one of the following four actions. Number 1. It may take the bill into consideration immediately or on some other fixed date. Number 2. It may refer the bill to a select committee of the House. Number 3. It may refer the bill to a joint committee of the two houses. Number 4. It may circulate the bill to elicit public opinion. A select committee consists of members of the House where the bill has originated, and a joint committee consists of members of both the houses of parliament. Committee stage. The usual practice is to refer the bill to a select committee of the House. This committee examines the bill thoroughly and in detail, clause by clause. It can also amend its provisions but without altering the principle underlying it. After completing the scrutiny and discussion, the committee reports the bill back to the House. Consideration stage. The House, after receiving the bill from the Select Committee, considers the provisions of the bill clause by clause. Each clause is discussed and voted upon separately. The members can also move amendments and, if accepted, they become part of the bill. Number 3. Third reading. At this stage, the debate is confined to the acceptance or rejection of the bill as a whole, and no amendments are allowed, as the general principles underlying the bill have already been scrutinized during the stage of second reading. If the majority of members present and voting accept the bill is regarded as passed by the House. Therefore, the bill is authenticated by the presiding officer of the House and transmitted to the second House for consideration and approval. A bill is deemed to have been passed by the Parliament only when both the Houses have agreed to it, either with or without amendments. Number 4. Bill in the second House. In the second House also, the bill passes through all the three stages, that is first reading, second reading and third reading. There are four alternatives before this House. Number 1. It may pass the bill as sent by the first House, that is without amendments. Number 2. It may pass the bill with amendments and return it to the first House for reconsideration. Number 3. It may reject the bill altogether. Number 4. It may not take any action and thus keep the bill pending. If the second House passes the bill without any amendments, or the first House accepts the amendments suggested by the second House, the bill is deemed to have been passed by both the Houses and the same is sent to the President for his assent. On the other hand, if the first House rejects the amendments suggested by the second House, or the second House rejects the bill altogether, or the second House does not take any action for 6 months, deadlock is deemed to have taken place. To resolve such a deadlock, the President can summon a joint sitting of the two houses. If the majority of the members present and voting in the joint sitting approves the bill is deemed to have been passed by both the houses. Number 5. Assent of the President. Every bill, after being passed by both the houses of Parliament, either singly or at a joint sitting, is presented to the President for his assent. There are three alternatives before the President. Number 1, he may give his assent to the bill. Number 2, he may withhold his assent to the bill. Number 3, he may return the bill for reconsideration of the House. If the President gives his assent to the bill become an act and is placed on the statute book. If the President withholds his assent to the bill, it ends and does not become an act. If the President returns the bill for reconsideration and if it is passed by both the houses, again with or without amendments, and presented to the President for his assent, the President must give his assent to the bill. Thus, the President enjoys only a suspensive veto. Money bills. Article 110 of the Constitution deals with the definition of money bills. It states that a bill is deemed to be a money bill if it contains only provisions dealing with all or any of the following matters. Number 1. The imposition, abolition, remission, alteration, or regulation of any tax. Number 2. The regulation of the borrowing of money by the Union Government. Number 3. The custody of the Consolidated Fund of India or the Contingency Fund of India, the payment of monies into or withdrawal of money from any such fund. Number 4. The appropriation of money out of the Consolidated Fund of India. Number 5. Declaration of any expenditure charged on the Consolidated Fund of India or increasing the amount of any such expenditure. Number 6. The receipt of money on account of the Consolidated Fund of India or the Public Account of India or the custody or issue of such money or the audit of the accounts of the Union or of a state. Number 7. Any matter incidental to any of the matters specified above. However, a bill is not to be deemed to be a money bill by reasons only that it provides for: Number 1. The imposition of fines or any other pecuniary penalties. Number 2. The demand or payment of fees for licenses or fees for service rendered. Number 3. The imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body for local purpose. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the Lok Sabha is final. His decision in this regard cannot be questioned in any court of law or in either House of Parliament or even the President. When a money bill is transmitted to the Rajya Sabha for recommendation and present through the President for assent, the Speaker endorses it as a money bill. The Constitution lays down a special procedure for the passing of money bills in the Parliament. A money bill can only be introduced in the Lok Sabha, and that too on the recommendation of the President. Every such bill is considered to be a government bill and can be introduced only by a minister. After a money bill is passed by the Lok Sabha, it is transmitted to the Rajya Sabha for its consideration. The Rajya Sabha has restricted powers with regard to a money bill. It cannot reject or amend a money bill. It can only make the recommendations. It must return the bill to the Lok Sabha within 14 days, whether with or without recommendations. The Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. If the Lok Sabha accept any recommendation, the bill is then deemed to have been passed by both the houses in the modified form. If the Lok Sabha does not accept any recommendation, the bill is then deemed to have passed by both the houses in the form originally passed by the Lok Sabha without any change. If the Rajya Sabha does not return the bill to the Lok Sabha within 14 days, the bill is deemed to have been passed by both the houses in the form originally passed by the Lok Sabha. Thus, the Lok Sabha has more powers than Rajya Sabha with regard to a money bill. On the other hand, both the houses have equal powers with regard to an ordinary bill. Finally, when a money bill is presented to the President, he may either give his assent to the bill or withhold his assent to the bill, but cannot return the bill for reconsideration of the houses. Normally, the President gives his assent to a money bill as it is introduced in the Parliament with his prior permission. Financial bills. Financial bills are those bills that deal with fiscal matters, that is, revenue or expenditure. However, the Constitution uses the term financial bill in a technical sense. Financial bills are of three kinds: Money Bill, Article 110, Financial Bill 1, Article 117, Clause 1, Financial Bills 2, Article 117, Clause 3. This classification implies that money bills are simply a species of financial bills. Hence, all money bills are financial bills, but all financial bills are not money bills. Only those financial bills are money bills which contain exclusively those matters which are mentioned in Article 110 of the Constitution. These are also certified by the Speaker of the Lok Sabha as money bills. The financial bills, first and second, on the other hand, have been dealt with in Article 117 of the Constitution. Ordinary bill versus money bill. Number 1. Ordinary bill can be introduced either in the Lok Sabha or the Rajya Sabha, while money bill can be introduced only in the Lok Sabha and not in the Rajya Sabha. Number 2. Ordinary bill can be introduced either by a minister or by a private member, while money bill can be introduced only by a minister. Number 3. Ordinary bill is introduced without the recommendation of the president, while money bill can be introduced only on the recommendation of the president. Number 4. Ordinary bill can be amended or rejected by the Rajya Sabha, while money bill cannot be amended or rejected by the Rajya Sabha. The Rajya Sabha should return the bill with or without recommendations, which may be accepted or rejected by the Lok Sabha. Number 5. Ordinary bills can be detained by the Rajya Sabha for a maximum period of 6 months, while money bill can be detained by the Rajya Sabha for a maximum period of 14 days only. Number 6. Ordinary bill does not require the certification of the Speaker, while money bill requires the certification of the Speaker when transmitted to the Rajya Sabha. Number 7. Ordinary bill is sent for the President assent only after being approved by both the houses. In case of a deadlock due to disagreement between the two houses, a joint sitting of both the houses can be summoned by the President to resolve the deadlock, while money bill is sent for the President assent even if it is approved by only Lok Sabha. There is no chance of any disagreement between the two houses, and hence there is no provision of joint sitting of both the houses in this regard. Number 8. Ordinary bill defeat in the Lok Sabha may lead to the resignation of the government if it is introduced by a minister, while money bill's defeat in the Lok Sabha leads to the resignation of the government. Number 9. Ordinary bill can be rejected, approved or returned for reconsideration by the President, while money bill can be rejected or approved but cannot be returned for reconsideration by the President. Financial bills first. A financial bill first is a bill that contains not only any or all the matters mentioned in Article 110 but also other matters of general legislation. For instance, a bill that contains a borrowing clause but does not exclusively deal with borrowing. In two respects, a financial bill 1 is similar to a money bill. Both of them can be introduced only in the Lok Sabha and not in Rajya Sabha. Both of them can be introduced only in the recommendation of the President. In all other respect, a financial bill first is governed by the same legislative procedure applicable to an ordinary bill. Hence, it can be either rejected or amended by the Rajya Sabha, except that an amendment other than for reduction or abolition of a tax cannot be moved in either house without the recommendation of the President. That is, the recommendation of the President is not required for moving an amendment making provision for the reduction or abolition of a tax. In case of a disagreement between the two houses over such a bill, the President can summon a joint sitting of the two houses to resolve the deadlock. When the bill is presented to the President, he can either give his assent to the bill or withhold his assent to the bill or return the bill for reconsideration of the House. Financial Bill 2. A Financial Bill 2 contains provisions involving expenditure from the Consolidated Fund of India but does not include any of the matters mentioned in Article 110. It is treated as an ordinary bill and in all respect it is governed by the same legislative procedure which is applicable to an ordinary bill. The only special feature of this bill is that it cannot be passed by either House of Parliament unless the President has recommended to that House the consideration of the bill. Hence, Financial Bill second can be introduced in either House of Parliament and recommendation of the President is not necessary for its introduction. In other words, the recommendation of the President is not required at the introduction stage but is required at the consideration stage. It can be either rejected or amended by either House of Parliament. In case of a disagreement between the two houses over such a bill, the President can summon a joint sitting of two houses to resolve the deadlock. When the bill is presented to the President, he can either give his assent to the bill or withhold his assent to the bill or return the bill for reconsideration of the houses. Joint sitting of two houses. Joint sitting is an extraordinary machinery provided by the Constitution to resolve a deadlock between the two houses over the passage of a bill. A deadlock is deemed to have taken place under any one of the following three situations after a bill has been passed by one house and transmitted to the other house. Number 1. If the bill is rejected by the other house. Number 2. If the houses have finally disagreed as to the amendments to be made in the bill. Number 3. If more than 6 months have elapsed from the date of the receipt of the bill by the other house without the bill being passed by it. In the above three situations, the President can summon both the houses to meet it in a joint sitting for the purpose of deliberating and voting on the bill. It must be noted here that the provision of joint sitting is applicable to ordinary bills or financial bills only and not to money bills or constitutional amendment bills. In the case of a money bill, the Lok Sabha has overriding powers while a constitutional amendment bill must be passed by each house separately. In reckoning the period of 6 months, no account can be taken of any period during which the other house to which the bill has been sent is prorogued or adjourned for more than 4 consecutive days. If the bill under dispute has already lapsed due to the dissolution of Lok Sabha, no joint sitting can be summoned, but the joint sitting can be held if the Lok Sabha is dissolved after the President has notified his intention to summon such a sitting as the bill does not lapse in this case. After the President notifies his intention to summon a joint sitting of the two houses, none of the houses can proceed further with the bill. The Speaker of Lok Sabha presides over a joint sitting of the two houses and the Deputy Speaker in his absence. If the Deputy Speaker is also absent from a joint sitting, the Deputy Chairman of Rajya Sabha presides. If he is also absent, such other person as may be determined by the members present at the joint sitting presides over the meeting. It is clear that the Chairman of Rajya Sabha does not preside over a joint sitting as he is not a member of either House of Parliament. The quorum is to constitute a joint sitting is 1/10 of the total number of members of the two houses. The joint sitting is governed by the rules of procedure of Lok Sabha and not of Rajya Sabha. If the bill in dispute is passed by a majority of the total number of members by both the houses present and voting in the joint sitting, the bill is deemed to have been passed by both the houses. Normally, the Lok Sabha with greater number wins a battle in a joint sitting. The Constitution has specified that at a joint sitting, new amendments to the bill cannot be proposed except in two cases. Number 1. Those amendments that have caused final disagreement between the two houses. Number 2. Those amendments that might have become necessary due to the delay in the passage of the bill. Since 1950, the provision regarding the joint sitting of the two houses has been invoked only thrice. The bills that have been passed at joint sittings are: Number 1. Dowry Prohibition Bill 1960. Number 2. Banking Service Commission Repeal Bill 1977. Number 3. Prevention of Terrorism Bill 2022. Budget in Parliament. The Constitution refers to the budget as the annual financial statement. In other words, the term budget has nowhere been used in the Constitution. It is the popular name for the annual financial statement that has been dealt with in Article 112 of the Constitution. The budget is a statement of the estimated receipt and expenditure of the Government of India in a financial year which begins on 1st April and ends on 31st March of the following year. In addition to the estimates of receipts and expenditure, the budget contains certain other elements Overall, the budget contains the following. Number 1. Estimates of revenue and capital receipt. Number 2. Ways and means to raise the revenue. Number 3. Estimates of expenditure. Number 4. Details of the actual receipt and expenditure of the closing financial year and the reasons for any deficit or surplus in that year. Number 5. Economic and financial policy of the coming year, that is, taxation proposals, prospect of revenue, spending program, and introduction of new schemes projects. Till 2017, the Government of India had two budgets, namely the railway budget and the general budget. While the former consisted of the estimates of receipt and expenditure of only the Ministry of Railways, the latter consisted of the estimate of receipt and expenditure of all the ministries of the Government of India except the railways. The railway budget was separated from the general budget in 1924 on the recommendations of the Ackworth Committee Report 1921. The reasons or objectives of this separation were as follows. Number 1. To introduce flexibility in railway finance. Number 2. To facilitate a business approach to the railway policy. Number 3. To secure stability of the general revenues by providing an assured annual contribution from railway revenues. Number 4. To enable the railways to keep their profits for their own development after paying a fixed annual contribution to the general revenues. In 2017, the central government merged the railway budget into the general budget. Hence, there is now only one budget for the Government of India, that is Union Budget. Constitutional provisions. The Constitution of India contains the following provisions with regard to the enactment of budget. Number 1. The President shall, in respect of every financial year, causes to be laid before both the Houses of Parliament a statement of estimated receipt and expenditure of the Government of India for that year. Number 2. No demand for a grant shall be made except on the recommendation of the President. Number 3. No money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law. Number 4. No money bill imposing tax shall be introduced in the Parliament except on the recommendation of the President, and such a bill shall not be introduced in the Rajya Sabha. Number 5. No tax shall be levied or collected except by authority of law. Number 6. Parliament can reduce or abolish a tax but cannot increase it. Number 7. The Constitution has also defined the relative roles or position of both the Houses of Parliament with regard to the enactment of the budget in the following way. A money bill or finance bill dealing with taxation cannot be introduced in the Rajya Sabha. It must be introduced only in the Lok Sabha. B. The Rajya Sabha has no power to vote on the demand for grants. It is the exclusive privilege of the Lok Sabha. C. The Rajya Sabha should return the money bill or finance bill to the Lok Sabha within 14 days. The Lok Sabha can either accept or reject the recommendation made by Rajya Sabha in this regard. Number 8. The estimates of expenditure embodied in the budget shall show separately the expenditure charged on the Consolidated Fund of India and the expenditure made from the Consolidated Fund of India. Number 9. The budget shall distinguish expenditure on revenue account from their expenditure. Number 10. The expenditure charged on the Consolidated Fund of India shall not be submitted to the vote of Parliament. However, it can be discussed by the Parliament. Charged expenditure. The budget consists of two types of expenditure: the expenditure charged upon the Consolidated Fund of India and the expenditure made from the Consolidated Fund of India. The charged expenditure is non-votable by the Parliament, that is, it can only be discussed by the Parliament, while the other type has to be voted by the Parliament. The list of the charged expenditure is as follows. Number 1. Emoluments and allowances of the President and other expenditure relating to his office. Number 2. Salaries and allowances of the Chairman and the Deputy Chairman of the Rajya Sabha and the Speaker and the Deputy Speaker of the Lok Sabha. Number 3. Salaries, allowances and pensions of the judges of the Supreme Court. Number 4. Pensions of the judges of High Court. Number 5. Salary, allowances and pension of the Comptroller and Auditor General of India. Number 6. Salaries, allowances and pension of the chairman and members of the Union Public Service Commission. Number 7. Administrative expenses of the Supreme Court, the Office of the Comptroller and Auditor General of India, and the Union Public Service Commission, including the salaries, allowances, and pensions of the persons serving in these offices. Number 8. The debt charges for which the Government of India is liable, including interest, sinking, fund charges, and redemption charges, and other expenditure relating to the raising of loans and the service and redemption of debt. Number 9. Any sum required to satisfy any judgment, decree, or award of any court or arbitral tribunal. Number 10. Any other expenditure declared by the Parliament to be so charged. Stages of enactment. The budget goes through the following 6 stages in the Parliament. Number 1. Presentation of budget. Number 2. General discussion. Number 3. Scrutiny by departmental committee. Number 4. Voting on demands for grants. Number 5. Passing of appropriation bill. Number 6. Passing of finance bill. Number 1. Presentation of budget. Conventionally, the budget is presented to the Lok Sabha by the Finance Minister on the last working day of February. Since 2017, the presentation of the budget has been advanced to 1st of February. The budget can also be presented to the House in 2 or more parts, and when such presentation take place, each part shall be dealt with as if it were the budget. Further, there shall be no discussion of the budget on the day on which it is presented to the House. The Finance Minister presents the budget with a speech known as the budget speech. At the end of the speech in the Lok Sabha, the budget is laid before the Rajya Sabha, which can only discuss it and has no power to vote on the demands for grants. The budget documents presented to the Parliament comprise of the following. Number 1. Budget speech. Number 2. Annual financial statement. Number 3. Demand for grants. Number 4. Appropriation bill. Number 5. Finance bill. Number 6. Statements mandated under the FRBM Act include macroeconomic framework statement, fiscal policy strategy statement, and medium term fiscal policy statement. Number 7. Expenditure budget. Number 8. Receipt budget. Number 9. Expenditure profile. Number 10. Memorandum explaining the provisions in the finance bill. Number 11. Budget at a glance. Number 12. Outcome budget. Earlier, the economic survey also used to be presented to the Parliament along with the budget. Now it is presented one day or a few days before the presentation of the budget. This report is prepared by the Finance Ministry and indicates the status of the national economy. Number 2. General discussion. The general discussion on budget begins a few days after its presentation. It takes place in both the Houses of Parliament and lasts until usually for 3 to 4 days. During this stage, the Lok Sabha can discuss the budget as a whole or on any question of principle involved therein, but no cut motion can be moved, nor can the budget be submitted to the vote of the House. The Finance Minister has a general right of reply at the end of the discussion. Number 3. Scrutiny by departmental committee. After the general discussion on the budget is over, the houses are adjourned for about 3 to 4 weeks. During this gap period, the 24 departmental standing committee of the Parliament examine and discuss in detail the demands for grants of the concerned ministers and prepare reports on them. These reports are submitted to both the Houses of Parliament and consideration. The standing committee system, established in 1993 and expanded in 2004, makes parliamentary financial control over ministries much more detailed, close, in-depth, and comprehensive. Number 4. Voting on demands for grants. In the light of the reports of the Departmental Standing Committee, the Lok Sabha takes up voting of demands for grants. The demands are presented ministry-wise. A demand becomes a grant before it has been duly voted. 2 points should be noted in this context. 1. The voting of demands for grants in the exclusive privileges of the Lok Sabha, that is, the Rajya Sabha has no power of voting the demands. Second, the voting is confined to the votable part of the budget. The expenditure charged on the Consolidated Fund of India is not submitted to the vote, it can only be discussed. Each demand is voted separately by the Lok Sabha. During this stage, the members of Parliament can discuss the details of the budget. They can also move motions to reduce any demand for grant. Such motions are called as cut motion, which are of 3 kinds. Policy cut motion. It represents the disapproval of the policy underlying the demand. It states that the amount of the demand be reduced to rupees 1. The members can also advocate an alternative policy. Economy cut motion. It represents the economy that can be affected in the proposed expenditure. It states that the amount of the demand be reduced by a specified amount, which may be either a lump sum reduction in the demand or omission or reduction of an item in the demand. Token cut motion. It ventilates a specific grievance that is within the sphere of responsibility of the Government of India. It states that the amount of the demand be reduced by rupees 100. A cut motion to be admissible must satisfy the following conditions. Number 1. It should relate to one demand only. Number 2. It should be clearly expressed and should not contain arguments or defamatory statements. Number 3. It should be confined to one specific matter. Number 4. It should not make suggestions for the amendment or repeal of existing laws. Number 5. It should not refer to a matter that is not primarily the concern of Union government. Number 6. It should not relate to the expenditure charged on the Consolidated Fund of India. Number 7. It should not relate to a matter that is under adjudication by a court. Number 8. It should not raise a question of privilege. Number 9. It should not revive discussion on a matter on which a decision has been taken in the same session. Number 10. It should not relate to a trivial matter. Number 11. It should not reflect on the character or conduct of any person whose conduct can only be challenged on a substantive motion. Number 12. It should not anticipate a matter which has been previously appointed for consideration in the same session. Number 13. It should not seek to raise a discussion on a matter pending before any statutory tribunal or statutory authority performing judicial or quasi-judicial function or any commission or court of inquiry. The significance of a cut motion lies in facilitating the initiation of concentrated discussion on a specific demand for grant and upholding the principle of responsible government by proving the activities of the government. However, the cut motion do not have much utility in practice. They are only moved and discussed in the House but not passed as the government enjoys majority support. Their passes by the Lok Sabha amounts to the expression of want of parliamentary confidence in the government and may lead to its resignation. On the last day of the days allotted for discussion and voting on the demands for grants, the Speaker puts all the remaining demands to vote and disposes them whether they have been discussed by the members or not. This is known as guillotine. Number 5. Passing of Appropriation Bill. The Constitution states that no money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law. Accordingly, an appropriation bill is introduced to provide for an appropriation out of the Consolidated Fund of India all money required to meet the grants voted by the Lok Sabha, the expenditure charged on the Consolidated Fund of India. No such amendment can be proposed to the appropriation bill in either house of the parliament that will have the effect of varying the amount or altering the destination of any grant voted or of varying the amount of any expenditure charged on the Consolidated Fund of India. The appropriation bill becomes the Appropriation Act after it is assented to by the President. This act authorizes or legalizes the payments from the Consolidated Fund of India. This means that the government cannot withdraw money from the Consolidated Fund of India till the enactment of the appropriation bill. This takes time and usually goes on till the end of April, but the government needs money to carry on its normal activities after 31st March, the end of the financial year. To overcome this functional difficulty, the Constitution has authorized the Lok Sabha to make any grant in advance in respect to the estimated expenditure for a part of the financial year, pending the completion of the voting of the demands for grants and the enactment of the appropriation bill. This provision is known as the vote on account. It is passed or granted after the general discussion on budget is over. It is generally granted for 2 months for an amount equivalent to 1/6 of the total estimation. Number 6. Passing of Finance Bill. The Finance Bill is introduced to give effect to the financial proposals of the Government of India for the following year. It is subjected to all the conditions applicable to a money bill. Unlike the Appropriation Bill, the amendments seeking to reject or reduce a tax can be moved in the case of Finance Bill. According to the Provisional Collection of Taxes Act of 1931, the Finance Bill must be enacted, that is passed by the Parliament and assented to by the President within 75 days. The Finance Act legalizes the income side of the budget and completes the process of the enactment of the budget. Other grants. In addition to the budget that contains the ordinary estimates of income and expenditure for one financial year, various other grants are made by the Parliament under extraordinary or special circumstances. Supplementary grant. It is granted when the amount authorized by the Parliament through the Appropriation Act for a particular service for the current financial year is found to be insufficient for that year. Additional grant. It is granted when a need has arisen during the current financial year for additional expenditure upon some new service not contemplated in the budget for that year. Excess grant. It is granted when money has been spent on any service during a financial year in excess of the amount granted for that service in the budget for that year. It is voted by the Lok Sabha after the financial year before the demands for excess grants are submitted to the Lok Sabha for voting. They must be approved by the Public Accounts Committee of Parliament. Vote of credit. It is granted for meeting an unexpected demand upon the resources of India when, on account of the magnitude or the indefinite character of the service, the demand cannot be stated with the details ordinarily given in a budget. Hence, it is like a blank check given to the executive by the Lok Sabha. Exceptional grant. It is granted for a special purpose and forms no part of the current service of any financial year. Token grant. It is granted when funds to meet the proposed expenditure on new service can be made available by reappropriation. A demand for the grant of a token sum of rupees 1 is submitted to the vote of Lok Sabha, and if assented, funds are made available. Reappropriation involves transfer of funds from one head to another. It does not involve any additional expenditure. Supplementary, additional excess and exceptional grants and vote of credit are regulated by the same procedure which is applicable in the case of a regular budget. Funds. The Constitution of India provides for the following three kinds of funds for the central government. Number 1. Consolidated Fund of India under Article 266. Number 2. Public Account of India under Article 266. Number 3. Contingency Fund of India under Article 267. Consolidated Fund of India. It is a fund to which all receipts are credited and all payments are debited. In other words, all revenues received by the Government of India, all loans raised by the government by the issue of treasury bill, loans or ways and means of advances, all money received by the government in repayment of loans forms the Consolidated Fund of India. All the legally authorized payment on behalf of the Government of India are made out of this fund. No money out of this fund can be appropriated, issued or drawn except in accordance with the parliamentary law. Public Account of India. All other public money other than those which are credited to the Consolidated Fund of India received by or on behalf of the Government of India shall be credited to the Public Account of India. This includes Provident Fund deposit, judicial deposit, saving bank deposit, departmental deposit, remittances and so on. This account is operated by executive action, that is, the payment from this account can be made without parliamentary appropriation. Such payments are mostly in the nature of banking transaction. Contingency Fund of India. The Constitution authorized the Parliament to establish a Contingency Fund of India into which amounts determined by law are paid from time to time. Accordingly, the Parliament enacted the Contingency Fund of India Act in 1950. This fund is placed at the disposal of the President and he can make advances out of it to meet unforeseen expenditure pending its authorization by the Parliament. The fund is held by the Finance Secretary on behalf of the President. Like the Public Account of India, it is also operated by executive action. Multifunctional role of Parliament. In the Indian politico-administrative system, The Parliament occupies a central position and has a multifunctional role. It enjoys extensive powers and performs a variety of functions towards the fulfillment of its constitutionally expected role. Its powers and functions can be classified under the following heads. Number 1. Legislative powers and functions. Number 2. Executive powers and functions. Number 3. Financial powers and functions. Number 4. Constituent powers and functions. Number 5. Judicial powers and functions. Number 6. Electoral powers and functions. Number 7. Other powers and functions. Number 1. Legislative powers and functions. The primary function of Parliament is to make laws for the governance of the country. It has exclusive power to make laws on the subjects enumerated in the Union list, which at present has 98 subjects, originally 97 subjects, and on the residuary subjects, that is, subjects not enumerated in any of the three lists. With regard to concurrent list, which has at present 52 subjects, originally 47 subjects, the Parliament has overriding powers. That is, the law of Parliament prevails over the law of the state legislature in case of a conflict between the two. The Constitution also empowers the Parliament to make laws on the subjects enumerated in the state list, which at present has 59 subjects, originally 66 subjects, under the following 5 abnormal circumstances. Number 1. When Rajya Sabha passes a resolution to that effect. B. When a proclamation of national emergency is in operation. C. When two or more states make a joint request to the Parliament. D. When necessary to give effect to international agreement, treaties and conventions. E. When President's rule is in operation in that state. All the ordinances issued by the President during the recess of the Parliament must be approved by the Parliament within 6 weeks after its reassembly. An ordinance becomes inoperative if it is not approved by the Parliament within that period. The Parliament makes laws in a skeleton form and authorizes the executive to make detailed rules and regulations within the framework of the parent law. This is known as delegated legislation or executive legislation or subordinate legislation. Such rules and regulations are placed before the Parliament for its examination. Number 2. Executive powers and functions. The Constitution of India established a parliamentary form of government in which the executive is responsible to the Parliament for its policies and act. Hence, the Parliament exercises control over the executive through question hour, 0 hour, half an hour discussion, short duration discussion, calling attention motion, adjournment motion, no confidence motion, censure motion, and other discussions. It also supervises the activities of the executive with the help of its committee like Committee on Government Assurance, Committee on Subordinate Legislation, Committee on Petitions, etc. The ministers are collectively responsible to the Parliament in general and to the Lok Sabha in particular. As a part of collective responsibility, there is individual responsibility, that is, each minister is individually responsible for the efficient administration of the ministry under his charge. This means that they continue in office so long as they enjoy the confidence of the majority members in the Lok Sabha. In other words, the Council of Ministers can be removed from office by the Lok Sabha by passing a no confidence motion. The Lok Sabha can also express lack of confidence in the government in the following ways. A. By not passing a motion of thanks on the President's inaugural address. B. By rejecting a money bill. C. By passing a censure motion or an adjournment motion. D. By defeating the government on a vital issue. E. By passing a cut motion. Therefore, the first function of Parliament can be said to be to select the group which is to form the government, support and sustain it in power so long as it enjoys its confidence, and to expel it when it ceases to do so, and leave it to the people to decide at the next general election. Number 3. Financial powers and functions. No tax can be levied or collected, and no expenditure can be incurred by the executive except under the authority and with the approval of Parliament. Hence, the budget is placed before the Parliament for its approval. The enactment of the budget by the Parliament legalizes the receipt and expenditure of the government for the ensuing financial year. The Parliament also scrutinizes government spending and financial performance with the help of its Financial Committee. These include Public Account Committee, Estimate Committee, and Committee on Public Undertakings. They brings out the cases of illegal, irregular, unauthorized, improper uses and wastage and extravagance in public expenditure. Therefore, the parliamentary control over the executive in financial matters operates in two stages. A. Budgetary control, that is, control before the appropriation of grants through the enactment of the budget. B. Post budgetary control, that is, control after the appropriation of grants through the three financial committees. The budget is based on the principle of annuity, that is, the parliament grants money to the government for one financial year. If the granted money is not spent by the end of the financial year, then the balance expires and returns to the Consolidated Fund of India. This practice is known as the rule of lapse. It facilitates effective financial control by the parliament as no reserve funds can be built without its authorization. However, the observance of this rule leads to heavy rush of expenditure towards the close of the financial year. This is popularly called as March rush. Number 4. Constituent powers and functions. The Parliament is vested with the powers to amend the Constitution by way of addition, variation, or repeal of any provision. The major part of the Constitution can be amended by the Parliament with the special majority, that is, a majority of the total membership of each House and a majority of not less than two-thirds of the members present and voting in each House. Some other provisions of the Constitution can be amended by the Parliament with simple majority, that is, a majority of the members present and voting in each House of Parliament. Only a few provisions of the Constitution can be amended by the Parliament by special majority and with the consent of at least half of the state legislatures by simple majority. However, the power to initiate the process of the amendment of the Constitution in all the three cases lies exclusively in the hands of the Parliament and not the state legislature. There is only one exception, that is, the state legislature can pass a resolution requesting the Parliament for the creation or abolition of the Legislative Council in the state. Based on the resolution, the Parliament makes an act for amending the Constitution to that effect. That to sum up, the Parliament can amend the Constitution in three ways: by simple majority, by special majority, and by special majority, but with the consent of half of all the state legislature. The constituent power of the Parliament is not unlimited. It is subject to the basic structure of the Constitution. In other words, the Parliament can amend any provision of the Constitution except the basic features of the Constitution. This was ruled by the Supreme Court in the Keshwanand Bharti case of 1973 and reaffirmed in the Minerva Mills case of 1980. Number 5. Judicial powers and function. The judicial power and functions of the Parliament include the following. A. It can impeach the President for the violation of the Constitution. B. It can remove the Vice President from his office. C. It can recommend the removal of judges, including Chief Justice of the Supreme Court and the High Courts, Chief Election Commissioner, Comptroller and Auditor General to the President. D. It can punish its members or outsiders for the breach of its privileges or its contempt. Number 6. Electoral powers and functions. The Parliament participates in the election of the President along with the state legislative assemblies and elect the Vice President. The Lok Sabha elect its Speaker and Deputy Speaker while the Rajya Sabha elects its Deputy Chairman. The Parliament is also authorized to make laws to regulate the elections to the offices of President and Vice President, to both the Houses of Parliament and to both the Houses of State Legislature. Accordingly, Parliament enacted the Presidential and Vice Presidential Election Act 1952, the Representation of People Act 1950 and the Representation of People Act 1951, etc. Number 7. Other powers and functions. The various other powers and functions of the Parliament include: Number A. It serves as the highest deliberative body in the country. It discusses various issues of national and international significance. B. It approves all the three types of emergencies, national, state and financial, proclaimed by the President. C. It can create or abolish the State Legislative Council on the recommendation of the concerned state legislative assemblies. D. It can increase or decrease the area, alter the boundaries and change the name of a state of the Indian Union. E. It can regulate an organization or jurisdiction of the Supreme Court and High Courts and can establish a common High Court for two or more states. Ineffectiveness of parliamentary control. The parliamentary control over government and administration in India is more theoretical than practical. In reality, the control is not as effective as it ought to be. The following factors are responsible for this. A. The parliament has neither time for expertise to control the administration, which has grown in volume as well as complexity. B. Parliament's financial control is hindered by the technical nature of the demands for grants. The parliamentarians, being laymen, cannot understand them properly and fully. C. The legislative leadership lies with the executive and it plays a significant role in formulating policies. D. The very size of the parliament is too large and unmanageable to be effective. E. The majority support enjoyed by the executive in the parliament reduces the possibility of effective criticism. F. The Financial Committee, like Public Account Committee, examines public expenditure after it has been incurred by the executive, thus they do post-mortem work. G. They increased recourse to guillotine, reduced the scope of financial control. H. The growth of delegated legislation has reduced the role of Parliament in making detailed laws and has increases the power of bureaucracy. I. The frequent promulgation of ordinances by the President dilutes the Parliament's power of legislation. J. The Parliament's control is sporadic, general, and mostly political in nature. K. Lack of a strong and steady opposition in the Parliament and a setback in the parliamentary behavior and ethics have also contributed to the ineffectiveness of legislative control over administration in India. Position of Rajya Sabha. The constitutional position of Rajya Sabha as compared with the Lok Sabha can be studied from the three angles. Number 1, where Rajya Sabha is equal to Lok Sabha. Number 2, where Rajya Sabha is unequal to Lok Sabha. Number 3, where Rajya Sabha has special powers that are not at all shared with the Lok Sabha. Equal status with Lok Sabha. In the following matters, the powers and status of the Rajya Sabha are equal to that of the Lok Sabha. Number 1, introduction and passage of ordinary bills. Number 2, introduction and passage of constitutional amendment bills. Number 3, introduction and passage of financial bill involving expenditure from the Consolidated Fund of India. Number 4, election and impeachment of the President. Number 5, election and removal of the Vice President. However, Rajya Sabha alone can initiate the removal of the Vice President. He is removed by a resolution passed by the Rajya Sabha by an effective majority, which is a type of special majority and agreed to by the Lok Sabha by a simple majority. Number 6, making recommendation to the President for the removal of Chief Justice and judges of Supreme Court and High Courts, Chief Election Commissioner and Comptroller and Auditor General. Number 7, approval of ordinances issued by the President. Number 8, approval of proclamation of all three types of emergencies by the President. Number 9, selection of ministers including the Prime Minister. Under the Constitution, the ministers including the Prime Minister can be members of either house. However, irrespective of their membership, they are responsible only to the Lok Sabha. Number 10, consideration of the reports of the constitutional bodies like Finance Commission, Union Public Service Commission, Comptroller and Auditor General, etc. Number 11, enlargement of the jurisdiction of the Supreme Court and of the Union Public Service Commission. Unequal status with Lok Sabha. In the following matters, the powers and status of the Rajya Sabha are unequal to that of the Lok Sabha. Number 1, a money bill can be introduced only in the Lok Sabha, not in Rajya Sabha. Number 2, Rajya Sabha cannot amend or reject a money bill. It should return to the bill to the Lok Sabha within 14 days, either with recommendation or without recommendation. Number 3, the Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. In both the cases, the money bill is deemed to have been passed by of the two houses. Number 4, a financial bill not containing solely the matters of Article 110 also can be introduced only in the Lok Sabha and not in the Rajya Sabha, but with regard to its passage, both the houses have equal powers. Number 5, the final power to decide whether a particular bill is a money bill or not is vested in the Speaker of the Lok Sabha. Number 6, the Speaker of Lok Sabha presides over the joint sitting of both the houses. Number 7, the Lok Sabha with greater numbers wins the battle in a joint sitting except when the combined strength of the ruling party in both the houses is less than that of the opposition parties. Number 8, Rajya Sabha can only discuss the budget but cannot vote on the demands for grants, which is the exclusive privilege of Lok Sabha. Number 9, A resolution for the discontinuance of the national emergency can be passed only by the Lok Sabha and not by the Rajya Sabha. Number 10. The Rajya Sabha cannot remove the Council of Ministers by passing a no confidence motion. This is because the Council of Ministers is collectively responsible only to the Lok Sabha, but the Rajya Sabha can discuss and criticize the policies and activities of the government. Special powers of Rajya Sabha. The Rajya Sabha has been given four exclusive or special powers that are not enjoyed by the Lok Sabha. Number 1. It can authorize the Parliament to make a law on a subject enumerated in the state list under Article 249. Number 2. It can authorize the Parliament to create new All India services common to both the centre and state, Article 312. Number 3. It alone can initiate a move for the removal of the Vice President. In other words, a resolution for the removal of the Vice President can be introduced only in the Rajya Sabha and not in the Lok Sabha under Article 67. Number 4. If a proclamation is issued by the President for imposing national emergency or President's rule or financial emergency at a time when the Lok Sabha has been dissolved or the dissolution of Lok Sabha takes place within the period allowed for its approval, then the proclamation can remain effective even if it is approved by the Rajya Sabha alone under Article 352, 356 and 360. The an analysis of the above points make it clear that the position of the Rajya Sabha in our constitutional system is not as weak as that of the House of Lords in the Britain constitutional system, nor as strong as that of the Senate in the American constitutional system. Except in financial matters and control over the Council of Ministers, the powers and status of the Rajya Sabha in all other spheres are broadly equal and coordinate with that of the Lok Sabha. Even though the Rajya Sabha has been given less power as compared with the Lok Sabha, its utility is supported on the following grounds. Number 1. It checks hasty, defective, careless, and ill considered legislation made by the Lok Sabha by making provision of the revision and thought. Number 2. It facilitates giving representation to eminent professionals and experts who cannot face the direct election. The President nominates 12 such persons to the Rajya Sabha. Number 3. It maintains the federal equilibrium by protecting the interest of the states against the undue interference of the centre. Parliamentary privileges. Meaning, parliamentary privileges are special rights, immunities, and exemptions enjoyed by the two houses of parliament, their committees, and their members. They are necessary in order to secure the independence and effectiveness of their actions. Without these privileges, the House can neither maintain their authority, dignity, and honor, nor can protect their members from any obstruction in the discharge of their parliamentary responsibilities. The Constitution has also extended the parliamentary privileges to those persons who are entitled to speak and take part in the proceedings of a House of Parliamentary or any of its committees. These include the Attorney General of India and Union Ministers. It must be clarified here that the parliamentary privileges do not extend to the President, who is also an integral part of the Parliament. Classification. Parliamentary privileges can be classified into two broad categories. Number 1, those that are enjoyed by each House of Parliament collectively. Number 2, those that are enjoyed by the members individually. Collective privileges. The privileges belonging to each House of Parliament collectively are: Number 1, it has the right to publish its report, debates, and proceedings, and also the right to prohibit others from publishing the same. The 44th Amendment Act of 1978 restored the freedom of the press to publish true reports of parliamentary proceedings without prior permission of the House, but this is not applicable in the case of a secret sitting of the House. Number 2. It can exclude strangers from its proceedings and hold secret sittings to discuss some important matters. Number 3. It can make rules to regulate its own procedure and the conduct of its business and to adjudicate upon such matters. Number 4. It can punish members as well as outsiders for breach of its privileges or its contempt by reprimand, ad- admonition, or imprisonment, also suspension of expulsion in case of members. Number 5. It has the right to receive immediate information of the arrest, detention, conviction, imprisonment, and release of a member. Number 6. It can institute inquiries and order the attendance of witnesses and send for relevant papers and records. Number 7. The courts are prohibited to inquire into the proceedings of a house or its committee. Number 8. No person, either a member or an outsider, can be arrested, and no legal process, civil or criminal, can be served within the precincts of the House without the permission of the presiding officer. Individual privileges. The privileges belonging to the members individually are: number 1. They cannot be arrested during the session of Parliament and 40 days before the beginning and 40 days after the end of a session. This privilege is available only in civil cases and not in criminal cases or preventive detention cases. Number 2. They have freedom of speech in Parliament. No member is liable to any proceedings in any court for anything said or any vote given by him in Parliament or its committee. This freedom is subject to the provision of the Constitution and to the rules and standing orders regulating the procedure of Parliament. Number 3. They are exempted from jury service. They can refuse to give evidence and appear as a witness in a case pending in a court when Parliament is in session. Breach of privilege and contempt of the House. When any individual or authority disregards or attacks any of the privileges, rights, and immunities either of the member individually or of the House in its collective capacity, the offence is termed as breach of privilege and is punishable by the House. Any act or omission which obstructs a House of Parliament, its members, or its officers in the performance of their functions, or which has a tendency, directly or indirectly, to produce results against the dignity, authority, and honor of the House, is treated as a contempt of the House. Though the two phrases breach of privilege and contempt of the House are used interchangeably, they have different implications. Normally, a breach of privilege may amount to contempt of the House. Likewise, contempt of the House may include a breach of privilege also. Contempt of the House, however, has wider implications. There may be a contempt of the House without specifically committing a breach of privilege. Similarly, actions which are not breaches of any specific privilege but are offences against the dignity and authority of the House amount to contempt of the House. For example, disobedience to a legitimate order of the House is not a breach of privilege but can be punished or contempt of the House. Sources of privileges. Originally, the Constitution Article 105 expressly mentioned two privileges, that is, freedom of speech in Parliament and right of publication of its proceedings. With regard to other privileges, it provided that they were to be the same as those of the British House of Commons, its committees and its members on the date of its commencement, that is, 26 January 1950. Until defined by Parliament. The 44th Amendment Act of 1978 provided that the other privileges of each House of Parliament, its committees, and its members are to be those which they had on the date of its commencement, that is 20 June 1979, until defined the Parliament. This means that the position with regard to other privileges remains same. In other words, the amendment has made only verbal changes by dropping a direct reference to the British House of Commons without making any change in the implication of the provisions. It should be noted here that the Parliament till now has not made any special law to exhaustively codify all the privileges. They are based on 5 sources, namely constitutional provisions, various laws made by the Parliament, rules of both the houses, parliamentary conventions, and judicial interpretations. Sovereignty of Parliament. The doctrine of sovereignty of Parliament is associated with the British Parliament. Sovereignty means the supreme power within the state. That supreme power in Great Britain lies with the Parliament. There are no legal restrictions on its authority and jurisdiction. Therefore, the sovereignty of Parliament, parliamentary supremacy, is a cardinal feature of the British constitutional system. According to A.V. Dicey, the British jurist, the principle has 3 implications. Number 1. The Parliament can make, amend, substitute, or repeal any law. D. Lolme, a British political analyst, said, the British Parliament can do everything except make a woman a man and a man a woman. Number 2. The Parliament can make constitutional laws by the same procedures as ordinary laws. In other words, there is no legal distinction between the constituent authority and the legislative authority of the British Parliament. Number 3. The parliamentary laws cannot be declared invalid by the judiciary as being unconstitutional. In other words, there is no system of judicial review in Britain. The Indian Parliament, on the other hand, cannot be regarded as a sovereign body in the similar sense, as there are legal restrictions on its authority and jurisdiction. The factors that limit the sovereignty of Indian Parliament are: Number 1. Written nature of the Constitution. The Constitution is the fundamental law of the land in our country. It has defined the authority and jurisdiction of all the three organs of the Union government and the nature of interrelationship between them. Hence, the Parliament has to operate within the limits prescribed by the Constitution. There is also a legal distinction between the legislative authority and the constituent authority of the Parliament. Moreover, to effect certain amendments to the Constitution, the ratification of half of the state is also required. In Britain, on the other hand, the Constitution is neither written nor there is anything like a fundamental law of the land. Number 2. Federal system of government. India has a federal system of government with a constitutional division of powers between the union and the state. Both have to operate within the spheres allotted to them. Hence, the law-making authority of the Parliament gets confined to the subjects enumerated in the Union list and concurrent list and does not extend to the subjects enumerated in the state list except in 5 abnormal circumstances, and that too for a short period. Britain, on the other hand, has a unitary system of government and hence all the powers are vested in the centre. Number 3. System of judicial review. The adoption of an independent judiciary with the power of judicial review also restricts the supremacy of our Parliament. Both the Supreme Court and High Court can declare the laws enacted by the Parliament as void and ultra vires unconstitutional if they contravene any provision of the Constitution. On the other hand, there is no system of judicial review in Britain. The British court have to apply the parliamentary laws to specific cases without examining their constitutionality, legality, or reasonableness. Number 4. Fundamental rights. The authority of the Parliament is also restricted by the incorporation of a code of justiciable amendments rights under Part 3 of the Constitution. Article 13 prohibits the state from making a law that either takes away totally or abrogates in part a fundamental right. Hence, a parliamentary law that contravenes the fundamental right shall be void. In Britain, on the other hand, there is no codification of justiciable fundamental right in the Constitution. The British Parliament has also not made any law that lays down the fundamental rights of the citizen. However, it does not mean that the British citizen do not have rights. Though there is no charter guaranteeing right, there is maximum liberty in Britain due to existence of the rule of law. Therefore, even though the nomenclature and organizational pattern of our parliament is similar to that of the British Parliament, there is a substantial difference between the two. The Indian Parliament is not a sovereign body in the sense in which the British Parliament is a sovereign body. Unlike the British Parliament, the authority and jurisdiction of the Indian Parliament are defined, limited, and restrained. In this regard, the Indian Parliament is similar to the American legislature known as Congress. In USA, also, the sovereignty of Congress is legally restricted by the written character of the Constitution, the federal system of government, the system of judicial review, and the Bill of Rights. The theoretical portion of this chapter ended here, but this chapter contains too many tables regarding different parliamentary functions or committees. So for further tables, you can refer the book or the PDF. Thank you so much. Chapter 23. Parliamentary Committees. Meaning, the Parliament is too unwieldly a body to deliberate effectively the issues that come up before it. The functions of the Parliament are varied, complex, and voluminous. Moreover, it has neither the adequate time nor necessary expertise to make a detailed scrutiny of all legislative measures and other matters. Therefore, it is assisted by a number of committees in the discharge of its duties. The Constitution of India makes a mention of these committees at different places, but without making any specific provisions regarding their composition, tenure, functions, etc. All these matters are dealt by the rules of two houses. Accordingly, a parliamentary committee means a committee that number 1 is appointed or elected by the House or nominated by the Speaker or Chairman. Number 2 works under the direction of the Speaker, Chairman. Number 3 presents its report to the House or to the Speaker or Chairman. Number 4 has a secretariat provided by the Lok Sabha, Rajya Sabha. The consultative committees, which also consist of members of parliament, are not parliamentary committees as they do not fulfill above four conditions. Classification. Broadly, parliamentary committees are of two kinds: standing committees and ad hoc committees. The former are permanent, constituted every year or periodically, and work on a continuous basis, while the latter are temporary and cease to exist on completion of the task assigned to them. Standing committees. On the basis of the nature of functions performed by them, standing committees can be classified into the following six categories. Number 1 Financial Committee. A. Public Account Committee, Estimate Committee, and Committee on Public Undertakings. Number 2 Departmental Standing Committees. 24. Number 3 Committees to Inquire. It includes Committee on Petitions, Committee of Privileges, Ethics Committee. Number 4 Committees to Scrutinize and Control. Committee on Government Assurances, Committee on Subordinate Legislation, Committee on Papers Laid on the Table, Committee on Welfare of SCs and STs, Committee on Empowerment of Women, Joint Committee on Offices of Profit. Number 5 Committees relating to the day-to-day business of the House. Business Advisory Committee, Committee on Private Members' Bill and Resolutions, Rules Committee, Committee on Absence of Members from Sittings of the House. Number 6 Housekeeping Committees or Service Committee, that is, committees concerned with the provision of facilities and services of members. General Purpose Committee, House Committee, Library Committee, and Joint Committee on Salaries and Allowances of Members. Ad hoc committees. Ad hoc committees can be divided into two categories, that is, inquiry committees and advisory committees. Number 1 Inquiry committees are constituted from time to time either by the two houses on a motion adopted in that behalf or by the Speaker, Chairman, to inquire into and report on specific subjects. For example, A. Committee on the conduct of certain members during President's address. B. Committee on draft 5-year plan. C. Railway Convention Committee. D. Committee on members of Parliament Local Area Development Scheme. E. Joint Committee on Bofors Contract. F. Joint Committee on Fertilizer Pricing. G. Joint Committee to inquire into irregularities in securities and banking transaction. H. Joint Committee on Stock Market Scam. I. Joint Committee on Security in Parliament Complex. J. Committee on Provision of Computers to Members of Parliament, Officers of Political Parties, and Officers of the Lok Sabha Secretariat. K. Committee on Food Management in Parliament House Complex. I. Committee on Installation of Portraits, Statues, Status of National Leaders and Parliamentarians in Parliament House Complex. M. Joint Committee on Maintenance of Heritage Character and Development of Parliament House Complex. N. Committee on Violation of Protect Norms and Contemptuous Behavior of Government Officers with the members of Lok Sabha. O. Joint Committee to examine matters relating to allocation and pricing of telecom licenses and spectrum. Number 2. Advisory Committee includes select or joint committees on bills which are appointed to consider and report on particular bills. These committees are distinguishable from the other ad hoc committees in as much as they are concerned with bills and the procedure to be followed by them is laid down in the rules of procedure and the direction by the Speaker or Chairman. When a bill comes up before a house for general discussion, it is open to that house to refer to it a select committee of the house or a joint committee of the two houses. A motion to this effect has to be moved and adopted in the house in which the bill comes up for consideration. In case the motion adopted is for reference of the bill to a joint committee, the decision is conveyed to the other house, requesting the members to nominate members of the other house to serve on the committee. The select or joint committee considers the bill clause by clause just as the two houses do. Amendments to various clauses can be moved by Members of the committee. The committee can also take evidence of associations, public bodies, or experts who are interested in the bill. After the bill has thus been considered, the committee submits its report to the House. Members who do not agree with the majority report may append their minutes of dissent to the report. Financial committees. Public Account Committee. This committee was set up first in 1921 under the provision of the Government of India Act of 1919 and has since been in existence. At present, it consists of 22 members, 15 from the Lok Sabha and 7 from the Rajya Sabha. The members are elected by the Parliament every year from amongst its members according to the principle of proportional representation by means of the single transferable vote. Thus, all parties get due representation in it. The term of office of the member is 1 year. A minister cannot be elected as a member of the committee. The chairman of the committee is appointed from amongst its members by the Speaker. Until 1966 to 67, the chairman of the committee belonged to the ruling party. However, since 1967, a convention has developed whereby the chairman of the committee is selected invariably from the opposition. The function of the committee is to examine the annual audit report of the Comptroller and Auditor General of India, which are laid before the Parliament by the President. The CAG submits three audit reports to the President, namely Audit Report on Appropriation Accounts, Audit Report on Finance Accounts, and Audit Report on Public Undertakings. The committee examines public expenditure not only from legal and formal point of view to discover technical irregularities, but also from the point of view of economy, prudence, wisdom, and propriety to bring out the case of wastage, loss, corruption, extravagance, inefficiency, and nugatory expenses. In more detail, the function of the committee are: number 1, to examine the appropriation accounts and the finance accounts of the union government and any other accounts laid before the Lok Sabha. The appropriation account compare the actual expenditure with the expenditure sanctioned by the Parliament through the Appropriation Act, while the finance accounts shows the annual receipt and disbursement of the union government. Number 2, in scrutinizing the appropriation accounts and the audit report of CAG on it, the committee has to satisfy itself that A. The money that has been disbursed was legally available for the applied service or purpose. B. The expenditure conforms to the authority that governs it. C. Every reappropriation has been made in accordance with the related rules. Number 3, to examine the accounts of state corporations, trading concerns, and manufacturing projects and the audit report of CAG on them, except those public undertakings which are allotted to the Committee on Public Undertakings. Number 4, to examine the accounts of autonomous and semi-autonomous bodies, the audit of which is conducted by the CAG. Number 5, to consider the report of the CAG relating to the audit of any receipt or to examine the accounts of stores and stocks. Number 6, to examine the money spent on any service during a financial year in excess of the amount granted by the Lok Sabha for that purpose. In the fulfillment of the above functions, the committee is assisted by the CAG. In fact, the CAG act as a guide, friend, and philosopher of the committee. On the role played by the committee, Ashok Chanda, who himself has been a CAG of India, observed, over a period of years, the committee has entirely fulfilled the expectation that it should develop into a powerful force in the control of public expenditure. It may be claimed that the traditions established and conventions developed by the Public Account Committee conform to the highest traditions of a parliamentary democracy. However, the effectiveness of the role of committee is limited by the following. A. It is not concerned with the questions of policy in broader sense. B. It conducts a post-mortem examination of accounts showing the expenditure already incurred. C. It cannot intervene in the matters of day-to-day administration. D. Its recommendations are advisory and not binding on the ministries. E. It is not vested with the power of disallowance of expenditures by the departments. F. It is not an executive body and hence cannot issue an order. Only the Parliament can take a final decision on its findings. Estimates Committee. The origin of this committee can be traced to the Standing Financial Committee set up in 1921. The first Estimates Committee in the post-independence era was constituted in 1950 on the recommendation of John Mathai, the then finance minister. Originally, it had 25 members, but in 1956, its membership was raised to 30. All the 30 members are from Lok Sabha only. The Rajya Sabha has no representation in this committee. These members are elected by the Lok Sabha every year from amongst its own members according to the principles of proportional representation by means of a single transferable vote. Thus, all parties get due representation in it. The term of office is 1 year. A minister cannot be elected as a member of committee. The chairman of the committee is appointed by the speaker from amongst its members and he is invariably from the ruling party. The function of the committee is to examine the estimate, include in the budget, and suggest economies in public expenditure. Hence, it has been described as a continuous economy committee. In more detail, the function of the committee are: number 1, to report what economies, improvements in organization, efficiency, and administrative reform consistent with the policy underlying the estimate can be effected. Number 2, to suggest alternative policies in order to bring about efficiency and economy in administration. Number 3, to examine whether the money is well laid out within the limits of the policy implied in the estimate. Number 4, to suggest the form in which the estimates are to be presented to Parliament. The committee shall not exercise its function in relation to such public undertakings are allotted to the Committee on Public Undertakings. The committee may continue the examination of the estimates from time to time throughout the financial year and report to the House as its examination proceeds. It shall not be incumbent on the committee to examine the entire estimates of any 1 year. The demands for grants may be finally voted despite the fact that the committee has made no report. However, the effectiveness of the role of the committee is limited by the following. A. It examines the budget estimate only after they have been voted by the Parliament and not before that. B. It cannot question the policy laid down by the Parliament. C. Its recommendations are advisory and not binding on the ministries. D. It examines every year only certain selected ministries and departments, thus, by rotation, it would cover all of them over a number of years. E. It lacks the expert assistance of the CAG, which is available to the Public Account Committee. F. Its work is in the nature of a postmortem. Committee on Public Undertakings. This committee was created in 1964 on the recommendation of the Krishna Menon Committee. Originally, it had 15 members, 10 from the Lok Sabha and 5 from the Rajya Sabha. However, in 1974, its membership was raised to 22, 15 from the Lok Sabha and 7 from the Rajya Sabha. The members of this committee are elected by the Parliament every year from amongst its own members according to the principle of proportional representation by means of a single transferable vote. Thus, all parties get due representation in it. The term of office of the members is 1 year. A minister cannot be elected as a member of the committee. The chairman of the committee is appointed by the speaker from amongst its members who are drawn from the Lok Sabha only. Thus, the member of the committee who are from the Rajya Sabha cannot be appointed as the chairman. The function of the committee are: number 1, to examine the reports and accounts of public undertakings. Number 2, to examine the reports of the Comptroller and Auditor General on public undertakings. Number 3, to examine in the context of autonomy and efficiency of public undertakings whether the affairs of the public undertakings are being managed in accordance with sound business principles and prudent commercial practices. Number 4, to exercise such other functions vested in the Public Accounts Committee and the Estimates Committee in relation to public undertakings which are allotted to it by the Speaker from time to time. The committee is not to examine and investigate any of the following. Number 1, matters of major government policy as distinct from business or commercial functions of the public undertakings. Number 2, matters of day-to-day administration. Number 3, matters for the consideration of which machinery is established by any special statute under which a particular public undertaking is established. Further, the effectiveness of the role of the committee is limited by the following. A. It cannot take up the examination of more than 10 to 12 public undertakings in a year. Number B. Its work is in the nature of a postmortem. Number C. It does not look into technical matters as its members are not technical experts. D. Its recommendations are advisory and not binding on the ministries. Departmental Standing Committees. On the recommendation of the Rules Committee of the Lok Sabha, 17 departmentally related standing committees were set up in the Parliament in 1993. In 2004, 7 more such committees were set up, thus increasing their number from 17 to 24. The main objective of the standing committee is to secure more accountability of the executive, that is the Council of Ministers, to the Parliament, particularly financial accountability. They also assist the Parliament in debating the budget more effectively. The 24 standing committee cover under their jurisdiction all the ministries, departments of the central government. Each standing committee consists of 31 members, 21 from Lok Sabha and 10 from Rajya Sabha. The members of the Lok Sabha are nominated by the Speaker from amongst its own members, just as the members of Rajya Sabha are nominated by the Chairman from amongst its members. A minister is not eligible to be appointed to be nominated as a member of any of the standing committee. In case a member after his nomination to any of the standing committees is appointed a minister, he then ceases to be a member of the committee. The term of office of each standing committee is 1 year from the date of its constitution. Out of the 24 standing committee, 8 work under the Rajya Sabha and 16 under the Lok Sabha. The 24 standing committee and the ministries departments placed under their jurisdiction are shown below. The function of each of the standing committees are: number 1, to consider the demands for grants of the concerned ministries, departments before they are discussed and voted in the Lok Sabha. Its report should not suggest anything of the nature of cut motions. Number 2, to examine bills pertaining to the concerned ministries or departments. Number 3, to consider annual reports of ministries and departments. Number 4, to consider national basic long-term policy documents presented to the houses. The following limitations are imposed on the functioning of these standing committees. Number 1, they should not consider the matters of day-to-day administration of the concerned ministries and departments. Number 2, they should not generally consider the matters which are considered by other parliamentary committees. It should be noted here that the recommendations of these committees are advisory in nature and hence not binding on the Parliament. The following procedure shall be followed by each of the standing committee in their consideration of the demands for grants and making a report thereon to the Houses. A. After general discussion on the budget in the Houses is over, the Houses shall be adjourned for a fixed period. B. The committee shall consider for demands for grants of the concerned ministries during the aforesaid period. C. The committee shall make their report within the period and shall not ask for more time. D. The demand for grants shall be considered by the House in the light of the reports of the committees. E. There shall be a separate report on the demands for grants of each ministry. The following procedure shall be followed by each of the standing committee in examining the bills and making report thereon. A. The committee shall consider the general principle and clauses of bills referred to it. B. The committee shall consider only such bills as introduced in either of the houses and referred to it. C. The committee shall make report on bills in a given time. The merit of the standing committee system in the Parliament are: number 1, their proceedings are devoid of any party bias. Number 2, the procedure adopted by them is more flexible than in the Lok Sabha. Number 3, the system makes parliamentary control over executive much more detailed, close, continuous, in-depth and comprehensive. Number 4, the system ensures economy and efficiency in public expenditure as the ministries, departments would now be more careful in formulating their demands. Number 5, they facilitate opportunities to all the members of parliament to participate and understand the functioning of the government and contribute to it. Number 6, they can avail of expert opinion or public opinion to make the reports. They are authorized to invite experts and eminent persons to testify before them and incorporate their opinions in their reports. Number 7, the opposition parties and the Rajya Sabha can now play a greater role in exercising financial control over the executive. Departmental standing committees and their jurisdiction. Committees under Rajya Sabha. Number 1, Committee on Commerce. It covered commerce and industry. Number 2, Committee on Home Affairs. It covered home affairs, development of northeastern region. Number 3, Committee on Human Resource Development. It covered human resource development, youth affairs and sports, women and child development. Number 4, Committee on Industry. It covers heavy industries and public enterprises, micro, small and medium enterprises. Number 5, Committee on Science and Technology, Environment and Forest. It covers science and technology, space, earth sciences, atomic energy, Environment, Forest and Climate Change. Number 6, Committee on Transport, Tourism and Culture. It covers civil aviation, road transport and highways, shipping, culture and tourism. Number 7, Committee on Health and Family Welfare. It covered health and family welfare, Ayurveda, yoga and naturopathy, Unani, Siddha and homeopathy. Number 8, Committee on Personal Public Grievance, Law and Justice. It covered law and justice, personal public grievance and pensions. Committees under Lok Sabha. Number 9, Committee on Agriculture. It covered agriculture and farmers' welfare, fisheries, animal husbandry, and dairying, food processing industries. Number 10, Committee on Information Technology. It covers communication, electronics and information technology, information and broadcasting. Number 11, Committee on Defense. It covers defense. Number 12, Committee on Energy. It covers new and renewable energy and power. Number 13, Committee on External Affairs. It covers external affairs. Number 14, Committee on Finance. It covers finance, corporate affairs, planning, statistics and program implementation. Number 15, Committee on Food, Consumer Affairs and Public Distribution. It covers consumer affairs, food and public distribution. Number 16, Committee on Labor. It covers labor and employment, skill development, entrepreneurship and textiles. Number 17, Committee on Petroleum and Natural Gas. It covers petroleum and natural gas. Number 18, Committee on Railways. It covers railways. Number 19, Committee on Urban Development. It covers housing and urban affairs. Number 20, Committee on Water Resources. It covers Jal Shakti. Number 21, Committee on Chemicals and Fertilizers. It covers chemicals and fertilizers. Number 22, Committee on Rural Development. It covers rural development and Panchayati Raj. Number 23, Committee on Coal and Steel. It covers coal, mines and steel. Number 24, Committee on Social Justice and Empowerment. Social Justice and Empowerment, Tribal Affairs and Minority Affairs. Committees to inquire. Committee on Petition. This committee examines petitions on bills and on matters of general public importance. It also entertains representation from individuals and associations on matters pertaining to union subjects. The Lok Sabha committee consists of 15 members while the Rajya Sabha committee consists of 10 members. Committee of Privileges. The function of this committee are semi-judicial in nature. It examines the cases of breach of privileges of the House and its members and recommends appropriate action. The Lok Sabha committee has 15 members while the Rajya Sabha committee has 10 members. Ethics Committee. This committee was constituted in Rajya Sabha in 1997 and in Lok Sabha in 2000. It enforces the code of conduct of members of parliament. It examines the cases of misconduct and recommends appropriate action. Thus, it is engaged in maintaining discipline and decorum in parliament. Committees on Scrutinize and Control. Committee on Government Assurances. This committee examines the assurances, promises and undertakings given by ministers from time to time on the floor of the House and reports on the extent to which they have been carried through. In the Lok Sabha, it consists of 15 members and in the Rajya Sabha, it consists of 10 members. It was constituted in 1953. Committee on Subordinate Legislation. This committee examines and reports to the House whether the powers to make regulations, rules, sub-rules and bylaws delegated by the Parliament or conferred by the Constitution to the Executive are being properly exercised by it. In both the Houses, the committee consists of 15 members. It was constituted in 1953. Committee on Papers laid on the table. This committee was constituted in 1975. The Lok Sabha committee has 15 members while the Rajya Sabha committee has 10 members. It examines all papers laid on the table of the House by ministers to see whether they comply with provision of the Constitution or the related act or rule. It does not examine statutory notifications and orders that fall under the jurisdiction of the Committee on Subordinate Legislation. Committee on Welfare of SCs and STs. This committee consists of 30 members, 20 from Lok Sabha and 10 from Rajya Sabha. Its functions are to consider the reports of National Commission for the SCs and National Commission for STs, to examine all matters relating to the welfare of SCs and STs, like implementation of constitutional and statutory safeguards, working of welfare program, etc. Committee on Empowerment of Women. This committee was constituted in 1997 and consists of 30 members, 20 from Lok Sabha and 10 from Rajya Sabha. It considers the reports of the National Commission for Women and examines the measures taken by the Union government to secure status, dignity, and equality for women in all fields. Joint Committee on Offices of Profit. This committee examines the composition and character of committees and other bodies appointed by the central, state, and union territory governments and recommends whether persons holding these offices should be disqualified from being elected as members of parliament or not. It consists of 15 members, 10 from Lok Sabha and 5 from Rajya Sabha. Committees relating to the day-to-day business of the House. Business Advisory Committee. This committee regulates the program and timetable of the House. It allocates time for the transaction of legislative and other business brought before the House by the government. The Lok Sabha committee consists of 15 members, including the Speaker as its chairman. In the Rajya Sabha, it has 11 members, including the chairman as its ex officio chairman. Committee on Private Members' Bill and Resolutions. This committee classifies bills and allocates time for the discussion and bills and resolutions introduced by private members other than ministers. This is a special committee of the Lok Sabha and consists of 15 members, including the Deputy Speaker as its chairman. The Rajya Sabha does not have any such committee. The same function in the Rajya Sabha is performed by the Business Advisory Committee of that House. Rules Committee. This committee considers the matters of procedure and conduct of business in the House and recommends necessary amendments or addition to the rules of the House. The Lok Sabha committee consists of 15 members, including the Speaker as its ex officio chairman. In the Rajya Sabha, it consists of 16 members, including the chairman as its ex officio chairman. Committee on Absence of Members. This committee considers all applications from members for leave of absence from the sitting of the House and examines the cases of members who have been absent for a period of 60 days or more without permission. It is a special committee of the Lok Sabha and consists of 15 members. There is no such committee in the Rajya Sabha and all such matters are dealt by the House itself. Housekeeping Committees. General Purpose Committee. This committee considers and advise on matters concerning affairs of the House which do not fall within the jurisdiction of any other parliamentary committee. In each House, the committee consists of the presiding officer, Speaker Chairman as its ex officio chairman, Deputy Speaker, Deputy Chairman in the case of Rajya Sabha, members of panel of chairpersons, panels of vice chairpersons in the case of Rajya Sabha, chairpersons of all the departmental standing committees of the House, leaders of recognized parties and groups in the House, and such other members as nominated by the presiding officer. House Committee. This committee deals with residential accommodation of members and other amenities like food, medical aid, etc., accorded to them in their houses and hostels in Delhi. Both the houses have their respective house committees. In the Lok Sabha, it consists of 12 members. Library Committee. This committee considers all matters relating to library of the parliament and assists the members in utilizing the library's service. It consists of 9 members, 6 from Lok Sabha and 3 from Rajya Sabha. Joint Committees on Salaries and Allowances of Members. This committee was constituted under the Salary, Allowances and Pension of Members of Parliamentary Act 1954. It consists of 15 members, 10 from Lok Sabha and 5 from Rajya Sabha. It frames rules for regulating payment of salary, allowances and pensions to members of parliament. Consultative Committees. Consultative committees are attached to various ministries, departments of the central government. They consist of members of both the houses of parliament. The Minister of State in charge of the ministry concerned act as the chairman of the consultative committee of that ministry. These committees provide a forum for informal discussion between the ministers and the members of parliament on policies and programs of the government and the manner of their implementation. These committees are constituted by the Ministry of Parliamentary Affairs. The guidelines regarding the composition, functions, and procedures of these committees are formulated by this ministry. The ministry also makes arrangements for holding their meetings both during the session and the intersession period of Parliament. The membership of these committees is voluntary and is left to the choice of the members and leaders of their parties. The maximum membership of a committee is 30 and the minimum is 10. These committees are normally constituted after the new Lok Sabha is constituted after general elections for the Lok Sabha. In other words, these committees shall stand dissolved upon dissolution of every Lok Sabha and shall be reconstituted upon constitution of every Lok Sabha. In addition, separate informal consultative committees of the members of parliament are also constituted for all the railway zones. Member of parliament belonging to the area falling under a particular railway zone are nominated on the informal consultative committee of that railway zone. Unlike the consultative committees attached to various ministries, departments, the meetings of the informal consultative committees are to be arranged during the session period only. Chapter 24 Parliamentary Forums. Establishment of the forums. The first Parliamentary Forum on Water Conservation and Management was constituted in the year 2005. Subsequently, 7 more Parliamentary Forums were constituted. At present, there are 8 Parliamentary Forums. Number 1. Parliamentary Forum on Water Conservation and Management 2005. Number 2. Parliamentary Forum on Youth 2006. Number 3. Parliamentary Forum on Children 2006. Number 4. Parliamentary Forum on Population and Public Health 2006. Number 5. Parliamentary Forum on Global Warming and Climate Change 2008. Number 6. Parliamentary Forum on Disaster Management 2011. Number 7. Parliamentary Forum on Artisans and Craftspeople 2013. Number 8. Parliamentary Forum on Millennium Development Goals 2013. Objectives of the forums. The objectives behind the constitution of the parliamentary forums are: number 1. To provide a platform to the members or to have interactions with the ministers concerned, experts and key officials from the nodal ministries with a view to have a focused and meaningful discussion on critical issues with a result-oriented approach for speeding up the implementation process. Number 2. To sensitize members about the key areas of concern and also about the ground level situation and equip them with the latest information, knowledge, technical know-how and valuable inputs from experts both from the country and abroad for enabling them to raise these issues effectively on the floor of the House and in the meetings of the departmentally related standing committees. Number 3. To prepare a database through collection of data on critical issues from ministries concerned, reliable NGOs, newspapers, United Nations, Internet, etc. and circulation thereof to the members so that they can meaningfully participate in the discussions of the forums and seek clarifications from experts or officials from the ministry present in the meetings. It has been mandated that the Parliamentary fora will not interfere with or encroach upon the jurisdiction of the departmentally related standing committee of the ministry department concerned. Composition of the forums. The Speaker of the Lok Sabha is the ex officio president of all the forums except the Parliamentary Forum on Population and Public Health, wherein the chairman of Rajya Sabha is the ex officio president and the speaker is the ex officio co-president. The deputy chairman of Rajya Sabha, the deputy speaker of Lok Sabha, the concerned ministers and the chairman of departmentally related standing committees are the ex officio vice presidents of the respective forums. Each forum consists of not more than 31 members, excluding the president, co-president and vice presidents, out of whom not more than 21 are from the Lok Sabha and not more than 10 are from the Rajya Sabha. Members other than the president, co-president and vice presidents of these forums are nominated by the speaker, chairman from amongst the leaders of various political parties, groups of or their nominees who have special knowledge, keen interest in the subject. The duration of the office of members of the forum is coterminous with their membership in the respective houses. A member may also resign from the forum by writing to the speaker or chairman. The president of the forum appoints a member convener for each forum to conduct regular approved programs meetings of the forum in consultation with the president. The meetings of the forums are held from time to time as may be necessary during parliament sessions. Functions of the forums. Parliamentary Forum on Water Conservation and Management. The functions of the forum are: number 1, to identify problems relating to water and make suggestions, recommendations for reconsideration and appropriate action by government organizations concerned. Number 2, to identify the ways of involving members of parliament in conservation and augmentation of water resources in their respective states constituencies. Number 3, to organize seminars, workshops to create awareness for conservation and efficient management of water. Number 4, to undertake such other related tasks as it may deem fit. Parliamentary Forum on Youth. The function of this forum are: number 1, to have focused deliberations on strategies to leverage human capital in the youth for accelerating development initiatives. Number 2, to build greater awareness amongst public leaders and at the grassroots level of the potential of youth for effecting socio-economic change. Number 3, to interact on a regular basis with youth representatives and leaders in order to better appreciate their hopes, aspirations, concerns, and problems. Number 4, to consider ways for improving Parliament's outreach to different sections of youth in order to reinforce their faith and commitment in democratic institutions and encourage their active participation therein. Number 5, to hold consultations with experts, national and international academicians, and government agencies concerned on redesigning of public policy in the matter of youth empowerment. Parliamentary Forum on Children. The function of the forum are: number 1, to further enhance awareness and attention of parliamentarians towards critical issues affecting children's well-being so that they may provide due leadership to ensure their rightful place in the development process. Number 2, to provide a platform to parliamentarians to exchange ideas, views, experiences, expert practices in relation to children in a structured manner through workshops, seminars, orientation programs, etc. Number 3, to provide parliamentarians an interface with civil society for highlighting children's issues including inter alia, the voluntary sector, media and corporate sector, and thereby to foster effective strategic partnerships in this regard. Number 4, to enable parliamentarians to interact in an institutionalized manner with specialized UN agencies like the UNICEF and other comparable multilateral agencies on expert reports, studies, news and trend analysis, etc. worldwide which are germane to developments in the sector. Number 5, to undertake any other task, project, assignment, etc. as the forum may deem fit. Parliamentary Forum on Population and Public Health. The functions of the forum are: number 1, to have focused deliberations on strategies relating to population stabilization and matters connected therewith. Number 2, to discuss and prepare strategies on issues concerning public health. Number 3, to build greater awareness in all sections of the society, particularly at the grassroots level regarding population control and public health. Number 4, to hold comprehensive dialogue and discussion in the matter of population and public health with experts at the national and international levels and to have interactions with multilateral organizations like WHO, United Nations Population Fund, and academicians and government agencies concerned. Parliamentary Forum on Global Warming and Climate Change. The function of the forum are: number 1, to identify problems relating to global warming and climate change and make suggestions, recommendations for consideration and appropriate action by the government organizations concerned to reduce the extent of global warming. Number 2, to identify the ways of involving members of parliament to interact with specialists of national and international bodies working on global warming and climate change with increased effort to develop new technologies to mitigate global warming. Number 3, to organize seminars, workshops to create awareness about the cause and effect of global warming and climate change among the members of parliament. Number 4, to identify the ways of involving members of parliament to spread awareness to prevent global warming and climate change. Number 5, to undertake such other related tasks as it may deem fit. Parliamentary Forum on Disaster Management. The function of the forum are: number 1, to identify problems relating to disaster management and make suggestions, recommendations for consideration and appropriate action by the government organizations concerned to reduce the effect of disaster. Number 2, to identify the ways of involving members of parliament to interact with specialists of national and international bodies working on disaster management with increased effort to develop new technologies to mitigate the effects of disasters. Number 3, to organize seminars, workshops to create awareness about the causes and effects of disasters among the members of parliament. Number 4, to identify the ways of involving members of parliament to spread awareness about disaster management. Number 5, to undertake such other related tasks as it may deem fit. Parliamentary Forum on Artisans and Craftspeople. The function of the forum are: number 1, to further enhance awareness and attention to parliamentarians towards critical issues affecting artisans and craftspeople so as to preserve and promote traditional art and craft through various mechanisms. Number 2, to provide a platform to parliamentarians to exchange ideas, views, experiences, expertise, and best practices in relation to artisans and craftspeople in a structured manner through workshops, seminars, orientation programs, etc. Number 3, to provide parliamentarians an interface with civil society for highlighting issues related to the craftspeople and artisans, including inter alia, the voluntary sector, media, and corporate sector, and thereby to foster effective strategic partnerships in this regard. Number 4, to enable parliamentarians to interact in an institutionalized manner with representatives of various union ministers, government organizations like Khadi and Village Industry Commission, Choir Board, the Council for Advancement of People's Action and Rural Technology, and other related organizations, bodies. Number 5, to hold comprehensive dialogue and discussions on the matters relating to preservation of art and traditional craft and the promotion of artisans and craftspeople with expert organizations at the national and international levels. Number 6, to undertake any other task, project, assignment, etc. as the forum may deem fit. Parliamentary Forum on Millennium Development Goals. The function of this forum are: number 1, to review and enhance awareness and attention of parliamentarians towards critical issues which have bearing on achievement of goals targets set under Millennium Development Goals by 2015. Number 2, to provide a platform to parliamentarians to exchange ideas, views, experiences, expertise, and best practices in relation to implementation of Millennium Development Goals in a structured manner through workshops, seminars, orientation programs, etc. Number 3, to provide parliamentarians an interface with civil society for highlighting issues related to Millennium Development Goals, that is, eradication of poverty, hunger, achievement of universal primary education, promotion of gender equality and empowerment of women, reduction of child mortality, improving maternal health, combating HIV/AIDS, malaria, and other diseases, ensuring environmental sustainability, and developing a global partnership for development. Number 4, to enable parliamentarians to interact in an institutionalized manner with specialized UN agencies and other comparable multilateral agencies, expert report studies, news and trend analysis, etc. regarding achievement of Millennium Development Goals. Number 5, to undertake any other task, project, assignment, etc. as the forum may deem fit. Chapter 25, Parliamentary Group. Rationale of the group. M.N. Kaul and S.L. Sadekar have nicely explained the rationale of the Indian Parliamentary Group in the following way. The establishment and development of relations among parliaments constitutes part of the regular activities of national parliaments, although promotion of inter-parliamentary relations has for many years been a significant part of the work of parliamentarians. Recently, it has received a new thrust due to the increased interdependence of nations in a global environment. It is imperative that parliamentarians will join hands to safeguard democracy and work in synergy to confront the challenges before the world and convert them into opportunities to facilitate peace and prosperity in their countries as well as globally. Parliamentarians from different parts of the world therefore have a forum where they can meet to discuss and find out solutions to their common problems. It is here that some sort of cross fertilization of ideas can take place not only between the older and the younger parliaments but also between parliamentarians working under different parliamentary systems. These problems are no doubt discussed in intergovernmental conferences. However, those discussions are not so frank and free as they can be at a conclave of legislators. Interparliamentary relations thus assume great importance today when the whole world is beset with many pressing problems. The problems that are faced by one parliament today may confront another tomorrow. It is therefore essential that a link should exist between various parliaments of the world. This link is maintained by India through the exchange of delegations, goodwill missions, correspondence, documents, etc., with foreign parliaments through the machinery of the IPG that act both as the national group of the Inter-Parliamentary Union and also as the Indian branch of Commonwealth Parliamentary Association. Composition of the group. IPG is an autonomous body. It was formed in the year 1949 in pursuance of a motion adopted by the Constituent Assembly Legislative. The membership of IPG is open to all members of Parliament. The former group members of Parliament can also become associate members of the group, but the associate members are entitled to limited rights only. They are not entitled to representation at meetings and conferences of the IPU and the CPA. They are also not entitled to the travel concessions provided to members by certain branches of the CPA. The Speaker of the Lok Sabha is the ex officio president of the group. The Deputy Speaker of the Lok Sabha and the Deputy Chairman of the Rajya Sabha are the ex officio vice presidents of the group. The Secretary General of the Lok Sabha act as the ex officio Secretary General of the group. Objectives of the group. The aims and objects of the group are mentioned below. Number 1. To promote personal contacts between members of the Parliament of India. Number 2. To study questions of public importance that are likely to come up before the Parliament, arrange seminars, discussions and orientation courses and bring out publications for the dissemination of information to the members of the group. Number 3. To arrange lectures on political defense, economic, social and educational problems by the members of the Parliament and distinguished persons. Number 4. To arrange visits to foreign countries with a view to develop contacts with members of other parliaments. Functions of the group. The various functions performed and activities undertaken by the group are as follows. Number 1. The group act as a link between the Parliament of India and the various parliaments of the world. This link is maintained through exchange of delegations, goodwill missions, correspondence, documents, etc. with foreign parliaments. Number 2. The group functions as the national group of the IPU and the main branch of CPA in India. Number 3. Addresses to the members of the Parliament while visiting heads of state and government of foreign countries and talks by eminent persons are arranged under the auspices of the group. Number 4. Seminars and symposia on parliamentary subjects of tropical interest are organized periodically at national as well as international level. Number 5. Members of the group, when visiting abroad, are given letters of introduction to the secretaries of the national groups of the IPU and secretaries of the CPA branches. The Indian missions in the countries of visit are also suitably informed so as to enable them to get assistance and usual courtesies. Number 6. Only those members of the Parliament who are members of the group of at least 6 months standing at the time of the composition of the delegation may be included in the Indian parliamentary delegations to foreign countries. Number 7. An uninterrupted flow of information to members regarding the activities of the group is maintained through the IPG newsletter brought out every quarter. It is sent regularly to all members of the group, including associate members. Number 8. As per decision of the group, an award of outstanding parliamentarian was instituted in the year 1995 to be given annually. A committee of 5 persons, constituted by the Speaker of the Lok Sabha, invites and finalizes the nomination for their board. Number 9. To encourage bilateral relations, the group constitutes parliamentary friendship groups with other countries in the parliament. The aims and objectives of the friendship group are to maintain political, social, and cultural contacts between the two countries and to assist in exchanges of information and experiences on issues relating to parliamentary activities. The group and IPU. The IPU is an international organization of the parliaments of sovereign states. At present, the IPU consists of 153 parliaments of sovereign nations. Its aim is to work for peace and cooperation among peoples and for the firm establishment of representative institutions. It fosters contacts, coordination, and the exchange of experience among parliaments and the parliamentarians of all member countries and contributes to better knowledge of the working of representative institutions. It also expresses its views on all burning questions of international importance for necessary effective implementation of parliamentary actions and suggest avenues for improving the working standard and capacity of international institutions. The main advantage of membership of the group insofar as its functions as the national group of the IPU are concerned are as follows. Number 1. It helped members of Indian parliamentary delegations to develop contacts with the parliamentarians of the member countries of the IPU. Number 2. The events provide an opportunity to study and understand contemporary changes, reforms taking place in various countries of the world. Number 3. It provides facilities to meet parliamentarians in different countries during tours in abroad or in India when visiting parliamentarians are here. Number 4. The members of the group are eligible to visit foreign countries as members of the Indian parliamentary delegations to inter-parliamentary conferences. In the recent past, members of the group have been holding different positions of the IPU, rapporteurs, chairman of drafting committee, etc., and by virtue of the same, the group has been successful in putting forward effectively the viewpoint of India on various important issues dealt in the IPU meetings. The group and CPA. The CPA is an association of about 17,000 Commonwealth parliamentarians spread over 175 national, state, provincial, and territorial parliaments. Its aim are to promote knowledge and understanding of the constitutional, legislative, economic, social, and cultural systems within a parliamentary democratic framework with particular reference to the countries of the Commonwealth of Nations and to countries having close historical and parliamentary associations with it. Its mission is to promote the advancement of parliamentary democracy by enhancing knowledge and understanding of democratic governance and by building an informed parliamentary community able to deepen the Commonwealth's democratic commitment and to further cooperation among its parliaments and legislatures. The main advantage of membership of the group insofar as its function as the main branch of the CPA in India are concerned are as follows. Number 1. Conferences and seminars. Membership provides an opportunity for participation in the plenary and regional conferences, seminars, visits, and exchanges of delegations. Number 2. Publications. All members of the group are entitled to receive free of charge the parliamentarian quarterly and in the newsletter first reading every second month. Number 3. Information. The Parliamentary Information and References Center of the CPA Secretariat provides information to members on parliamentary, constitutional, and Commonwealth matters. Number 4. Introductions. The CPA branches readily assist in arranging introductions for members visiting other jurisdictions. Number 5. Parliamentary facilities. Members visiting other Commonwealth countries are normally accorded parliamentary courtesies, especially access to debates and local members. Number 6. Travel facilities. Some branches provide for a designated number of their members annually to undertake study tours of Commonwealth and other countries to compare political and procedural developments. Other branches arrange and host visits. Chapter 26. Supreme Court. Unlike the American Constitution, the Indian Constitution has established an integrated judicial system with the Supreme Court at the top and the High Courts below it. Under a High Court and below the state level, there is a hierarchy of subordinate courts, that is, district courts and other lower courts. This single system of courts, adopted from the Government of India Act of 1935, enforces both central laws as well as the state laws. In USA, on the other hand, the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. There is thus a double system of courts in USA, one for the center and the other for the states. To sum up, India, although a federal country like a USA, has a unified judiciary and one system of fundamental law and justice. The Supreme Court of India was inaugurated on January 28, 1950. It succeeded the Federal Court of India, established under the Government of India Act of 1935. However, the jurisdiction of the Supreme Court is greater than that of its predecessor. This is because the Supreme Court has replaced the British Privy Council as the highest court of appeal. Article 124 to 147 in Part 5th of the Constitution deal with the organization, independence, jurisdiction, powers, procedures, and so on of the Supreme Court. The Parliament is also authorized to regulate them. Composition and appointment. At present, the Supreme Court consists of 34 judges, 1 Chief Justice, and 33 other judges. In 2019, the Centre notified an increase in the number of Supreme Court judges from 31 to 34, including the Chief Justice of India. This followed the enactment of the Supreme Court Number of Judges Amendment Act 2019. Originally, the strength of the Supreme Court was fixed at 8, 1 Chief Justice and 7 other judges. The Parliament has increased this number of other judges progressively to 10 in 1956, to 13 in 1960, to 17 in 1977, to 25 in 1986, to 30 in 2008, and to 33 in 2019. Appointment of judges. The judges of the Supreme Court are appointed by the President. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Courts he deems necessary. The other judges are appointed by President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Courts are as he deems necessary. The consultation with the Chief Justice is obligatory in the case of appointment of a judge other than Chief Justice. Controversy over consultation. The Supreme Court has given different interpretation of the word consultation in the above provision. In the first judge's case, 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. But in the second judge's case, 1993, the court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. Hence, it ruled that the advice tendered by the Chief Justice of India is binding on the President in the matters of appointment of the judges of the Supreme Court, but the Chief Justice would tender his advice on the matters after consulting 2 of his senior-most colleagues. Similarly, in the third judge's case, 1998, the court opined that the consultation process to be adopted by the Chief Justice of India requires consultation of plurality judges. The sole opinion of the Chief Justice of India does not constitute the consultation process. He should consult a collegium of 4 senior-most judges of the Supreme Court, and even if 2 judges give an adverse opinion, he should not send the recommendation to the government. The court held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. The 99th Constitutional Amendment Act of 2014 and the National Judicial Appointment Commission Act of 2014 have replaced the collegium system of appointing judges to the Supreme Court and High Courts with a new body called the National Judicial Appointment Commission. However, in 2015, the Supreme Court has declared both the 99th Constitutional Amendment as well as the NJAC Act as unconstitutional and void. Consequently, the earlier collegium system became operative again. This verdict was delivered by the Supreme Court in the fourth Judge's Case 2015. The court opined that the new system, that is NJAC, would affect the independence of the judiciary. Appointment of Chief Justice. From 1950 to 1973, the practice has been to appoint the senior-most judge of the Supreme Court as the Chief Justice of India. This established convention was violated in 1973 when A.N. Ray was appointed as the Chief Justice of India by superseding three senior judges. Again in 1977, M.U. Baig was appointed as the Chief Justice of India by superseding the then senior-most judge. The discretion of the government was curtailed by the Supreme Court in the second Judge's Case of 1993, in which the Supreme Court ruled that the senior-most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. Qualifications, oath and salaries. Qualifications of judges. A person to be appointed as a judge of the Supreme Court should have the following qualifications. Number 1, he should be a citizen of India. Number 2, he should have been a judge of a high court or high courts in succession for 5 years, or he should have been an advocate of a high court or high courts in succession for 10 years, or he should be a distinguished jurist in the opinion of the President. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of the Supreme Court. Oath or affirmation. A person appointed as a judge of the Supreme Court before entering upon his office has to make and subscribe an oath or affirmation before the President or some person appointed by him for this purpose. In his oath, a judge of the Supreme Court swears, number 1, to bear true faith and allegiance to the Constitution of India. Number 2, to uphold the sovereignty and integrity of India. Number 3, to duly and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear or favor, affection or ill will. And number 4, to uphold the Constitution and the laws. Salaries and allowances. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency. In 2018, the salary of the Chief Justice was increased from 1 lakh to 2.80 lakh per month, and that of a judge from 19,000 to 2.50 lakh per month. They are also paid sumptuary allowance and provided with free accommodation and other facilities like medical, car, telephone, etc. The retired Chief Justice and judges are entitled to 50% of their last drawn salary as monthly pension. Tenure and removal. Tenure of judges. The Constitution has not fixed the tenure of a judge of the Supreme Court. However, it makes the following three provisions in this regard. Number 1, he holds office until he attains the age of 65 years. Any question regarding his age is to be determined by such authority and in such manner as provided by Parliament. Number 2, he can resign his office by writing to the President. Number 3, he can be removed from his office by the President on the recommendation of the Parliament. Removal of judges. A judge of the Supreme Court can be removed from his office by an order of the President. The President can issue the removal order only after an address by Parliament has been presented to him in the same session for such removal. The address must be supported by a special majority of each House of Parliament, that is, a majority of the total membership of that House and a majority of not less than 2/3 of the members of that House present and voting. The grounds of removal are to proved misbehavior and incapacity. The Judges Inquiry Act of 1968 regulates the procedure relating to the removal of a judge of the Supreme Court by the process of impeachment. Number 1. A removal motion signed by 100 members in the case of Lok Sabha or 50 members in the case of Rajya Sabha is to be given to the Speaker or Chairman. Number 2. The Speaker or Chairman may admit the motion or refuse to admit it. Number 3. If it is admitted, then the Speaker or Chairman is to constitute a three-member committee to investigate into the charges. Number 4. The committee should consist of the Chief Justice or a judge of the Supreme Court, a Chief Justice of a High Court, and a distinguished jurist. Number 5. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. Number 6. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. Number 7. Finally, the President passes an order removing the judge. It is interesting to know that no judge of the Supreme Court has been impeached so far. The first case of impeachment is that of Justice V. Ramaswamy of the Supreme Court, 1991 to 93. Though the inquiry committee found him guilty of misbehavior, he could not be removed as the impeachment motion was defeated in the Lok Sabha. The Congress party abstained from voting. Acting ad hoc and retired judges. Acting Chief Justice. The President can appoint a judge of the Supreme Court as an acting Chief Justice of India when Number 1. The office of Chief Justice of India is vacant. Number 2. The Chief Justice of India is temporarily absent. Number 3. The Chief Justice of India is unable to perform the duties of his office. Ad hoc judge. When there is a lack of quorum of the permanent judges to hold or continue any session of the Supreme Court, the Chief Justice of India can appoint a judge of a High Court as an ad hoc judge of the Supreme Court for a temporary period. He can do so only after consultation with the Chief Justice of the High Court concerned and with the previous consent of the President. The judges so appointed should be qualified for appointment as a judge of the Supreme Court. It is the duty of the judge so appointed to attend the sittings of the Supreme Court in priority to other duties of his office. While so attending, he enjoys all the jurisdiction, powers, and privileges and discharges the duties of a judge of the Supreme Court. Retired judge. At any time, the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a High Court who is duly qualified for appointment as a judge of the Supreme Court to act as a judge of the Supreme Court for a temporary period. He can do so only with the previous consent of the President and also of the person to be so appointed. Such a judge is entitled to such allowances as the President may determine. He will also enjoy all the jurisdiction, powers, and privileges of a judge of a Supreme Court, but he will not otherwise be deemed to be a judge of the Supreme Court. Seat and procedure. Seat of Supreme Court. The Constitution declares Delhi as the seat of the Supreme Court, but it also authorizes the Chief Justice of India to appoint other place or places as seat of the Supreme Court. He can take decision in this regard only with the approval of the President. This provision is only optional and not compulsory. This means that no court can give any direction either to the President or to the Chief Justice to appoint any other place as a seat of the Supreme Court. Procedure of the Court. The Supreme Court can, with the approval of the President, make rules for regulating generally the practice and procedure of the court. The constitutional cases or references made by the President under Article 143 are decided by a bench consisting of at least 5 judges. All other cases are decided by single judges and division benches. The judgments are delivered by the open court. All judgments are by majority vote, but if differing, then judges can give dissenting judgment or opinions. Independence of Supreme Court. The Supreme Court has been assigned a very significant role in the Indian democratic political system. It is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and guardian of the Constitution. Therefore, its independence becomes very essential for the effective discharge of the duties assigned to it. It should be free from encroachments, pressures, and interferences of the Executive, Council of Ministers, and the Legislature, Parliament. It should be allowed to do justice without fear or favor. The Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court. Number 1. Mode of appointment. The judges of the Supreme Court are appointed by the President, which means the Cabinet, in consultation with the members of the judiciary itself, that is, judges of the Supreme Court and the High Courts. This provision curtails the absolute discretion of the executive as well as ensures that the judicial appointments are not based on any political or practical considerations. Number 2. Security of tenure. The judges of the Supreme Court are provided with the security of tenure. They can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. This means that they do not hold their office during the pleasure of the President, though they are appointed by him. This is obvious from the fact that no judge of the Supreme Court has been removed or impeached so far. Number 3. Fixed service conditions. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be changed to their disadvantage after their appointment except during a financial emergency. Thus, the conditions of service of the judges of the Supreme Court remain same during their term of office. Number 4. Expenses charged on consolidated fund. The salaries, allowances, and pensions of the judges and the staff, as well as the all administrative expenses of the Supreme Court, are charged on the Consolidated Fund of India. Thus, they are non-votable by the Parliament, though they can be discussed by it. Number 5. Conduct of judges cannot be discussed. The Constitution prohibits any discussion in Parliament or in a state legislature with respect to the conduct of the judges of the Supreme Court in the discharge of their duties, except when an impeachment motion is under consideration of the Parliament. Number 6. Ban on practice after retirement. The retired judges of the Supreme Court are prohibited from pleading or acting in any court or before any authority within the territory of India. This ensures that they do not favor anyone in the hope of future favor. Number 7. Power to punish for its contempt. The Supreme Court can punish any person for its contempt. Thus, its actions and decisions cannot be criticized and opposed by anybody. This power is vested in the Supreme Court to maintain its authority, dignity, and honor. Number 8. Freedom to appoint its staff. The Chief Justice of India can appoint officers and servants of the Supreme Court without any interference from the executive. He can also prescribe their conditions of service. Number 9. Its jurisdiction cannot be curtailed. The Parliament is not authorized to curtail the jurisdiction and powers of the Supreme Court. The Constitution has guaranteed the Supreme Court jurisdiction of various kinds. However, the Parliament can extend the same. Number 10. Separation from executive. The Constitution directs the state to take steps to separate the judiciary from the executive in the public services. This means that the executive authorities should not possess the judicial powers. Consequently, upon its implementation, the role of executive authorities in judicial administration came to an end. Jurisdiction and powers of Supreme Court. The Constitution has conferred a very extensive jurisdiction and vast powers on the Supreme Court. It is not only a federal court like the American Supreme Court, but also a final court of appeal like the British House of Lords, the upper house of the British Parliament. It is also the final interpreter and guardian of the Constitution and guarantor of the fundamental rights of the citizens. Further, it has advisory and supervisory powers. Therefore, Aladi Krishnaswamy Iyer, a member of the drafting committee of the Constitution, rightly remarked, the Supreme Court of India has more power than any other Supreme Court in any part of the world. The jurisdiction and powers of the Supreme Court can be classified into the following. Number 1. Original jurisdiction. Number 2. Writ jurisdiction. Number 3. Appellate jurisdiction. Number 4. Advisory jurisdiction. Number 5. A court of record. Number 6. Power of judicial review. Number 7. Constitutional interpretation. Number 8. Other powers. Number 1. Original jurisdiction. As a federal court, the Supreme Court decides the disputes between different units of the Indian Federation. More elaborately, any dispute between the center and one or more states between the center and any state or states on one side and one or more other states on the other side, between two or more states. In the above federal disputes, the Supreme Court has exclusive original jurisdiction. Exclusive means no other court can decide such disputes, and original means the power to hear such disputes in the first instance, not by way of appeal. With regard to the exclusive original jurisdiction of the Supreme Court, 2 points should be noted. 1. The dispute must involve a question, whether of law or fact, on which the existence or extent of a legal right depends. Thus, the questions of political nature are excluded from it. 2. Any suit brought before the Supreme Court by a private citizen against the center or a state cannot be entertained under this. Further, this jurisdiction of the Supreme Court does not extend to the following: A. A dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, senet, or any other similar instrument. B. A dispute arising out of any treaty, agreement, etc., which specifically provides that the said jurisdiction does not extend to such a dispute. C. Interstate water dispute. D. Matters referred to the Finance Commission. E. Adjustment of certain expenses and pensions between the center and the state. F. Ordinary dispute of commercial nature between the center and the state. G. Recovery of damages by a state against the center. In 1961, the first suit under the original jurisdiction of the Supreme Court was brought by West Bengal against the center. The state government challenged the constitutional validity of the coal-bearing areas Acquisition and Development Act 1957 passed by the Parliament. However, the Supreme Court dismissed the suit by upholding the validity of the Act. Number 2. Writ jurisdiction. The Constitution has constituted the Supreme Court as the guarantor and defender of the fundamental rights of the citizens. The Supreme Court is empowered to issue writs including habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of the fundamental rights of an aggrieved citizen. In this regard, the Supreme Court has original jurisdiction in the sense that an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. However, the writ jurisdiction of the Supreme Court is not exclusive. The High Court are also empowered to issue writs for the enforcement of the fundamental rights. It means when the fundamental right of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Therefore, the original jurisdiction of the Supreme Court with regard to federal disputes is different from its original jurisdiction with regard to dispute relating to fundamental rights. In the first cases, it is exclusive, and in the second case, it is concurrent with High Court jurisdiction. Moreover, the parties involved in the first case are units of the federation, center and state, while the dispute in the second case is between a citizen and the government, central or state. There is also a difference between the writ jurisdiction of the Supreme Court and that of the High Court. The Supreme Court can issue writs only for the enforcement of the fundamental rights and not for other purposes. The High Court, on the other hand, can issue writs not only for the enforcement of the fundamental rights but also for other purposes. It means that the writ jurisdiction of the High Court is wider than that of Supreme Court, but the Parliament can confer on the Supreme Court the power to issue writs for other purposes also. Number 3. Appellate jurisdiction. As mentioned earlier, the Supreme Court has not only succeeded the Federal Court of India but also replaced the British Privy Council as the highest court of appeal. The Supreme Court is primarily a court of appeal and hears appeals against the judgments of the lower courts. It enjoys a wide appellate jurisdiction which can be classified under 4 heads. Number 1. Appeals in constitutional matters. Number 2. Appeals in civil matters. Number 3. Appeals in criminal matters. Number 4. Appeals by special leave. Number 1. Constitutional matters. In the constitutional cases, an appeal can be made to the Supreme Court against the judgment of a High Court if the High Court certifies that the case involves a substantial question of law that requires the interpretation of the Constitution. Based on the certificate, the party in the case can appeal to the Supreme Court on the ground that the question has been wrongly decided. Number 2. Civil matters. In civil cases, an appeal lies to the Supreme Court from any judgment of a High Court if the High Court certifies that the case involves a substantial question of law of general importance, that the question needs to be decided by the Supreme Court. Originally, only those civil cases that involved a sum of rupees 20,000 could be appealed before the Supreme Court, but this monetary limit was removed by the 30th Constitutional Amendment Act of 1972. Criminal matters. The Supreme Court hears appeals against the judgment in a criminal proceedings of a High Court if the High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to death, has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to the death, certifies that the case is a fit one for appeal to the Supreme Court. In the first two cases, an appeal lies to the Supreme Court as a matter of right, that is, without any certificate of the High Court. But if the High Court has reversed the order of conviction and has ordered the acquittal of the accused, there is no right to appeal to the Supreme Court. In 1970, the Parliament had enlarged the criminal appellate jurisdiction of the Supreme Court. Accordingly, an appeal lies to the Supreme Court from the judgment of a High Court if the High Court has an appeal reversed an order of acquittal of an accused person and sentenced him to imprisonment for life or for 10 years, has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to imprisonment for life or for 10 years. Further, the appellate jurisdiction of the Supreme Court extends to all civil and criminal cases in which the Federal Court of India had jurisdiction to hear appeals from the High Court but which are not covered under the civil and criminal appellate jurisdiction of the Supreme Court mentioned above. Appeal by special leave. The Supreme Court is authorized to grant in its discretion special leave to appeal from any judgment in any matter passed by any court or tribunal in the country except military tribunal and court martial. This provision contains the four aspects as under. Number 1. It is a discretionary power and hence cannot be claimed as a matter of right. Number 2. It can be granted in any judgment, whether final or interlocutory. Number 3. It may be related to any matter constitutional, civil, criminal, income tax, labor, revenue, advocates, etc. Number 4. It can be granted against any court of tribunal and not necessarily against a high court, of course, except a military court. Thus, the scope of this provision is very wide and it vests with the Supreme Court with a plenary jurisdiction to hear appeals. On the exercise of this power, the Supreme Court itself held that, being an exceptional and overriding power, it has to be exercised sparingly and win caution and only in special extraordinary situations. Beyond that, it is not possible to fetter the exercise of this power by any set formula or rule. Number 4. Advisory jurisdiction. The Constitution under Article 143 authorizes the President to seek the opinion of the Supreme Court in the two categories of matters. Number 1. On any question of law or fact of public importance which has arisen or which is likely to arise. Number 2. On any dispute arising out of any pre-constitutional treaty, agreement, covenant, engagement, senate, or any other similar instruments. In the first case, the Supreme Court may tender or may refuse to tender its opinion to the President. But in the second case, the Supreme Court must tender its opinion to the President. In both the cases, the opinion expressed by the Supreme Court is only advisory and not a judicial pronouncement. Hence, it is not only binding on the President, he may follow or may not follow the opinion. However, it facilitates the government to have an authoritative legal opinion on a matter to be decided by it. So far, 2019, the President has made 15 references to the Supreme Court under its advisory jurisdiction, also known as consultative jurisdiction. These are mentioned below in the chronological order. Number 1. Delhi Laws Act in 1951. Number 2. Kerala Education Bill in 1958. Number 3. Berubari Union Case in 1960. Number 4. Sea Custom Act in 1963. Number 5. Kesav Singh's case relating to the privileges of the legislature in 1964. Number 6. Presidential election in 1974. Number 7. Special Courts Bill in 1978. Number 8. Jammu and Kashmir Resettlement Act in 1982. Number 9. Cauvery Water Dispute Tribunal in 1992. 10. Rama Janmabhoomi case in 1993. 11. Consultation process to be adopted by the Chief Justice of India in 1998. Number 12. Legislative competence of the centre and states on the subjects of natural gas and liquefied natural gas in 2001. Number 13. The constitutional validity of the Election Commission's decision on deferring the Gujarat Assembly elections in 2002. Number 14. Punjab Termination of Agreement Act in 2004. Number 15. 2G Spectrum Case Verdict and the mandatory auctioning of natural resources across all sectors in 2012. Number 5. A Court of Record. As a court of record, the Supreme Court has two powers. Number 1. The judgment proceedings and act of the Supreme Court are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any court. They are recognized as legal precedents and legal references. Number 2. It has power to punish for contempt of court either with simple imprisonment for a term up to 6 months or with fine up to Rs 2,000 or with both. In 1991, the Supreme Court has ruled that it has power to punish for contempt not only of itself but also of high courts, subordinate courts and tribunals functioning in the entire country. Contempt of court may be civil or criminal. Civil contempt means willful disobedience to any judgment, order, writ, or other process of a court, or willful breach of an undertaking given to a court. Criminal contempt means the publication of any matter or doing an act which scandalizes or lowers the authority of a court or prejudices and interferes with the due course of a judicial proceeding, interferes or obstructs the administration of justice is in any other matter. However, innocent publication and distribution of some matter, fair and accurate report of judicial proceedings, fair and reasonable criticisms of judicial act, and comment on the administrative side of the judiciary do not amount to contempt of court. Number 6. Power of judicial review. Judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactment and executive orders of both the central and state governments. On examination, if they are found to be violative of the Constitution, ultra vires, they can be declared as illegal, unconstitutional, and invalid, rule and void by the Supreme Court. Consequently, they cannot be enforced by the government. Number 7. Constitutional interpretation. The Supreme Court is the ultimate interpreter of the Constitution. It can give final version to the spirit and content of the provisions of the Constitution and the verbiage used in the Constitution. While interpreting the Constitution, the Supreme Court is guided by a number of doctrines. In other words, the Supreme Court applies various doctrines in interpreting the Constitution. The important doctrines are mentioned below. Number 1. Doctrine of severability. Number 2. Doctrine of waiver. Number 3. Doctrine of eclipse. Number 4. Doctrine of territorial nexus. Number 5. Doctrine of pith and substance. Number 6. Doctrine of colorable legislation. Number 7. Doctrine of implied powers. Number 8. Doctrine of incidental and ancillary powers. Number 9. Doctrine of precedent. Number 10. Doctrine of occupied fields. Number 11. Doctrine of prospective overruling. Number 12. Doctrine of harmonious construction. Number 13. Doctrine of liberal interpretation. Number 8. Other powers. Besides the above, the Supreme Court has numerous other powers. A. It decides the dispute regarding the election of the President and the Vice President. In this regard, it has the original, exclusive and final authority. B. It inquires into the conduct and behavior of the chairman and members of the Union Public Service Commission on a reference made by the President. If it finds them guilty of misbehavior, it can recommend to the President for their removal. The advice tendered by the Supreme Court in this regard is binding on the President. C. It has power to review its own judgment and order. Thus, it is not bound by its previous decision and can depart from it in the interest of justice or community welfare. In brief, The Supreme Court is a self-correcting agency. For example, in the Keshwanand Bharti case of 1973, the Supreme Court departed from its previous judgment in the Golaknath case of 1967. D. It is authorized to withdraw the cases pending before the High Courts and dispose them by itself. It can also transfer a case or appeal pending before one High Court to another High Court. E. Its law is binding on all courts in India. Its decree or order is enforceable throughout the country. All authorities, civil and judicial, in the country should act in aid of the Supreme Court. F. It has power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory of the country. The Supreme Court's jurisdiction and powers with respect to matters in the Union list can be enlarged by the Parliament. Further, its jurisdiction and powers with respect to other matters can be enlarged by a special agreement of the centre and the state. Supreme Court advocates. Three categories of advocates are entitled to practice law before the Supreme Court. They are: number 1, senior advocates. These are advocates who are designated as senior advocates by the Supreme Court of India or by any high court. The court can designate any advocate with his consent as senior advocate if, in its opinion, by virtue of his ability, standing at the bar, or special knowledge or experience in law, the said advocate is deserving of such distinction. A senior advocate is not entitled to appear without an advocate on record in the Supreme Court or without a junior in any other court or tribunal in India. He is also not entitled to accept instructions to draw pleadings or affidavits, advise on evidences, or do any drafting work of any analogous kind in any court or tribunal in India, or undertake conveyancing work of any kind whatsoever, but this prohibition shall not extend to setting any such matter as aforesaid in consultation with a junior. Number 2. Advocates on record. Only these advocates are entitled to file any matter or document before the Supreme Court. They can also file an appearance or act for a party in the Supreme Court. Number 3. Other advocates. These are advocates whose names are entered on the roll of any state bar council maintained under the Advocate Act 1961, and they can appear and argue any matter on behalf of a party in the Supreme Court, but they are not entitled to file any document or matter before the court. Comparing Indian and American Supreme Court. Number 1. Indian Supreme Court original jurisdiction is confined to federal cases, while American Supreme Court's original jurisdiction covers not only federal cases but also cases relating to naval forces, maritime activities, ambassadors, etc. Number 2. Indian Supreme Court's appellate jurisdiction covers constitutional, civil, and criminal cases, while American Supreme Court's appellate jurisdiction is confined to constitutional cases only. Number 3. Indian Supreme Court has a very wide discretion to grant special leave to appeal in any matter against the judgment of any court or tribunal except military, while American Supreme Court has no such plenary power. Number 4. Indian Supreme Court has advisory jurisdiction, while American Supreme Court has no advisory jurisdiction. Number 5. Indian Supreme Court scope of judicial review is limited, while in American Supreme Court scope of judicial review is very wide. Number 6. Indian Supreme Court defends right of the citizen according to the procedure established by law, while American Supreme Court defends rights of the citizen according to the due process of law. Number 7. Indian Supreme Court's jurisdiction and powers can be enlarged by Parliament, while American Supreme Court's jurisdiction and powers are limited to that conferred by the Constitution. Number 8. Indian Supreme Court has power of judicial superintendence and control over state high courts due to integrated judicial system, while American Supreme Court has no such power due to double or separated judicial system. 27. Judicial Review. The doctrine of judicial review originated and developed in the USA. It was propounded for the first time in the famous case of Marbury versus Madison 1803 by John Marshall, the then Chief Justice of the American Supreme Court. In India, on the other hand, The Constitution itself confers the power of judicial review on the judiciary, both the Supreme Court as well as High Courts. Further, the Supreme Court has declared the power of judicial review as a basic feature of the Constitution or an element of the basic structure of the Constitution. Hence, the power of judicial review cannot be curtailed or excluded even by a constitutional amendment. Meaning of judicial review. Judicial review is the power of the judiciary to examine the constitutionality of legislative enactments and executive orders of both the central and state governments. On examination, if they are found to be violative of the constitution, ultra vires, they can be declared as illegal, unconstitutional, and invalid, null and void by the judiciary. Consequently, they cannot be enforced by the government. Justice Saeed Shah Muhammad Qadri has classified the judicial review into the following three categories. Number 1. Judicial review of constitutional amendments. Number 2. Judicial review of legislation of the parliament and state legislatures and subordinate legislations. Number 3. Judicial review of administrative action of the union and the state and authorities under the state. The Supreme Court used the power of judicial review in various cases, as for example, the Golaknath case 1967, the bank nationalization case 1970, the Privy Purses abolition case 1971, the Keshwanand Bharti case 1973, the Minerva Mills case 1980, and so on. In 2015, the Supreme Court declared both the 99th Constitutional Amendment 2014 and the National Judicial Appointment Commission Act 2014 as unconstitutional and null and void. Importance of judicial review. Judicial review is needed for the following reasons. A. To uphold the principle of the supremacy of the Constitution. B. To maintain federal equilibrium, balance between the center and the states. C. To protect the fundamental rights of the citizens. In a number of cases, the Supreme Court has pointed out the significance of the power of judicial review in our country. Some of the observations made by it in this regard are given below. In India, it is the Constitution that is supreme, and that a statute law to be valid must be in conformity with the constitutional requirements, and it is for the judiciary to decide whether any enactment is constitutional or not. Our Constitution contains express provisions for judicial review of legislation as to its conformity with the Constitution. This is especially true as regards the fundamental rights to which the court has been assigned the role of sentinel on the qui viva. As long as some fundamental rights exist and are a part of the Constitution, the power of judicial review has also to be exercised with a view to see that the guarantees afforded by these rights are not contravened. The Constitution is supreme lex, the permanent law of the land, and there is no branch of government above it. Every organ of government, be it the executive or the legislature of the judiciary, derives its authority from the Constitution, and it has to act within the limits of its authority. No one, however highly placed, and no authority, howsoever lofty, can claim that it shall be the sole judge of the extent of its power under the Constitution, or whether its action is within the confines of such power laid down by the Constitution. This court is the ultimate interpreter of the Constitution, and to this court is assigned the delicate task of determining what is the power conferred on each branch of government, whether it is limited, and if so, what are the limits, and whether any action of that branch transgress such limits. It is the function of the judges, may their duty, to pronounce upon the validity of laws. If courts are totally deprived of the power, the fundamental rights conferred on the people will become a mere adornment, because rights without remedies are as writ in water. A controlled constitution will then become uncontrolled. The judges of the Supreme Court have been entrusted with the task of upholding the Constitution, and to this end have been conferred the power to interpret it. It is they who have to ensure that the balance of power inviolate by the Constitution is maintained, and that the legislature and the executive do not, in the discharge of their functions transgress constitutional limitations. The founding fathers very wisely therefore incorporated in the constitution itself the provision of judicial review so as to maintain the balance of federalism, to protect the fundamental rights and fundamental freedoms guaranteed to the citizens, and to afford a useful weapon for availability, availment, and enjoyment of equality, liberty, and fundamental freedoms, and to help to create a healthy nationalism. The function of judicial review is a part of the constitutional interpretation itself. It adjusts the constitution to meet new conditions and needs of the time. Constitutional provisions for judicial review. Though the phrase judicial review has nowhere been used in the Constitution, the provisions of several articles explicitly confer the power of judicial review on the Supreme Court and the High Courts. These provisions are explained below. Number 1. Article 13 declares that all laws that are inconsistent with or in derogation of the fundamental rights shall be null and void. Number 2. Article 32 guarantees the right to move the Supreme Court for the enforcement of the fundamental rights and empowers the Supreme Court to issue directions or orders or writs for that purpose. Number 3. Article 131 provides for the original jurisdiction of the Supreme Court in center-state and interstate dispute. Number 4. Article 132 provides for the appellate jurisdiction of the Supreme Court in constitutional cases. Number 5. Article 133 provides for the appellate jurisdiction of the Supreme Court in civil cases. Number 6. Article 134 provides for the appellate jurisdiction of the Supreme Court in criminal cases. Number 7. Article 134A deals with the certificate for appeal to the Supreme Court from the High Courts. Number 8. Article 135 empowers the Supreme Court to exercise the jurisdiction and powers of the Federal Court under any pre-constitution law. Number 9. Article 136 authorizes the Supreme Court to grant special leave to appeal from any court or tribunal except military tribunal and court-martial. Number 10. Article 143 authorizes the President to seek the opinion of the Supreme Court on any question of law or fact and on any pre-constitution legal matters. Number 11. Article 226 empowers the High Courts to issue directions or orders or writs for the enforcement of the fundamental rights and for any other purpose. Number 12. Article 227 vests in the High Courts the power of superintendence over all courts and tribunals within their respective territorial jurisdictions except military courts or tribunals. Number 13. Article 245 deals with the territorial extent of laws made by Parliament and by the legislatures of a state. Number 14. Article 246 deals with the subject matter of laws made by Parliament and by the legislature of a state, that is, Union List, State List, and Concurrent List. Number 15. Article 251 and 254 provide that in case of a conflict between the central law and the state law, the central law prevails over the state law and the state law shall be void. Number 16. Article 372 deals with the continuance in force of the pre-constitution laws. Scope of judicial review. The constitutional validity of a legislative enactment or an executive order can be challenged in the Supreme Court or in the High Courts on the following three grounds. A. It infringes the fundamental right under Part 3rd. B. It is outside the competence of the authority which has framed it. C. It is repugnant to the constitutional provisions. From the above, it is clear that the scope of judicial review in India is narrower than what exists in the USA. Though the American Constitution does not explicitly mention the concept of judicial review in any of its provisions, this is because the American Constitution provides for due process of law against that of procedure established by law, which is contained in the Indian Constitution. The difference between the two is the due process of law gives wide scope of the Supreme Court to grant protection to the rights of its citizens. It can declare laws violative of these rights void not only on substantive grounds of being unlawful but also on procedural grounds of being unreasonable. Our Supreme Court, while determining the constitutionality of a law, however, examines only the substantive question, that is, whether the law is within the powers of the authority concerned or not. It is not expected to go into the question of its reasonableness, suitability, or policy implications. The exercise of wide power of judicial review by the American Supreme Court in the name of due process of law clause has made the critics to describe it as a third chamber of the legislature, a super legislature, the arbiter of social policy, and so on. This American principle of judicial supremacy is also recognized in our constitutional system, but to a limited extent. Nor do we fully follow the British principle of parliamentary supremacy. There are many limitations on the sovereignty of parliament in our country, like the written character of the constitution, the federalism with division of powers, the fundamental rights, and the judicial review. In effect, what exists in India is a synthesis of both, that is, the American principle of judicial supremacy and the British principle of parliamentary supremacy. Judicial review of the ninth schedule. Article 31B saves the Act and regulations included in the ninth schedule from being challenged and invalidated on the ground of contravention of any of the fundamental rights. Article 31B, along with the ninth schedule, was added by the First Constitutional Amendment Act of 1951. Originally, in 1951, the ninth schedule contains only 13 Act and regulations, but at present, in 2016, their number is 282. Of these, the Act and Regulations of the state legislature deals with land reforms and abolition of the Jamidari system, and that of the parliament deal with other matters. However, in a significant judgment delivered in I.R. Coelho case 2007, the Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the ninth schedule. The court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the ninth schedule. It said that the laws placed under the ninth schedule after April 24, 1973 are open to challenge in court if they violated fundamental rights guaranteed under the Article 14, 15, 19 and 21 or the basic structure of the Constitution. It was on April 24, 1973 that the Supreme Court first propounded the doctrine of basic structure or basic features of the Constitution to its landmark verdict in the Keshwanand Bharti case. While delivering the above judgment, the Supreme Court made the following conclusions. Number 1. A law that abrogates or abridges rights guaranteed by Part 3rd of the Constitution may violate the basic structure doctrine or it may not. If former is the consequence of law, whether by an amendment of any article of Part 3rd or by an insertion in the ninth schedule, such law will have to be invalidated in the exercise of judicial review power of court. The constitutional validity of the ninth schedule laws on the touchstone of basic structure doctrine can be adjudged by applying the direct impact and effect test, that is right test, which means the form of an amendment is not the relevant factor but the consequence thereof would be the determinative factor. 2. The majority judgment in the Keshwanand Bharti case, read with Indira Gandhi case, requires the validity of each new constitutional amendment to be judged on its own merits. The actual effect and impact of the law on the rights guaranteed under Part 3rd has to be taken into account for determining whether or not it destroys basic structure. The impact test would determine the validity of the challenge. Number 3. All amendments to the Constitution made on or after 24th April 1973 by which the ninth schedule is amended by inclusion of various laws therein shall have to be tested on the touchstone of the basic or essential features of the Constitution as reflected in Article 21, read with Articles 14 and 19 and the principles underlying them. To put it differently, even though an act is put in the ninth schedule by a constitutional amendment, its provision would be open to attack on the ground that they destroy or damage the basic structure if the fundamental right or rights taken away or abrogated pertains or pertain to the basic structure. Number 4. Justification for conferring protection, not blanket protection, on the laws included in the 9th schedule by constitutional amendments shall be a matter of constitutional adjudication by examining the nature and extent of infraction of a fundamental right by a statute sought to be constitutionally protected and on the touchstone of the basic structure doctrine as reflected in Article 21, read with Articles 14 and 19 by application of the right test and essence of the right test, taking the synoptic view of the articles in Part 3rd as held in the Indira Gandhi case. 16. Applying the above test to 9th schedule, if infraction affects the basic structure, then such a law or laws will not get the protection of the 9th schedule. When the triangle of Article 21 read with Article 14 and 19 is sought to be eliminated, not only the essence of the right test but also the right test has to apply. There is also a difference between the right test and the essence of the right test. Both form part of the application of the basic structure doctrine. When in a controlled constitution conferring limited power of amendment, an entire chapter is made inapplicable, the essence of the right test as applied in Nagaraj case will have no applicability. In such a situation, to judge the validity of the law, it is the right test which is more appropriate. Number 5. If the validity of any 9th schedule law has already been upheld by this court, it would not be open to challenge such law again on the principles declared by this judgment. However, if a law held to be violative of any rights in Part 3rd is subsequently incorporated in the 9th schedule after 24th April 1973, such a violation infraction shall be open to challenge on the ground that it destroys or damages the basic structure as indicated in Article 21, read with Articles 14 and 19 and the principles underlying them. Number 6. Action taken and transactions finalized as a result of the Impugnus Act shall not be open to challenge. 28. Judicial activism. The concept of judicial activism originated and developed in the USA. This term was first coined in 1947 by Arthur Schlesinger Jr., an American historian and educator. In India, the doctrine of judicial activism was introduced in mid 1970s. Justice V.R. Krishna Iyer, Justice P.N. Bhagwati, Justice O. Chinnappa Reddy, and Justice D.A. Desai led the foundation of judicial activism in the country. Meaning of judicial activism. Judicial activism denotes the proactive role played by the judiciary in the protection of the rights of citizens and in the promotion of justice in the society. In other words, it implies the assertive role played by the judiciary to force the other two organs of the government, legislature and executive, to discharge their constitutional duties. Judicial activism is also known as judicial dynamism. It is the antithesis of judicial restraint, which means the self control exercised by the judiciary. Judicial activism is defined in the following way. Number 1. Judicial activism is a way of exercising judicial power that motivates judges to depart from normally practiced strict adherence to judicial precedent in favor of progressive and new social policies. It is commonly marked by decision calling for social engineering, and occasionally these decision represents intrusion in the legislative and executive matters. Number 2. Judicial activism is the practice in the judiciary of protecting or expanding individual rights through decisions that depart from established precedent or are independent of or in opposition of supposed constitutional or legislation intent. Number 3. Judicial activism can be defined as the process of law making by judges. It means an active interpretation of existing legislation by a judge made with a view to enhance the utility of that legislation for social betterment. Judicial activism is different from judicial permission, which means interpretation of existing provisions of law without an attempt to enhance its beneficial aspect. Number 4. Judicial activism is a philosophy of judicial decision making whereby judges allow their personal views about public policy, among other factors, to guide their decisions. Number 5. Judicial activism is a procedure to evolve new principles, concepts, maxims, formulae, and relief to do justice or to expand the standing of the litigant and open the door of courts for needy or to entertain litigation affecting the entire society or a section of it. The concept of judicial activism is closely related to the concept of public interest litigation. It is the judicial activism of the Supreme Court which is the major factor for the rise of PIL. In other words, PIL is an outcome of judicial activism. In fact, PIL is the most popular form or manifestation of judicial activism. Judicial review and judicial activism. The concept of judicial review and judicial activism are closely related to each other, but there is a difference between them. The following points bring out this difference. Number 1. Since about the mid 20th century, a version of judicial review has acquired the nickname of judicial activism, especially in the USA. In India, the participants in the debate mix up judicial activism with judicial review. The former is that with a form of latter in which judges participate in law making policies that is not only uphold or invalidate laws in terms of constitutional provisions but also exercise their policy preferences in doing so. Number 2. The concept of judicial activism is inherent in judicial review, which empowers the court to uphold the Constitution and declare the laws and action inconsistent with the Constitution as void. Judicial activism is necessary for ensuring proper discharge of duties by other organs. Number 3. The term judicial activism came into currency sometime in the 20th century to describe the act of judicial legislation, that is, judges making positive law. However, there is no standard definition of the term judicial activism. As a whole, it can be said that judicial activism stresses the importance of judicial review and a powerful judiciary in the protection and promotion of certain core rights. Number 4. The expanded concept of locus standi in connection with PIL by judicial interpretation from time to time has expanded the jurisdictional limits of the courts exercising judicial review. This expanded role has been given the title of judicial activism by those who are critical of this expanded role of the judiciary. Number 5. Judicial activism as regards constitutional cases falls under the rubric of what is commonly called judicial review, and at the broadcast level it is on any occasion where a court intervenes and strikes down a piece of duly enacted legislation. Justification of judicial activism. According to Dr. B.L. Badera, the reason of judicial activism are as follows. Number 1. There is near collapse of the responsible government when the legislature and executive fail to discharge their respective functions. This results in erosion of the confidence in the constitution and democracy amongst the citizens. Number 2. The citizen of the country look up to judiciary for the protection of their right and freedoms. This leads to tremendous pressure on judiciary to step in aid for the suffering masses. Number 3. Judicial enthusiasm, that is, the judges like to participate in the social reforms that take place in the changing times. It encourages the public interest litigation and liberalizes the principle of locus standi. Number 4. Legislative vacuum, that is, there may be certain areas which have not been legislated upon. It is therefore upon court to indulge in judicial legislation and to meet the changing social needs. Number 5. The Constitution of India has itself adopted certain provisions which gives judiciary enough scope to legislate or to play an active role. Similarly, Subhas Kashyap observes that certain eventualities may be conceived when the judiciary may have to overstep its normal jurisdiction and intervene in areas otherwise falling within the domain of the legislature and the executive. Number 1. when the legislature fails to discharge its responsibilities. Number 2. In case of a hunger legislature, when the government it provides a weak, insecure and busy only in the struggle for survival and therefore unable to take any decision which displeases any caste, community or other group. Number 3. Those in power may be afraid of taking honest and hard decisions for fear of losing power and for that reason may have public issues referred to court as issues of law and order to mark time and delay decisions or to pass on the odium of strong decision making to the courts. Number 4. Where the legislature and the executive fail to protect the basic right of citizens like the right to live a decent life, healthy surroundings or to provide honest, efficient and just system of laws and administration. Number 5. Where the court of law is misused by a strong authoritarian parliamentary party government for ulterior motives as was sought to be done during the emergency aberration. Number 6. Sometimes the courts themselves knowingly or unknowingly become victims of human all too human by weakness of craze for populism, publicity, playing to the media and hogging the headlines. According to Dr. Vandana, the concept of judicial activism can be seen to be reflecting from the following trends, namely, number 1, expansion of rights of hearing in the administrative process, number 2, excessive delegation without limitation, number 3, expansion of judicial control over discretionary powers, number 4, expansion of judicial review over the administration, number 5, promotion of open government, number 6, indiscriminate exercise of contempt power. Number 7. Exercise of jurisdiction when none exist. Number 8. Overextending the standard rules of interpretation in its search to achieve economic, social, and educational objective. Number 9. Passing of orders which are per se unworkable. Activators of judicial activism. Upendra Bakshi, an eminent jurist, has delineated the following typology of social human rights activists who activated judicial activism. Number 1. Civil rights activists. These groups primarily focus on civil and political rights issues. Number 2. People rights activists. These groups focus on social and economic rights within the context of state repression of people's movement. Number 3. Consumer rights group. These formations raise issues of consumer right within the framework of accountability of the polity and the economy. Number 4. Bonded labor groups. These groups ask for judicial activism is nothing short of annihilation of wage slavery in India. Number 5. Citizens for Environmental Action. These groups activate an activist judiciary to combat increasing environmental degradation and pollution. Number 6. Citizen groups against large irrigation project. These activist formation ask the Indian judiciary the impossible for any judiciary in the world, namely cease to and desist from ordering against mega irrigation projects. Number 7. Rights of child groups. These groups focus on child labor, the right to literacy, juveniles in custodial institutions, and rights of children born to sex workers. Number 8. Custodial rights groups. These groups include social action by prisoners rights group, women under state protective custody, and persons under preventive detention. Number 9. Poverty rights group. These groups litigate issues concerning drought and famine relief and urban impoverished. Number 10. Indigenous Peoples' Right Group. These groups agitate for issues of forest dwellers, citizens of the 5th and 6th schedules of the Indian Constitution, and identity rights. Number 11. Women's rights groups. These groups agitate for issues of gender equality, gender based violence, and harassment, rape, and dowry matters. Number 12. Bar based groups. These associations agitate for issues concerning autonomy and accountability of the Indian judiciary. Number 13. Media autonomy groups. These groups focus on the autonomy and accountability of the press and instruments of the mass media owned by the state. Number 14. Assorted lawyer based groups. This category includes the critically influential lawyers groups which agitate for various causes. Number 15. Assorted individual petitioners. This category includes freelance activist individuals. Apprehensions of judicial activism. The same jurist Upendra Bakshi also presented a typology of fears which are generated by judicial activism. He observes the fact entail invocation of a wide range of fears. The invocation is designed to bring into a nervous rationality among the India's most conscientious justices. He described the following types of fear. Number 1. Ideological fears. Are they usurping powers of legislature, the executive, or of other autonomous institutions in a civil society? Number 2. Epistemic fears. Do they have enough knowledge in economic matters of Manmohan Singh, in scientific matters of the czars of atomic energy establishment, the captains of the Council of Scientific and Industrial Research, and so on? Number 3. Management fears. Are they doing justice by adding this kind of litigation work load to a situation of staggering growth of arrears? Number 4. Legitimation fears. Are not they causing depletion of their symbolic and instrumental authority by passing orders in public interest litigation which the executive may bypass or ignore? Would not the people's faith in judiciary, a democratic recourse, by thus eroded? Number 5. Democratic fears. Is a profusion of public interest litigation nurturing democracy or depleting its potential for the future? Number 6. Biographic fears. What should be in my place in national affairs after superannuation of if I overdo this kind of litigation? Judicial activism versus judicial restraint. Meaning of judicial restraint. Judicial activism and judicial restraint are the two alternative judicial philosophies in the United States. Those who subscribe to judicial restraint contend that the role of judges should be scrupulously limited. Their job is merely to say what the law is, leaving the business of lawmaking, where if properly belongs, with the legislature and the executors. Under no circumstance, moreover, should judges allow their personal political values and policy agendas to color their judicial opinions. This view holds that the original intent of the authors of the Constitution and its amendment is knowable and must guide the courts. Assumptions of judicial restraint. In the USA, the doctrine of judicial restraint is based on the following six assumptions. Number 1. The court is basically undemocratic because it is a non elective and presumably non responsive to the popular will. Because of its alleged oligarchic composition, the court should refer wherever possible to the more democratic branches of government. Number 2. The questionable origins of the great power of judicial review, a power not specifically granted by the Constitution. Number 3. The doctrine of separation of powers. Number 4. The concept of federalism, dividing powers between the nation and the state, requires the court differences toward the action of state government and officials. Number 5. The non ideological but pragmatic assumption that since the court is dependent on the Congress for its jurisdiction and resources and dependent on public acceptance for its effectiveness, it ought not to overstep its boundaries without consideration of the risk involved. Number 6. The aristocratic notion that being a court of law and inheritor and custodian of the Anglo-American legal tradition, it ought not to go too far to the level of politics, law being the process of reason and judgment, and politics being concerned only with power and influence. From the above, it is clear that all the assumptions except the second dealing with the judicial review hold good in the Indian context too. Supreme Court observation. While delivering a judgment in December 2007, the Supreme Court of India called for judicial restraint and asked court not to take over the function of the legislature or the executive, saying there is a broad separation of powers under the Constitution and each organ of the state must have respect for others and should not encroach on other domain. In this context, the concerned bench of the court made the following observations. Number 1. The bench said, we are repeatedly coming across cases where judges are unjustifiably trying to perform executive or legislative functions. This is clearly unconstitutional. In the name of judicial activism, judges cannot cross their limits and try to take over functions which belong to another organ of the state. Number 2. The bench said judges must know their limits and must not try to run the government. They must have modesty and humility and not behave like emperors. Number 3. Quoting from the book The Spirit of Laws by Montesquieu on the consequences of not maintaining separation of powers among the three organs, the bench said the French political philosopher's warning is particularly apt and timely for the Indian judiciary today, since very often it is rightly criticized for overreach and encroachment on the domain of other two organs. Number 4. Judicial activism must not become judicial adventurism. The bench warned the court's adjudication must be done within the system of historically validated restraints and conscious minimization of judges' preferences. Number 5. The court must not embarrass administrative authorities and must realize that administrative authorities have expertise in the field of administration while the court does not. Number 6. The bench said the justification often given for judicial encroachment on the domain of the executive or the legislature is that the other two organs are not doing their jobs properly. Even assuming this is so, the same allegations can be made against the judiciary too because there are cases pending in courts for half a century. Number 7. If the legislature or the executive was not functioning properly, it was for the people to correct the defects by exercising their franchisee properly in the next elections and voting for candidate who would fulfill their expectation or by other lawful methods, example peaceful demonstration. Number 8. The remedy is not in the judiciary taking over the legislative or the executive function because that will not only violate the delicate balance of power enshrined in the Constitution but also because the judiciary has neither the expertise nor the resource to perform these functions. Number 9. The bench said judicial restraint is consistent with and complementary to the balance of power among the three independent branches of the state. It accomplishes this in two ways. First, judicial restraint not only recognizes the equality of the other two branches with the judiciary, it also fosters that equality by minimizing inter-branch interference of the judiciary. Second, judicial restraint tends to protect the independence of the judiciary. When court encroach on the legislative or administrative fields, almost inevitably voters, legislators, and other elected officials will conclude that the activities of judges should be closely monitored. Chapter 29. Public Interest Litigation. The concept of public interest litigation originated and developed in the USA in the 1960s. In the USA, it was designed to provide legal representation to previously unrepresented groups and interests. It was undertaken in recognition of the fact that the ordinary marketplace for legal services fails to provide such services to significant segments of the population and to significant interest. Such groups and interests include the poor, environmentalists, consumers, racial and ethnic minorities, and others. In India, the PIL is a product of the judicial activism role of the Supreme Court. It was introduced in the early 1980s. Justice V.R. Krishna Iyer and Justice P.N. Bhagwati were the pioneers of the concept of PIL. PIL is also known variously as social action litigation, social interest litigation, and class action litigation. Meaning of PIL. The introduction of PIL in India was facilitated by the relaxation of the traditional rule of locus standi. According to this rule, only that person whose rights are infringed alone can move the court for the remedies, whereas the PIL is an exception to this traditional rule. Under the PIL, any public spirited citizen or a social organization can move the court for the enforcement of the rights of any person or group of persons who, because of their poverty or ignorance or socially or economically disadvantaged position, are themselves unable to approach the court for the remedies. Thus, in a PIL, any member of the public having sufficient interest can approach the court for enforcing the rights of other persons and redressal of a common grievance. The Supreme Court has defined the PIL as a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class of the community have pecuniary interest or some interest by which their legal rights or liabilities are affected. PIL is absolutely necessary for maintaining the rule of law, furthering the cause of justice, and accelerating the pace of realization of the constitutional objectives. In other words, the real purposes of PIL are: number 1, vindication of the rule of law; number 2, facilitating effective access to justice to the socially and economically weaker section of the society; number 3, meaningful realization of the fundamental rights. Features of PIL. The various features of the PIL are explained below. Number 1. PIL is a strategic arm of the legal aid movement and is intended to bring justice within the reach of the poor masses who constitute the low visibility area of humanity. Number 2. PIL is a totally different kind of litigation from the ordinary traditional litigation, which is essentially of an adversary character where there is a dispute between two litigating parties, one making claims seeking relief against the other and that other opposing such claim or resisting such relief. Number 3. PIL is brought before the court not for the purpose of enforcing the right of one individual against another, as happens in the case of ordinary litigation, but it is intended to promote and vindicate public interest. Number 4. PIL demands that violations of constitutional and legal rights of large numbers of people who are poor, ignorant, or in a socially or economically disadvantaged position should not go unnoticed and unaddressed. Number 5. PIL is essentially a cooperative effort on the part of the petitioner, the state or public authority, and the court to secure observance of the constitutional or legal rights, benefit, and privileges conferred upon the vulnerable section of the community and to reach social justice to them. Number 6. In PIL, litigation is undertaken for the purpose of redressing public injury, enforcing public duty, protecting social collective, diffused rights and interest, or vindicating public interest. Number 7. In PIL, the role held by the court is more assertive than in traditional actions. It is creative rather than passive and it assumes a more positive attitude in determining act. Number 8. Though in PIL court enjoys a degree of flexibility unknown to the trial of traditional private law litigations, whatever the procedure adopted by the court, it must be procedure known to judicial tenets and characteristics of a judicial proceedings. Number 9. In a PIL, unlike traditional dispute resolution mechanism, there is no determination or adjudication of individual rights. Scope of PIL. In 1998, the Supreme Court formulated a set of guidelines to be followed for entertaining letters or petitions received by its as PIL. These guidelines were modified in 1993 and 2003. According to them, the letters or petitions falling under the following categories alone will ordinarily be entertained as PIL. Number 1. Bonded labor matters. Number 2. Neglected children. Number 3. Non-payment of minimum wages to workers and exploitation of casual workers and complaints of violation of labor laws except in individual cases. Number 4. Petitions from jails complaining of harassment for premature release and seeking release after having completed 14 years in jail, death in jail, transfer release on personal bond, speedy trial as a fundamental right. Number 5. Petitions against police for refusing to register a case, harassment by police, and death in police custody. Number 6. Petitions against atrocities on women, in particular harassment of bride burning, rape, murder, kidnapping, etc. Number 7. Petitions complaining of harassment or torture of villagers by co-villagers or by police from persons belonging to scheduled caste and scheduled tribes and economically backward classes. Number 8. Petitions pertaining to environmental pollution, disturbance of ecological balance, drugs, food adulteration, maintenance of heritage and culture, antiques, forest and wildlife, and other matters of public importance. Number 9. Petitions from riot victim. Number 10. Family pension. The cases falling under the following categories will not be entertained as PIL. Number 1. landlord-tenant matters. Number 2, service matter and those pertaining to pension and gratuity. Number 3, complaint against central state government departments and local bodies except those relating to item number 1 to 10 above. Number 4, admission to medical and other educational institution. Number 5, petitions for early hearing of cases pending in high courts and subordinate courts. Principles of PIL. The Supreme Court evolved the following principles in regard to PIL. Number 1. The court in exercise of power under Article 32 and 226 of the Constitution can entertain a petition filed by any interested person in the welfare of the people who are in a disadvantaged position and does not in a position to knock the doors of the court. The court is constitutionally bound to protect the fundamental right of such disadvantaged people and direct the state to fulfill its constitutional promises. Number 2. When the issues of public importance, enforcement of the fundamental rights of large number of people, that is the constitutional duties and function of the state are raised, the court treat a letter or a telegram as a PIL. In such cases, the court relaxes the procedural laws on also the law relating to pleadings. Number 3. Whenever injustice is meted out to a large number of people, the court will not hesitate to step in to invoke Articles 14 and 21 of the Constitution of India as well as the International Convention on Human Rights, which provide for a reasonable and fair trial. Number 4. The common rule of locus standi is relaxed so as to enable the court to look into the grievances complained on behalf of the poor, deprived, illiterate, and the disabled who cannot vindicate the legal wrong or legal injury caused to them for violation of any constitutional or legal right. Number 5. When the court is prima facie satisfied about violation of any constitutional right of a group of people belonging to the disadvantaged category, it may not allow the state or to government from raising the question as to the maintainability of the petition. Number 6. Although procedural laws apply on PIL cases, the question as to whether the principle of res judicata or principles analogous thereto would apply depend on the nature of the petition and also fact and circumstances of the case. Number 7. The dispute between two varying groups purely in the realm of private law would not be allowed to be agitated as a PIL. Number 8. However, in an appropriate case, although the petitioner might have moved a court in his private interest and for redressal of the personal grievances, the court in furtherance of the public interest may treat it necessary to inquire into the state of affairs of the subject of litigation in the interest of justice. Number 9. The court in special situations may appoint commission or other bodies for the purpose of investigating into the allegations and findings out fact. It may also direct management of a public institution taken over by such commission. Number 10. The court will not ordinarily transgress into a policy. It shall also take utmost care not to transgress into jurisdiction while purporting to protect the right of the people from being violated. Number 11. The court would ordinarily not step out of the known areas of judicial review. The High Court, although may pass an order for doing complete justice to the parties, it does not have a power akin to Article 142 of the Constitution of India. Number 12. Ordinarily, the High Court should not entertain a writ petition by way of PIL questioning constitutionality or validity of a statute or a statute law. Guidelines for admitting PIL. The PIL has now come to occupy an important field in the administration of law. It should not be allowed to become publicity interest litigation or politics interest litigation or private interest litigation or paisa interest litigation or middle class interest litigation. The Supreme Court in this context observed PIL is not a pill or a pinaka for all wrongs. It was essentially meant to protect basic human right of the weak and the disadvantaged and was a procedure which was innovated where a public spirited person files a petition in effect on behalf of such person who on account of poverty, helplessness or economic and social disabilities could not approach the court for relief. There have been in recent times increasingly instances of abuse of PIL. Therefore, there is a need to re-emphasize the parameters within which PIL can be resorted to by a petitioner and entertained by the court. Therefore, the Supreme Court laid down the following guidelines for checking the misuse of the PIL. Number 1. The court must encourage genuine and bona fide PIL and effectively discourage and curb the PIL filed for extraneous consideration. Number 2. Instead of every individual judge devising his own procedure for dealing with PIL, it would be appropriate for each High Court to properly formulate rules for encouraging the genuine PIL filed and discouraging PIL filed with oblique motives. Number 3. The court should prima facie verify the credentials of the petitioner before entertaining the PIL. Number 4. The court shall be prima facie satisfied regarding the correctness of the contents of petition before entertaining the PIL. Number 5. The court should be fully satisfied that substantial public interest is involved before entertaining the petition. Number 6. The court should ensure that the petition which involves larger public interest, gravity, and urgency must be given priority over other petitions. Number 7. The court, before entertaining the PIL, must ensure that the PIL is aimed at redressal of genuine public harm and public injury. The court should also ensure that there is no personal gain, private motive, or oblique motive behind filing PIL. Number 8. The court should also ensure that the petition filed by busybodies for extraneous and ulterior motives must be discouraged by imposing exemplary cost or adopting similar novel methods to curb frivolous petitions and the petitions filed for extraneous consideration.